Good morning, everyone. We're going to get started. My name is Steve Nowak, and I'm the Symposium editor for the University of St. Thomas Law Journal. I want to welcome my fellow journal members and our distinguished guests and speakers from across the country to the 2023 Spring Symposium. It is my sincere hope that this symposium fosters scholarship and a continuing dialogue focused on professional identity formation in required law school curriculum. I must thank the faculty from the Holloran Center for Ethical Leadership in the Professions for their guidance in producing this symposium, specifically Professor Neil Hamilton and Professor David Granardo, with a special thank you to Professor Jerry Organ, whom I have worked closely with the last several months. I would also like to thank West Academic for providing financial support for this symposium. And finally, I want to thank my fellow journal members and the symposium committee who contributed their time and effort to making this gathering possible. And now I will turn things over to Interim Dean Joel Nichols to provide some remarks.
Hi, everyone. Welcome. It's so great to have you here this morning. I'm Joel Nichols, the Dean of the Law School at St. Thomas. I get the easy job, which is to welcome you and thank you for coming. I'm so grateful to Stephen, to Sean, to our journal members who've worked so hard to put on this event. Another thank you to the Holloran Center, especially Neil and Jerry, and their work over many years organizing efforts at professional identity formation. It's just another, another one of the continued efforts making progress in this space. And to all of you who've come from many places to visit to us today, I hope that you feel and experience a strong sense of welcome that is a hallmark of who we are at St. Thomas. Come on in, we've got room in the jury boxes. There's a few empty seats back in the gallery, one-off seats. You may have to climb over someone just a bit, but that'll work. In the couple of minutes that I have, I want to make sure that I'm being brief, but also just point out just a couple of things as I was looking over the program and the different curriculum for today, and tie it to at least one of the things. It's a lot of things we could tie it to at St. Thomas, but one of the things that I speak about at St. Thomas is I like to think about how every member of our law school community, students, staff, faculty alike, are whole people, right? So we sometimes will talk about a whole person education, but I mean just a little bit more than that, right? That too often, the law asks law schools, historically has done this all the time, to seek intellectual questions and to pursue the life of the mind. I'm an academic, I love the life of the mind, it's great. But if we only go on that avenue, we disassociate, right? And we stay in our minds and we miss, I would say, 2/3 of what's going on, right? Because we are not just minds, we are hearts and we are embodied people, right? So that triad, I think, is critical to who we are. We don't want to only ask intellectual questions and have graduates that disassociate from non-legal aspects of problems and miss the emotional components there. We've long resisted that compartmentalization in St. Thomas, and so we want to recognize that our students also, like the clients they're going to interact with, experience deep emotions, giving rise to compassion and empathy, and inhabit bodies so that physical and mental health matters, and it matters how we show up in a space. Physically, we know from neuroscience that the way that we come into a space impacts and regulates the people around us through the mirror neurons that are there. So the easiest example, right? I have 3 dogs. You can laugh at that. It's a funny thought. But one of them doesn't have much energy. The other 2 do. But she comes into a space as a body herself, and one of her jobs she was trained for is to walk in and calm the space down. She's great at it, right? You know people like that, don't you? Right? Not all of us are going to be that way. We bring different energy to the space, but if we just ignore that happens, we're missing things. How does this connect to professional identity formation? I think it's critical, right? Because we look at the things that clients want, that employers want. I mentioned this in one of the classes that I teach in professional identity formation sometimes. If you look at the IELTS list or other places, historically law schools will teach maybe 2 or 3 of the top 10 things that get listed in the explicit curriculum. That's why this subject's so important. What's there lying right under the surface? What are those expectations about connecting with people, about emotional intelligence, about timeliness, about relational skills, about teamwork, right? And then how do those find their way into the required curriculum? So the other thing that I thought, I won't stay on this because I told Jerry that I'd be short within my time and even cede some to him. He's smiling at me because now I'm not doing it. But as examples of ways that we know this happens, right? 3 quick things that come to mind about student examples, but then I'm going to leave to you to tie. Oh, they're even giving me time cards now. This is how far we've fallen. I will be way less than that, I promise. But I'll leave to you to connect these differently. But 3 things that are happening this week that I had conversations about, right? We had students arguing at the Ninth Circuit today, or on Monday. It's actually on Tuesday. They traveled on Monday, right, with a professor. So you want to talk about like stepping into that lawyer role. They're doing the lawyer role with the real clients in that one. So they're forming that professional identity, acting it out, right, getting the guidance of the professor all along the way. We had students this week who are in Washington, D.C. We had a professor who was called out to work with the U.S. Pardon Office, and he can't make it, so he works with the students and asked if the students could go in his stead, and they did it. So they've been out in D.C. the last couple of days, and they're not only meeting at that office, they've taken the initiative, exactly the kind of thing we'd want them to do, that initiative taking, right? They set up extra meetings with representatives from seven different electorate representatives from Minnesota and a couple of surrounding states to talk about clemency. And the role that it needs to play in different spaces. And I talked to a student just within the last day thinking about this topic, and she said to me, one of the things that I've learned in school is just simply working on this budget thing, this thing that sits with me. But I had to prepare that, and then I worked with the advisors, and I talked to the people that were helping administer the budget. We had to prep it for next year, and I left thinking, I think maybe I can do this when I'm not just in school, right? Yes, you can, right? That's the whole point. So it's easy for me as I write them down. It's like, okay, you guys are all going to tell me that's not necessarily required curriculum. Great, then have a conference about it, please, right? And make sure that those pieces are being worked in the right ways, whether that's in contracts or torts, or saying, no, this is kind of thematic overall, right? It can't just be one thing dropped in because this comes across overall. Okay, I am ceding time to my friends Jerry and Neil, who will have far more and better things to say, and longer than me. Thank you again for being here.
Well, it's very exciting to have you here. I want to simply note that we started 5 minutes late, but we're going to try to end on time. Thank you, Joe. So I'm going to go into my auctioneer's voice. Listen carefully. So the focus for my conversation, I want to kind of situate what we're doing in a slightly broader context. Thank you. There we go. So the title is Collective Intentionality, and I want to start with this idea, right? Even before there was a professional formation movement, law school was a formation experience, right? It has always been a formation experience. There's a sociological transition. We come in as students and we leave and we're lawyers and we're in this culture that shapes us, right? So my challenge is I have come to think of that as formation through pervasive inattentiveness, right? We don't actually think about it. We don't talk collectively about it. We're not purposeful about it, but it's happening, and it's not necessarily happening in a good way. All right, so why? Legal education is a pretty siloed existence, right? I frequently refer to law professors as independent contractors who just happen to be in the same building, right? And they don't necessarily talk to each other about what it is they're doing, how what they're doing might complement what somebody else is doing. And so we're not collective as a general matter in how we approach things. So individual, not collective. We focus on thinking like a lawyer. As Dean Nichols highlighted, we tend to be on the rational analytical side. We don't tend to emphasize a lot of other competencies, characteristics that are necessary to be successful as a lawyer. And in a lot of respects, I think we collectively, right? I'm not talking about any of you individually, you're all caring professors, but collectively, I think our culture, our law school culture tends to disregard the experiences, motivations, and values of the students, and don't really reflect on how we're doing that and how we are reshaping their motivations and values. And there's actually some empirical evidence to support this, right? At one point, this was just, okay, that's what Oregon thinks, and maybe a few other people. But there's actually some really good data. So a lot of you are probably familiar with the work of Larry Krieger and Ken Sheldon. It started on studying law student well-being. But then they did this study of lawyers, thousands of lawyers in 4 different jurisdictions that was published in the article, What Makes Lawyers Happy? So something that's not in that article is this. So I had conversations with Larry when they were putting the survey together and saw drafts of the survey. And so when the article came out and I started thinking about this question, is there empirical data? I remembered I'd seen his survey and so they had a set of questions about aspects of practice and how law school had helped or not shape those. And there were like 9 of them. And they reported on a couple of them, but they did not report on this one. So I just said, Larry, you have that data, right? Can you send it to me? So here it is. As part of my law school curriculum, including classes, internships, or externships, but not including outside jobs, I received significant training in this area that was practical for actual law practice. And they had 2 questions. 1, identifying my own values. 2, integrating my own values into the practice of law. And both of those are closer to disagree than neutral. Right? Thousands of lawyers saying my experience of law school did not help me integrate or identify my own values or integrate my values into the profession of law. The other really significant piece of that is the data they have on the shift among law students. So in their earlier study, they were able to document a shift in motivation, right? Students came in, and actually at our table, we had a little conversation about this morning. Students came in intrinsically motivated, wanting to serve others, and the law school culture moves them toward extrinsic motivations, right? Prestige, success, grades, dollars, whatever it might be. So their data shows that. I did a survey of 1Ls with some funding from Access Lex. It ended up being about 250 students from 11 different law schools, 280 who had done both a fall 1L, spring 1L in 2020, 2021. And that data also showed there were only a handful of things that had statistically significant differences, but one of them was a shift from intrinsic motivation toward extrinsic motivation. So this is what we are doing, right? We're forming our students in ways that I would say are unhelpful. Let me see if I can avoid moving for a second and have it work. There we go. So why do values matter? Here's what I want you to think about, right? As we help our students explore what they might want to do as lawyers with their gifts and talents and who they want to be as lawyers, it's important that we provide examples to them. So do we want them to be Roy Cohn, right? So why do I focus it on that lawyer? So for those of you who don't remember, Roy Cohn died in the mid-'80s. He was investigated multiple times by the New York Bar and finally disbarred just before his death. His claim to fame right now is that he was Donald Trump's attorney, and Donald Trump wants more of them like him. He's always looking for his new Roy Cohn. So why do I highlight that? Roy Cohn is someone who had no respect for the rule of law. Roy Cohn is someone who felt you should just be doing whatever you can, win at all costs on behalf of your own client, and that could include disregarding discovery requests, that could include lying, that could include all sorts of things. He's one of the worst examples possible of being a lawyer. So I highlight him because at the ILEC conference I attended in August, there was a panel talking about kind of the tension between zealous advocacy and the rule of law as a constraint on overzealous advocacy. And really interesting conversation, and they unfortunately let me ask the first question when they were done. And so my question was, are you saying that Roy Cohn should be the example we put before our students? And the response from one of the panelists was, no, that's not what I'm saying, but I think that's what we've been doing. Right? So a pervasive inattentiveness breeds Roy Cohn. That's not a good thing. That can't be a good thing. All right. So how are we doing this? So just a really quick, for those of you who've read The Ordinary Religion of the Law School Classroom, I'm a big fan. Roger Crampton, who was Dean of Cornell at the time in the late 70s. Just a couple of observations he made. The question is whether the selection and training of law students doesn't neglect humane aspects of personal development, emotional aspects of the professional relationship, development of capacities of imagination, empathy, self-awareness, and sensitivity to others. So for the students in here, does that ring a bell? Does law school seem to not necessarily emphasize imagination, empathy, self-awareness, sensitivity to others? And we're trying, right? This is a school where we're trying to do that. Law school can result in a disregard for morality's values, a disregard of humanity, a disconnectedness from ourselves and our moral compasses, a disintegrative experience rather than an integrative experience. At our table, Howard Katz referred to having received a gift from one of his friends, which was a bunch of letters he had written when he was a student. I actually remember writing a letter in November of my first year of law school in which I described law school as an atomistic experience, disintegrative, disconnected from myself and others. This is really the fulcrum for us, for the Holleran Center, educating lawyers in 2007, where Bill Sullivan and the team from Carnegie highlighted that there are 3 apprenticeships across all professional education, but in law school, particularly the 3rd apprenticeship of professional identity formation is shaped profoundly by the 1st apprenticeship, the thinking like a lawyer, cognitive analysis and knowledge. And if you want other evidence, Elizabeth Smirt's Language of Law School describes the first year experience as unmooring the self, marginalizes fairness, justice, morality, emotional life, and caring for others, eroding the very ability to make ethical decisions. So thinking like a lawyer is essential, right? It's the bread and butter of what we do. It's a necessary competence, but it's not sufficient. It does not help us build relationships of trust with clients, right? It does not help us figure out how we want to tell a story that an audience, a jury, whomever can hear and understand to be persuasive. And it doesn't give us the relationship and collaboration skills that will be essential to success as a lawyer. So it's important, but we have to be thinking about these other things. So what should our purpose be? What we focus on here at the Holleran Center is 2 aspects. This is our definition of professional identity: a deep responsibility and commitment to serving clients, the profession, and the rule of law, and a commitment to proactive, continuous professional development toward excellence at all the competencies needed to provide that service, right? That's really what we think we should be focusing on. So why are we right here, right now? So this is a culmination of about a decade of work. We started doing workshops in summer of 2013 through 2019, 13 workshops, 250 some people from 40 some law schools, trying to create critical masses of people focused on professional identity formation at multiple law schools, and had some success. So things that have been happening in the last 6 years. We had a symposium workshop here 6 years ago, February 2017, focused on learning outcomes, and part of that generated working groups who came up with stage development models that we call milestones for a number of the professional formation learning outcomes. But since 2017, like almost we're getting close to 100 schools that now have a professional development course of some sort in the first year. That was 30 in 2017. Profoundly increased emphasis on experiential learning, that's partly an ABA mandate, and then last year, new changes to Standard 303 that really emphasized the importance of this. But through all that, through our conversations, we've realized that the required curriculum still is focused on thinking like a lawyer. And Neil and David and I are very grateful to Barbara Glesner-Fines and Lou Bill Jonas and Kendall Crew, who have been fellows with the center for a while. And this gathering, I actually have to thank Barbara Glesner-Fines, because she started talking to us about 5 years ago. You got to get in the required curriculum. You got to get in the required curriculum. And finally, we're trying to do that, right? So what can we do? Be more intentional, work collectively, provide opportunities to reflect. Neil will talk about some other things momentarily. Support our students, right? Part of this is just being present with them and loving them as they work through this process. The challenges, the disappointments, the discoveries of who they want to be and what they think that means for who they want to be as a lawyer. And then give them permission to explore things, to go beyond simply thinking like a lawyer and engage values and relationships. So I'm going to stop here and turn it over to Neil, who has a few minutes. He's going to talk about some of the key principles we've acquired over the last decade thinking about this. And then we will start with our first panel at 9:35.
Show me how to advance it.
All it is down arrow.
Wait a minute. This one?
Down arrow.
Okay,
Yep.
okay, great. Well, thanks, Jerry. Just deeply grateful for everybody in the room, the students especially. This is the seventh symposium that Holleran Center has done with the Law Journal. A lot of the literature that framed the movement that we're in was helped by our editors here. So very grateful. Grateful for so many people in the room who've been part of this movement, and many were in the movement really, whether we called it that, long before we were doing workshops. Some people here have been writing in this area for many years and teaching in this area. So we're building on a lot of experience. I do want students to realize when you watch Professor Organ manage this workshop, I didn't realize until the first workshop that I was in the presence of the best workshop leader I've ever seen in my life. So you really are, you can kind of go to school on Professor Organ in terms of how to manage these things. And he will do his best to keep this train on time. So I'm going to walk through this quite quickly. We've synthesized these principles of what are the most effective curricular principles that inform professional identity formation from those sources, a number of sources. The one thing that I really want you to focus on that we don't focus on as faculty is that a lot of the formation is happening outside the building. Actually, I believe that is my sense. The 2 summers and the outside clerkships are enormously important in formation. That happened at our discussion at the table this morning at breakfast. People were describing particularly formative moments in their legal education, and quite a number of the comments were, well, the most formative things were happening in the clerkships. And whether you got lucky and got a mentor and a coach in the clerkships, which the law schools are not, in general, doing much to integrate that. So this is the key principle. Anybody who's been with our programming for all these years, I learned the hard way, and I won't go into stories about all the humility that Professor Organ and I have learned over the years of things we've tried that have not worked well. That was our lesson. You got to go where the students are, not where we are. Because if you go where we are, I mean, I'm 2 generations from my students for the most part. I have to go to your world and try to see the world from your eyes into how you are experiencing this profession. So that's kind of the most, and then that is true with all of the efforts we're trying to change legal education. Go where the professors and the staff are and engage there as to what's important to them. Okay, so then principle 2 is, and this is now what I'll repeat this because it's so important. Medical education scholarship shows this so dramatically, and of course they have in this 3rd and 4th year of medical school rotational experiences, right? Every medical MD student goes through about 10 rotational experiences. They hope, and they're trying to train their professors into better coaching, better mentorship. But that's what's happening, where you're actually doing the work. And that's what the students, that's what I'm, as those of you that, well, this group, you're all 2Ls, but my new roadmap version, it's completely about helping the student find authentic professional experiences. You need guided reflection. That's then that means you need a coach in here. Mentors, you'll see in a minute. Well, let me go to the next slide. You need guided reflection from an experienced person helping you to grow here. I've come to the conclusion coaching is really the heart of it because it's individualized. In a large section, I can try to help you, but it's very difficult for me to individualize in a large section. Virtually impossible, really, if I have 80. But one-on-one, and now I'm trying to go where you are, and we're trying to assess where you are. Modeling, that's the way I came into the profession. I realized later that really what my professors were doing is modeling the highest craftspersonship of the law, of the technical skills. It took me a while. Nobody told me that that's what they were doing, but it took me a while. Mentoring, I got lucky pretty early in practice where I found some mentors who were available to me. That's our mentorship program. But coaching, now we have an experienced professional who I'm going proactive to engage you. Going proactive, trying to see where are you, what can I do to help you as an individual. Earlier stage students don't use modeling and mentoring very well. They stay way too passive. So that's why I've come to the conclusion, well, coaching is really going to be the key. And then this last one, and this is the one where Jerry and I, although the programming are going around the country, I mean, because everybody in the law building, including the staff, are siloed. Everybody that's how lawyers are anyway. We just do our thing and we don't coordinate very well. But this whole thing, this whole social movement we're in, we're going to have to work together more than we ever have before to see where each of these students is and coordinate our coaching into where they are, work together across the staff and the faculty. So that's really that is revolutionary, no question about that. So thank you very much. I turn it back to Jerry.
Okay, the first panel can come up. That'd be awesome.
Good morning. Thank you everyone for being here, for traveling across the country to join us today for this wonderful symposium. My name is Andrew Ridland. I'm a 3L here at St. Thomas Law, as well as one of the publications editors for the Law Journal. It's an honor to be here and to speak with you and to join you for these wonderful conversations. And just a moment of gratitude. We're going to be talking about mentorship and things of that nature throughout today. And I want to thank Professor Hamilton for his personal role in my law school journey as a faculty mentor. He is walked alongside me since day one, and I can say that's been very enriching for my law school experience and actually even my career, the work that I have been able to do throughout law school, so thank you. Just a disclaimer, I studied Latin and Greek in undergrad, and I studied abroad in Italy and learned some Italian, and I've studied some Spanish, and so when I pronounce names, sometimes it comes out kind of funny. Just an example of that, way before I was thinking about law school, a friend of mine was applying for a marriage visa, and he asked me to fill out an affidavit for him, right? And this was all via email. And so I'd never heard the word pronounced, and then I shared this with my supervisor, who's a St. Thomas Law grad at the time, and I called it an affidavit, which would have been the proper Latin pronunciation. I had no idea. So my apologies in advance if I mispronounce any of your names. But our first panel this morning will focus on professional identity formation through role-playing scenarios. We'll hear from Professor Jamie Abrams with the American University Washington College of Law, Professor Michael Vitillo with the Pacific McGeorge School of Law, Professor Howard Katz from Cleveland State University College of Law, and finally from Professor Colleen Metal from the University of Nebraska College of Law. I'd highly encourage you all to review their accomplishments and bios in the symposium program. We'll hear from each of them for about 15 minutes, and then at the close of the hour, we'll have another 15 minutes for Q&A and discussion. So thank you once again, and please join me in welcoming our panel.
Good morning, it's great to meet you all. This is my first in-person conference since COVID, which seems scandalous, so I'm so excited to be here. Huge thank you to all the Law Review folks who are here. I know what a busy time of year it is, and the fact that you're so present and leading such an important initiative speaks volumes to the kinds of lawyers you're going to be. So I'm thankful to all the organizers, to Team West Academic over there in the jury box, and I'm really grateful to be a part of this. So I'm going to present about a role play. That's what our whole panel is. So mine sits in tort law, but I'm going to try to speak a little bit more broadly about how you might launch or conceive of a similar role play, and so in other courses. And so what I do in torts is a dental malpractice simulation. It is quite large scale, so it involves a full section of first-year law students and the entire graduating class of a dental school. So it's a lot of people. The night before, the Zoom anxiety really sets in about whether this is really going to work. But it tethers to so many aspects of professional identity formation. And so the origin of this is my work in tort law simulations. And so I wrote that after a consult with Mike about this series and what it was all about. And when I first wrote this book, I really thought what I was doing was skills sensitization, that I was taking torts and bringing it to life. I didn't have any conception of it as a professional identity formation tool. I just wanted to sensitize them to the students to the core skills that a tort lawyer would deploy, like taking a deposition or preparing for a deposition, writing a demand letter, writing a piece of a complaint. And so that's how I approached the book. But as this professional identity formation requirement came out, and as I came to study all of the materials coming out of this center particularly, I really came to see the simulation as something quite different. So it is a bridge to practice, but getting students on this journey in their first year, and for me it's always been in their first semester, has such a transformative role of seeing students come to life as a lawyer. So the first thing I always tell my students before we approach the simulation is go to the dentist first before you open this book, because you will never want to go to the dentist again afterwards. But students, we use this throughout the semester. So negligence is like 40 to 50% of the torts class, and it's really big for students to get their minds around each of those components. And so This is a simulation that is both threaded through all of the content as we learn it, and then capstone at the end, and we do the performative deposition. So there are separate chapters in this book on standards of care, causation, and damages that all use the same simulation. So a lot of this is incorporated organically into the classroom, and so we'll learn about professional standards of care, and then we'll sort of talk. And so I have some of the key issues up here. So we'll learn about standards of care, but then we'll quickly realize that they don't just fall from the sky, right? That we actually have to go to professionals in the field, hire them, get them to work with our legal team, and then we need to ask a whole bunch of questions and learn what it means to be a dentist. And so in our simulation, we have a rural teacher who goes to a local dentist, ends up needing a root canal, and she is advised that she could get it there, or she could go to an endodontist specialist. She ends up doing it locally, and while she's getting the procedure, a piece of the file breaks off. I know, it's horrible. And it apparently happens more than you would think. So it involves standards of care of what should have happened. Should the doctor have seen the broken equipment? Should they have disclosed it? They take an x-ray. When should they have reviewed the x-ray? How should they have contacted her? Then it bridges a busy period in the office, and they don't return her calls, and she ends up with an infection and needing more medical care. So for standards of care, there's so much to unpack there. Students don't know about this stuff. I don't know about this stuff. So we need experts. And so we bring in dental students who write for our students a disclosure. So the dental students on their own are working with their faculty. And I think it's really important to note, I think Neil might have mentioned this in his remarks today, but certainly in his writings before, the medical profession is so much farther ahead of us on this. They've been thinking about this for years, and that's actually how I came up with the idea. Was our dental school came and said, we have so much work to teach students about the legal system and how it stands as a backstop to the medical care that they provide. Could we do something together? So we did this based on a real case file from our dental school. So in the dental school, they're having their own conversations about their standards of care, and then we divide them. So half of them are expert witnesses for the plaintiff, half for the defense. None of them are the defendant dentist. They're all experts. And they have to write a disclosure. They do it collaboratively, and they work with their professors to do that. And then they send the disclosure to their lawyer team. And in that, they explain what they're going to tell us about the standard of care. But of course, it's pretty cursory and pretty conclusory, and we need to get that out in a deposition much more thoughtfully. And we need to poke holes into the other side's expert deposition disclosure. So we do that for both standards of care and for causation. And so we add into the hypo some facts on that in between the root canal and the presentation at the emergency room, the patient suffers an assault through a domestic violence incident. And so is that really what caused, and it's in the same region of the root canal, is that really what caused it? And then we interject some questions about defective products. So we have some Google reviews and some critiques that this is just too cheap of a dental file, and we learn that dentists routinely use a single-use file multiple times to save money, and that is the standard of care to do something that is off the label. How do we reconcile with that? So there's a lot of pieces packed into it. I have done this simulation twice, once in Baltimore and once in Louisville. So I like to call this the sort of triple crown of collaborations. It always ends with a stiff bourbon, no matter where I do it. But it is a big simulation. So the first time I did it, it was one torts class and the entire graduating class of dental students at Louisville. So it was Baltimore Law, Louisville, dentist, and so all by Zoom during the COVID year. And it was an extraordinary highlight for those students because it was by far the most interactive thing they did. We took these great screenshots of everybody and, just lawyering. We had this conference room backdrop that everybody shared. So we made it try to look like everyone was in the same room together. And then when we got back to in-person, I was back at the University of Louisville, and we did it with two sections, so 150 1Ls and 150 dental students, but we still kept it on Zoom because it was just easier than there's so many rooms involved. So we do big teams, so they break it up. There'll be like 6 or 8 lawyers in one team. Some will ask the questions on standard of care, others will be the experts on causation. But what we did the second time, so first time we just did it and everybody there were mentors in the room who were alums who were able to stay in the Zoom room, but it was a safe space, right? It's like 10 lawyers. They're not performing in front of their class. They're not being graded for anything other than participation. And there were lawyers in the room who gave feedback in a Google file that the students could see later. But it was very carefully constructed to be supportive, recognizing that the students weren't super well trained on doing depositions. They were trained on torts, and then they were using depositions as a tool to bring those concepts to life. But the second time I did that, I didn't feel so great about not having a demo. So the second time we did it, I worked with our civil procedure class and and we ended up having the civil procedure professor select a group of students, and the dental school selected a group of students, and we prepped for a couple of weeks with a demo that ended it. So everybody was in their Zoom rooms, and then the next class when we came together up in the front for the law school, we had a demo deposition that was much more thoughtful, much more prepared, and there were lots of like very carefully planned things that we could celebrate. So I felt like that helped add a little bit of, I think I've talked ahead of my slides, but that helped add a little bit more of the instruction in the skill itself, because they were able to do it once and then see it modeled as well. So for next year, I've actually switched to a different model, and we have a medical malpractice class that happens to meet during the fall semester. And in that class, they're gonna prepare the demo on their own, and then we're gonna do the Zoom room together. So there's lots of things I think that I set out in the simulation to achieve that connect to building law students' professional identity formation. The fact that we do it with dental students is so transformative, because here are 2 separate professions, and in law school everyone is sort of fiefdoms, right? You're section 1, I'm section 2, or I'm a 1L, you're a 2L. But then when we come together this way, we're all lawyers and they're all dental professionals. And when we come together, there's just a much more socialized sense of what we're all trying to do together. And how those relate. So the lawyers have to teach the dental students what is a deposition, what's going to happen in it, what am I going to ask you, what is the opposing counsel going to ask you, how do you handle that? So they have to prepare and teach the students about the legal system and where this falls in the process. And the dental students need to find their own voice as to what professionals do, and they have to be the expert. And so we have this really cool moment, and for both the dental faculty and I watching it, it really is transformative to see students start to take on, to go from learning what a deposition is in a reading and talking about it in class, and then I go in the Zoom room and see them prepping with their crew, and it's now theirs, right? They've made those concepts their own, and they're the ones teaching a fellow member of another profession. So there's a lot of community building, and you can really see that as folks come together. It transfers concepts to practice. So for us, these are core torts principles, but we really quickly see that torts don't just, the standards of care themselves don't just come out of the book, they come out of the work of lawyers doing factual development and crafting a standard of care that is the most beneficial for their client. And students see how these medical and torts systems interact. So the way I always describe it to my students is that what we're doing is skills sensitization to inform practice. I'm not teaching trial practice, and I don't have the bandwidth or the space in the class to teach the skill of deposition taking too much. So we try to do pretty much everything collaboratively. So if you're on the team for the plaintiffs, the team for the defense, we break into subgroups of standards of care, causation, and damages, and then we create a shared Google file, and we draft questions together in there. So the file gets pretty big, it's not super well organized, but it's a repository from which students can grow. And it's great, it's probably the first time in law school where they're thinking this way, where I could actually start my task by seeing what others have done before me and then adapting it or taking some things that I like from my peers and making it my own. So that shared Google file really helps get everybody comfortable. There's some people who fly through it really comfortably. There are other people who are like, state your name, and then just sit for a while. So it's a really good space to, for folks to come together, but not so face-to-face, right? They're working separately in the classroom on the standard of care day or the causation day, and they're doing it silently, so everyone has the sort of bandwidth and space and sort of privacy to put what they want into the Google file as the weird animals that they show up as in the, the Google, like they have a lot of safety to be in there as their anonymous selves. So the biggest things that I think come out of it is the students really see the role of the relationship between lawyers and physicians or professionals in setting standards of care. They also tether it properly to civil procedure. So for both of the schools where I've done this, civil procedure and torts were offered in the same semester. So it does sort of bring civil procedure to life. That's not my core goal, but boy, is it a great benefit for 1Ls to see that happening and make civil procedure seem relevant and connected. So in terms of feedback, I really encourage students to try this out. They're not graded for what they do, but they're graded for everything that they turn in. So they all take from that Google file and make their own deposition prep outline, and they turn that in, and then they get the Google feedback from a mentor in the Zoom room. So there's lots of opportunities for feedback. My favorite part of it, though, comes from what I call the shout outs at the end. Nobody wants to say what they loved about the simulation. A few people will, but they're so excited to shout out their classmates. And that's just a beautiful moment where, what did you like? What was a good moment in your room? And they are so excited to tell how they watched one of their peers ask this great question that got this great answer. And so there's lots of collaborative learning. So the way I sort of describe it is it really is a critical transformation of me from the sort of sage on the stage to the guide on the side. I'm watching and orchestrating, facilitating this entirely, but they're the ones doing it. So here's just some quick little visuals. This is like one of the Google files, and so I would put this up on a day. This one's on standards of care. They're not super interesting, but just to show like the students are sort of working in there and creating. These are on causation for the defense, and the students will sort of work together, and in class will critique and talk, but it's never about any one question. It's about what strategies are going to be best. So I think this has been a successful simulation to really help students understand who they work for, what the client's goals are, how they're going to use their skills to achieve those client goals. Really, there is a profound socialization process, and this is sort of collaboration, like on steroids, right? There's so much collaboration happening from civil procedure to torts across the campus to the dental school. So it is incredibly time consuming to set up, but is unequivocally the most rewarding thing I have ever done in my professional career, particularly seeing the way students hold themselves when they come out of having completed it. So that's what I do, and I look forward to any questions or comments at the end. Thanks.
No. Technology, no. Electric type. When I started, I tell my students that when I was in law school, an electric typewriter was new technology. I wish I had more time to really thank the law review editors and the people here at St. Thomas. We started at 8 o'clock, and Professor Organ made us work through breakfast, and I've already learned in the last 2 hours a whole lot. And I realized that I didn't realize how my work has actually placed me in part of this movement. I started teaching in 1977 at Loyola New Orleans. And in those days, you did what the associate dean told you, and I was assigned civil procedure. I know associate deans have a lot harder job these days getting new faculty to teach what the associate dean tells them they need to teach. But I started teaching civil procedure in 1977, as I mentioned, and for a long time it was a difficult slog. Imagine watching students with their eyes glazed over. You're talking about Pennoyer versus Neff. You're talking about the international shoe. The Erie Doctrine. Now, I have a special connection to the Erie Doctrine. My wife's name is Erie, and I met her long before I went to law school. But so for me, it has a special meaning, but for law students, it's a lot more difficult. In civil procedure cases don't have what one of my students called the fun facts of torts cases. So in the 1990s, I realized I had to start animating the course, and I started adopting simulation exercises. There wasn't that much in the literature, but in the 2000s, right around the time those series of articles appeared in the New York Times, where the authors said that basically we in legal education weren't teaching our students anything that they needed to know. And that was sort of an inspiration, along with the very steep decline in applications. It was sort of an inspiration for me, along with reading the Carnegie Report, to come up with a book proposal, the simulation books that could dovetail with traditional courses. And I had a happy interaction with Lewis Higgins. If I had more time, I would embarrass Lewis. What a great, open-minded guy he was. He came to my office and let me persuade him to sell West on the book series, the Bridge to Practice series. I've got 3 books, 3 topics in the series: Crim Law, Crim Pro, and Civ Pro. Civ Pro is the one that I think, from my perspective, that I enjoy the most, because it really does animate civil procedure. It dovetails with a traditional civil procedure book, and it does so many of the things that we're talking about at this conference. Let me describe it briefly. On the first day of law school, my students, first day of law school, meet a client, a young woman, young lawyer, who faces the publication of an article that is going to destroy her career. It's defamatory, it's written by a shady journalist. It links her to a prominent politician and claims that they have been involved in a liaison that led to an abortion that she claims did not take place. Powerful stuff on day one. They meet the client, they have an idea about what the basic legal rules are going to be that are going to govern the lawsuit. The book then moves through pleading, discovery, personal jurisdiction, subject matter jurisdiction. There are 10 chapters. There's a vertical choice of law problem, and it ends with a summary judgment problem. Today, I'm going to talk about some of the lessons that students learn about not only the skills, but also professional identity through the process of discovery. The teacher's manual has a robust plaintiffs' and defendants' discovery packet. It includes memos to the file, captioned work product attorney-client privilege, but the memos are filled with facts. And those of you who are civil procedure people realize that students are going to have to negotiate the difference between privilege, work product protection, and discovery and disclosure of factual material. There are role summaries for different actors in the drama. If you have time and bandwidth, doing depositions, you could have students playing the roles of the various participants. There's also a series of rather embarrassing emails and other material in both files. What I've done it different ways over time. What I find the most effective, especially to do what we're all talking about in this conference, helping students develop their professional identity, what I have found works best is having students working in small groups, all representing the plaintiff. One, they develop the collaboration, working with one another. But I represent the defendant because I know I can then control the message and make sure that certain lessons are learned during the course of the discovery exercises. We go through about 3.5 weeks of back and forth, automatic disclosure, interrogatories, answers to interrogatories, and then we explore what's going to happen next. Are you going to have to file a Rule 37 motion to compel me to disclose information that I have told you I'm not going to disclose? One of the things I'm trying to do throughout, by the way, is to model how you should be doing it, how to write interrogatories. Even more importantly, how to respond. For example, Rule 26B5. Any Civ Pro students in here? All right, okay, that's okay. I'm assuming you would know what 26B5 is. But for example, modeling how you can really explain what a legitimate claim of privilege is, rather than waving the privilege wand, but to really try to model for students how you do it. But now I want to go to some of the details, some of the kind of conversations that we have when we get into the specifics of the interrogatories that are involved in the particular problem. One of the more technical aspects is the difference between work product, privilege, and underlying facts that have to be disclosed. The reason why I include the work product memos and attorney-client privilege, the caption, is because most students are stunned when they find out about the Federal Rules of Civil Procedure, what a progressive document the federal rules are, leveling the playing field by allowing me to get from you the documents that are going to win my case. I haven't had the advantage of the Fox litigation, but think about that, what has been revealed about how cynical people at Fox were. And without that information, a successful lawsuit against the defendant in that case would be nearly impossible to win. And so we go back and forth. They're claiming all sorts of privilege and work product protection. And then we have the discussion about why, in fact, we have the Federal Rules of Civil Procedure. It's not a technical rule. This is a vision about how to do justice. And that is, I get to discover the harms that you have caused, unless you do have probably a very narrow privilege, and it's certainly almost never work product. So that's one conversation. The other thing, going back to what a couple of folks were talking about earlier, the zealous advocate model. Students, when they respond to my interrogatories, don't realize I know exactly what's in their file. And so I've written an interrogatory to get very close to a document that or information they don't want to share. And the conversations that we have are quite amazing. One student a few years ago said, well, why don't I just shred the document? Now, imagine, I mean, when we're talking about identity formation and we're talking about what it means to be a lawyer, it couldn't get any better. And again, this is a 1L. And so, we've got an opportunity, I hope, to recalibrate his moral compass. No, I'm quite serious. But I don't know if we succeeded. He did pass the bar. But think about that conversation, because he represents that extreme of the zealous advocate who has no idea that we are so much more and need to be so much more. I'm preaching to the choir, but you think about that conversation that we then had in class. And he's an extreme example. There's so many other examples where students want to do a Muhammad Ali bob and weave, or a Bill Clinton. It depends what is kind of response. And so we get to talk about how the rules are designed, and then we get to talk about the pragmatics. If your moral compass needs recalibration, I can try to explain to students what the pragmatics are, why you need to have, if you don't have a good ethical compass, why you need to develop one. For example, if you're playing dirty, what's the other side going to do? We know how the federal rules are designed. Judges want you to do it all on your own. If you're not cooperating with your opponent, how is the judge going to look at you when the other side makes a Rule 37 motion, brings you before the court, and you have gone and engaged in some kind of pettifoggery? And if you really have been able to withhold that information, we then explore how information comes out. You think you can hide it. You think you can shred it. But then maybe somebody actually on the other side does believe in telling the truth. And there are reasons why we tell the truth. Sometimes we tell the truth because we're afraid that if we don't tell the truth, someone else will rat us out. Or maybe we do really believe in telling the truth. So we get that discussion going about why you need to develop a significant moral compass. Another thing I talk about is in Sacramento, where McGeorge is, we talk about the small legal community and what kind of reputation you want to have. And this is in their first year of law school, within the first month or 6 weeks of law school. We're talking about who you want to be. I also talk about, well, you're in a large law firm, and the corporate culture may be that you're supposed to play excessive zeal and withhold that information. And I talk to students about how they want to live. Do you want to go home at night and be able to look at yourself in the mirror? Now, I'm not naive about it. I also talk to them about student debt and the reality that you've taken on your first job, and here this high and mighty law professor is telling you to have an ethical backbone when the senior partner tells you to withhold the document. These are the conversations we're having at the formative stage within the first semester of their law school career. Let me wrap it up. I know I'm running out of time. I haven't seen the 1 minute warning yet, but I certainly don't want to be dragged off the stage. So I want to wrap things up with a couple of final thoughts. I'm not sure how well it's worked from my students' perspective, but one of the really good things, there have been really a number of wonderful conversations already, but before I met Professor Organ in person, he was asking me whether I do anything with student reflection. I have not to date, but this coming fall semester I certainly will, because my own view is that if I get it right, and I'll be asking you more questions, Jerry, later about how to do it effectively, I think what I'm going to discover is something that you were talking about, Jamie, is that students, if they start talking about the professional experiences that they're learning, I think I will get confirmation that I'm doing it right. Thank you.
Hi there, everyone. Like everyone else, I want to thank Jerry for inviting me, Stephen, and everyone else who helped organize this. I am Howard Katz from the Cleveland State University. Thank you, Big Ten brothers and sisters. When I walked into the breakfast this morning, I saw that even my friend and colleague from California was wearing a tie, so I knew that this was about serious professionalism. And so fortunately, in addition to the scarf that I brought, I also brought a tie. I am a doctrinal professor who slowly, over a period of years, has realized that there are other important things in law school besides doctrinal teaching. I'm also, as I make my presentation, I want to make clear that even if I sound absolutely certain about something, I may not be, and in effect, everything that I say is preceded by an implied Quaker query. Have you considered this? I'm going to make three major points. The first, the importance of teaching negotiation. The second, how a negotiation exercise or class is a wonderful vehicle for teaching professional identity formation. And the third, how thinking about the first year curriculum and the role of professional formation and skills leads to thinking about designing a curriculum in ways that can provide different students with opportunity. In a presentation that I made several years ago at the Emory Transactional Law Conference, I made the case that negotiation should be a required course at every law school, or at least be made more widely available. I won't go into all the arguments. The basic point I was making is that while some lawyers litigate, all lawyers, and in fact all people, negotiate. After I made the presentation, someone came up to me, and I can't remember who it is, and I wish I could so that I could thank them, and they made the additional point that negotiation is the perfect vehicle to teach professional identity formation. A negotiation exercise puts students in the role of being an attorney, or in some cases, a client, depending how the negotiation is structured. They must interact with other student lawyers, both outside the negotiation, to schedule it, for example, and during the negotiation. They must treat the other side with respect, even if it's a student who they may not like, who they may not get along with, or maybe they have had no previous interaction with that student at all. Obviously, during the negotiation, They need to act with professionalism. And after they've negotiated, if the requirement is also to write up the agreement, they need to do further interaction. A critical aspect of this, and another reason why a negotiation exercise is such a good vehicle, is that normally, and anyone who teaches negotiation, I hope, would agree with me, normally a negotiation exercise involves a reflection by the student about the negotiation. And so it's very easy, and it makes sense, to add questions to the student to reflect on the professionalism in their behavior and the behavior of the other side during the negotiation, as well as reflecting on their method of negotiation. Another reason that negotiation exercises or a module or a course has value for professional formation is related to the idea of a lawyer's reputation, and this is something that was just referred to. I talk about reputation to my first-year students as well, and I tell them the story about how when I moved back to Cleveland, I was looking to rent a house, and it happened that the house that I was shown by the daughter of someone, it turns out that her mother was a very hard-nosed attorney in town. She had had one case, one, against my father, who was a sole practitioner in Cleveland, about a generation older than she was. Based on that one interaction, she rented the house to me sight unseen. It wasn't even a handshake deal because I never met her. 10 years later, I met her, well after we had moved out of the house. And so the idea of reputation is something that I talk about to my students. And when a student is engaged in a negotiation, they quickly figure out which of their classmates are and are not reliable and trustworthy. I'm not going to ask for any show of hands. I'm not going to ask people to secretly write names on a piece of paper. This isn't Survivor, so we're not going to vote one of our classmates off the island, but I think you get the point. Engaging with classmates in simulations like this makes much more real the discussion that we try to have with our students about reputation. There are numerous examples of how we can incorporate a negotiation exercise into a first-year class. I was just giving a talk about teaching at St. Mary's Law School in San Antonio, where one of your professors used to be a professor, and I was talking to the criminal law professor who does a negotiation exercise about plea bargaining. And here the negotiation exercise not only helps develop professional identity, it reinforces substantive doctrine in the course, and it also exposes students to something that's very significant to the practice, but that isn't something that most professors spend a lot of time on in their criminal law class. In contracts, of course, you can have a negotiation about one or more contractual clauses. And again, the negotiation both reinforces doctrine and it shows students the transactional side of practice, which is again something we tend to not emphasize as much. And there are other examples, obviously the torts example that we heard about earlier. In property, we could try to draft an easement or have a border dispute involving adverse possession. The third point I want to make is about a larger point about curriculum design. As I was thinking about this sort of thing, and I hope that it will convince the people here, I don't think they need convincing, to begin to incorporate various kinds of exercises into their class, and also hopefully will be useful in having the professors here be able to talk to their colleagues back at their schools about the importance of what we're doing here. At last year's SEALS conference, and that's the Southeast Association of Law Schools, there was a discussion group mainly among deans addressing the challenges of curriculum reform. And I apologize to any of the professors here who have been involved in curriculum reform. I'm probably bringing back certain very traumatic memories for which I apologize and for which I should have warned you in advance. These deans were talking about various guideposts or best practices involved in curriculum reform, having an inclusive practice, considering a process, considering what skills our students will need when they graduate and practice law, those sorts of things. But there was another factor to consider that I don't think was on the table, particularly in designing the first-year curriculum. We need to think about the importance of incorporating into the first year different kinds of law school, not just the core skill of legal analysis, which is what I tend to write about and which tends to be my area of emphasis. We need to do other things, including skills training, including professional identity formation. And we need to do these things both to send a message that appellate case-based reasoning is not the only normal, it's not the only skill that an attorney needs, to show students the connection between law school and practice, but most importantly, to let a different group of students thrive, not just the usual suspects who can do well in the legal analysis part of law school. My wife, Jackie, teaches negotiation and has taught it for many years, in addition to doctrinal courses. And one of the things that she told me is that it is often, but not always, the people who do well in what we consider normal law school are not always the people who do well in a negotiation course. Back when there were faculty lounges, and back when there were faculty who hung out in faculty lounges, it was very common for professors to mention to each other that some of our best practicing attorneys, graduates of our school, were C students in law school. And let me ask you this, if we're so smart, how come we haven't been able to design a curriculum, particularly and including a first-year curriculum that would have allowed those students to get A's in law school and enjoy that kind of success while they were in law school? Now, whether that means a separate graded course, whether that means integrating something into a doctrinal course or into the legal writing course, that's a big topic, and that's a topic for another day. Those are design issues, which will be different at every school. But before you get to design issues, we have to decide exactly what it is we are trying to build. I yield the remainder of my time.
All right, Walzander's setting me up here. I'm Colleen Medill. I'm delighted to be here. I came out of a transactional practice, and so my goal, I tell my students, is don't be a case in a future edition of my property casebook. I've started doing this long before we had the buzzwords of professional identity. I just felt like we needed to have something, particularly in the first year curriculum, that integrated real practice, the rules of professional responsibility, just at a conceptual level. They'll get the full-blown course as a 2L or a 3L. But also to think about who am I and how do I want to project that as a lawyer? Because I think people come into law school with this perception that it's all about, fighting and the sleaze and all the things that you see on TV. And for the introverts in the class, the thought of a whole career doing that is a little scary. And so I wrote the first developing professional skills book in property, and it was on paper. And so what I'm going to show you today will be published very shortly. Thank you to West, and particularly I want to call out Megan Putler, who was my editor on this project. So the exercises in that book, which were originally published over 10 years ago, are now interactive modules, which I'm going to show you. And so you can use these in different ways in the classroom. You can do them together as a group, or you can have the students do them on their own, and then when they come back, have a class discussion about it. So I typically have them submit their work product through Canvas, which is our learning management system. And so I'll take a look at what they do, but I've done this for so long, I know exactly what they're going to do. And but the discussion for this exercise, I think, is really interesting because it's on adverse possession and trespass. We would do this in week 2 of property, and so that could be week 2 of their, for many years I did it week 2 of law school. So with that little introduction, there are a lot of snippets here of audio and additional information that we're not going to listen to because of time. And I'm going to try and get to the professional identity examination materials, which are at the end. If you're interested in seeing the whole thing, and there are 6 of these different modules for property, I have my laptop and I'm happy to show you all of this. So, I think I'm okay here if I can just remember to talk into this microphone. So with that, I'll be skipping, but I'm also.
You will attempt to resolve without resorting to litigation a dispute between adjacent landowners. Your client has a claim for trespass, and the neighbor may have a defense of title acquired by adverse possession. You will review the common law elements for a trespass claim and for perfecting title to real property through adverse possession. You will also practice the skills of negotiation and working with strong-willed clients.
All right, so we'll click. We're not going
Monarch
to.
Manufacturing Company is a new client of your law firm. The owner of Monarch is Miranda Mesa, who is the company's president. Miranda has come to you because a problem has arisen in connection with an industrial manufacturing building owned by Monarch. In your initial client's interview with Miranda, you learned that Monarch is a manufacturing company with 500 employees. Monarch produces and services wind-powered turbines that generate electricity. 3 months ago, the company signed long-term contracts to supply and service wind-powered turbines to several new utility company customers. To fulfill the terms of these contracts, Monarch must immediately expand its production capacity. 6 weeks ago, Monarch purchased a 50,000 square foot industrial building from Idlewood Furniture. Miranda relied on her brother-in-law, a commercial real estate agent, to inspect the property before Monarch made its offer. The building sits on a 200,000 square foot lot. Miranda planned to expand the existing structure by adding a 50,000 square foot addition. Last week, Miranda saw the building for the first time when she met with Hal Harley, the owner of Harley Construction, who Miranda selected to be the general contractor on the project. Miranda and Hal toured the facility and discussed the best place to locate the new addition. As they walked through the overgrown area behind the building, sharp-eyed Hal noticed that the mechanical system that provided heating, ventilation, and air conditioning to a different industrial building located on the adjacent lot encroached upon the Monarch lot. Hal told Miranda that this HVAC system would have to be relocated to accommodate the new addition to the Monarch building. The HVAC system and related ductwork sit on a concrete pad that occupies a total of 1,000 square feet.
So that becomes important in terms of.
I need you to relocate your
dollars.
mechanical system immediately. The HVAC system is on my lot, and I need it removed to expand the building.
The contractor who installed the HVAC system must have misplaced it. It sat there for 10 years, and Idlewood never complained.
I don't care about Idlewood. I own the lot now, and I want this junky thing moved.
Well, make me an offer, and I'll think about it. Otherwise, see you in court.
So I skipped a couple things, but the woman in the dark jumpsuit is the adjacent owner of the adjacent building. Idlewood is the seller that Miranda bought that building, okay? So there's
Next, Miranda had the Monarch lot surveyed. The survey showed that the HVAC system was located on the Monarch lot. Unfortunately for Monarch, its title insurance policy, purchased when Monarch bought the property from Idlewood Furniture, excluded from coverage any encroachment that would have been revealed by an accurate survey prior to the purchase. With no claim available under the title insurance policy, Miranda contacted you to solve the problem. Prior to meeting with Miranda,
So you do research, and you've
Miranda
got a
wants you
statute
to
of
file
limitations.
immediately a civil complaint against DD Tool and Casting for trespass. You have convinced Miranda that the more appropriate course of action would be to attempt to negotiate a solution first before filing a lawsuit. Miranda has agreed to have you write a letter to DD Tool and Casting asking that the HVAC system be removed, but she is unwilling to have her company pay for more than 1 hour of your time to write the letter.
Typical client.
Based on these facts, prepare a letter to Danielle Davis and DD Tool and Casting using the template provided. Assume in writing your letter that, in addition to State Code Section 15.235, the jurisdiction follows the objective state of mind test for determining whether an adverse possessor can satisfy the adverse or hostility element for acquiring title by adverse possession.
So there are a lot of substantive elements built in this, but I want to focus on the professional identity component. Okay, so now what you have to do is you have to go through all of these different points to consider. The substantive part over here, but in particular, professional identity comes in when you have to figure out what's going to be your negotiation strategy and the tone of your letter. So I asked them, given the dollar value of the disputed real estate, it's 1,000 square feet, and in another part I skipped, you learn it's valued at $3.50 a square foot. Does it make economic sense to send this thing to trial? And how will the tone of your letter make the other party more or less willing to negotiate or litigate? So that sets up the professional identity component. And so now they have to go through various support, the documents are pretty minimal here, it's just a survey. Expanded points to consider, more substance, law and practice. This is where you have some more things on professional identity and asking them to think about how they're going to approach this assignment. After they complete all that, then they go to the assignment. And so we've got some questions that this is, it also is kind of practice for the next gen bar exam. We have some substantive multiple choice questions here. They have to go through all this to make sure that they, understand the substance. And so now we're going to continue. So how do your responses stack up against the rubrics of this lesson? When Megan talked to me about this, one of the things we discussed was, I said, well, on this one, there is no one right answer. There is a spectrum that people can take in the tone of their letter. And so as you'll see in a minute, I give 4 different, all correct answers that are sort of on this continuum from uber cordial to pretty stern, but still cordial. So that's the epiphany really for the students, because they'll originally write something that is what they think they should write as a lawyer. And then it's great. I'll take what they submit, I'll throw it on a doc-cam, and I'll say, okay, well, why'd you say this? How do you think the other side's going to respond to that? And a lot of it is fairly typical. The one I love is where they sit there and they just blast the other side, and then they sign it very truly yours or cordially, or, it's just schizophrenic. And it's an epiphany for them. So Self-assessment, the following points are things you should avoid in your letter. This is a mixture of substance and strategy. Avoid a tone that's internally inconsistent. So, move this thing right away, you jerk. Monarch desires to be a good neighbor. We look forward to resolving this. So I've got several of these. Sometimes they'll concede issues like the HVAC system was obvious. So you have to watch out for that. That's more of a substantive thing. Avoid making unreasonable demands. So, this is a good one. You have 3 days to move this thing. So I don't know if any of you have, that's a big HVAC system. And today, you can't get people to come out and check your air conditioner, let alone move this huge industrial thing. So, I try and get them to think about these things. And for the most part, they're unconscious when they write that. And then you point that out and they're like, oh, yeah, okay. Maybe that's not so good. I say avoid making legal arguments or being argumentative in tone. If you start talking about the law, you'll immediately send the adjacent owner to whom? Their attorney. Now remember, this is 1,000 square feet, $3.50 a square foot. So, there's plenty of time to litigate this if you can't reach an amicable solution. And so we've talked a lot about zealous advocacy, but there is in the prior law and practice section, one of the model rules says, on the one hand, be a zealous advocate, but on another hand, as an attorney and in advising a client, you can advise on things other than the law. And so here the question is, does this even make sense for you and your business and this long-term relationship with your neighbor? All of those things, and we go through the model rule, are appropriate to talk about with your client, not just technical elements for trespass and adverse possessions. So how am I doing here on time? How much time do I have? About a minute and a half. Perfect. I got plenty of time. So this exemplar, I represent Monarch. We purchased this, blah, blah, blah. We'd like you to move it within 30 days, okay? So this is probably the most harsh letter. What's interesting is they struggle with, how do I sign the letter? Do I say regards? Do I say sincerely? What do I do? So that's one of the exemplars. Let me see if I can get back. Oh, I think I got to go to previous. So I just asked them in each of these. Oh, thank you, Xander. You can see it's ironic that S. West asked me to do this because I'm like the worst tech person ever. Where's my cursor? Okay, thanks, Xander. I'm having trouble with the glare here. All right, so then the most cordial one, let's do exemplar number 4. And these are all just, as I said, on the continuum. So this person took an economic approach. We're neighbors. Given the value of this is $3.50 per square foot, it's still valuable for me. We've got to do this expansion. We're under a lot of pressure. Okay, that's why the client's going crazy. Contact me so we can work toward a solution. And so with that, I am out of time, and Xander's going to take me out of this. And so we're done.
Yes. So I have the previous role of being in charge of our curriculum forum. Thanks, Howard, for giving me more of the shakes than I already have. So one question that I have for the torts for Jamie. One question that keeps coming back to us when we talk about in our curriculum reform committee, our formation of identity and putting these things in the first year curriculum. What the pushback that I keep getting is bar passage rate. And so my question is, even though the bar is changing, which I think is helpful for this whole conversation, to the extent it changes the way that they are intending, or they're saying it's going to, but we will still have students who take the bar that's the regular bar exam and not the next gen bar. So, and I know that we can track how our students do in each of the first year subjects. So do you see a change? So when you do this in a very skills-based way, have you seen a change in your students' performance on the torts part of the bar? Do you have that data?
No, that's a great question. And I only started it 3 years ago, so this is the first class that will graduate. But one of the things I do say explicitly to my students is that 40 to 50% of the questions tested on the MBE about torts are negligence questions. And so I do sort of give them a little bit more of a justification well before, next gen bar, where this could easily be a next gen bar question. But this is the core of where torts bar questioning sits. So I do emphasize that. Where I've seen the biggest, I do see their exams are dramatically different. Like they know how to write a torts exam. The plaintiff will argue, the defendant will counter, here's what I predict. Like they know how to reason through a torts problem. But that is a great question. And it would be really interesting because in all instances, it was just my section doing it. So we'd have the comparative data of whether, so anecdotally, I would say that by making that content their own, by having to teach it to, that's kind of ideally what a great study group would do, where you teach each other. So I do think that by making the material their own and teaching it to the dental students, that they just master it better. But it's a great point, and I'm going to take a note because I'm going to see if I can hustle that data down going forward.
I'm a big believer in this methodology teaching, but that's the pushback
Yep.
I keep getting. And I'm a co-teacher, and I also worry about if we spend the time in discovery, we don't spend the time where other parts is tested. And I think that's always the pushback.
Yeah, but if you learn material better,
Right.
that seems to me obvious. It's almost impossible to collect meaningful empirical data on it because you're comparing so many different students and nobody's got the bandwidth to follow up my students versus another section students, and certainly the other professor doesn't want to be compared. So you see the problem. But intuitively, if you learn this material better, think about learning discovery rules in the abstract.
Why not? I teach it all the time.
Well, there you are, and you don't have trouble sleeping, or your students don't. It bores me until you actually are playing the game.
So just a quick note on Simon's question. This is our end of the morning conversation tomorrow.
Oh, so I'm ahead of the game?
You're just foreshadowing.
You know me.
Here's the coverage, right? How do we do this when there's this mindset that we have to cover so much stuff, right? And so you teed it up well. That's a great question.
You're welcome.
I'm wondering what your ideas are about sort of making the transition from a more traditional course to one that incorporates these exercises. In particular, how do you're going to have to start by just, trying one. It seems unrealistic to say, okay, I'm going to remap the whole course. And then how do you prevent that from being like this odd duck of a project? It's like, oh, we spent this 1 week doing something that was different than the whole rest of the course. And so how does you cope with that?
I'll take the first shot at that. I think you start small. The other thing is, there's always a question of, is this just busy work? Does this matter for my grade? Blah, blah, blah. Okay. So when I first started this, I had people writing their demand letter on a piece of notebook paper before class and tearing it out and handing it in. And so the next class, I called those people up and I said, in my son's third grade class, Mrs. Smith does not accept paper with hanging chads. And so I called him up by name, I handed it to him, and I said, you have 24 hours to get this back to me. Peer pressure is great. So, what I do is, because my exercises and theirs are very different. Mine, you submit a written work product. Even when I have them do a landlord-tenant negotiation, they have to have a term sheet. But I tell them that it's going to be not pass-fail, it's a high pass, like at a B+, because especially when they're doing it so early in law school, they come in with such different ability levels in different areas. And I say, if you don't get a high pass, your name will be on the list and you will be called up and you'll be asked to redo it. And so usually it only takes one round of an exercise and then they are performing at a fairly high level. I tell them if they don't do it well, if they don't get a high pass on the second round, then they have 15 points docked off their final exam.
One thing that I would add, for me, it comes in how I approach every Socratic class before that. So I do use the Socratic method, and I tell my students that I do it in ways that are skills-centered and client-centered. So not what's the rule, what's the holding, who hired a lawyer, what did they ask their lawyer to do, what were, how did the lawyer develop those facts? So everything that we're doing before is trying to bring to life the lawyering process. So it does help it feel, I think, more organic. And then as to like the value piece, this is really dumb, but I also give all my students a certificate for participating. And like they live in this like micro credentialing world. And so like, I literally print it in my faculty, copier, like it's not, but like, it means, I do think a lot of them put it on their resume. A lot of them don't have anything else to put on their resume. And their employers say, what was that? And they start chatting it up. And then the employer says, oh, I wish I had that. And I give like golden toothbrush awards to students who are standouts. So I do find some ways to help. Like, I love the point Howard made earlier about how different students thrive in this. So for the students who win my little golden toothbrush awards, like I think that's probably, for some of them, might be the only like distinction they might get in the, like it's a very different kind of distinction. I probably need to give it a better name so they can put it on their resume more thoughtfully. But I do try to meet them where they are in this like micro credentialing world.
I would add something, I think it dovetails a little bit. When I teach doctrinally, I have an article, it's on SSR and it hasn't been published yet, talking about the way that I teach legal analysis. My co-author and I humbly call it the unified field theory of teaching legal analysis, for those of you who are physics majors. And the part of the idea, although the main idea is to be efficient in teaching doctrinal legal analysis, one of the advantages of that method is that I am talking about how anything we do in class relates to what we do on the final exam, and it relates to what lawyers do in practice. So it's not just talking about skills and values, how they relate to practice, but it is constantly reminding students that what we do, the abstract legal analysis we're doing in week 2 on elements of battery is what lawyers do in some form. And so when you then do something that is not the normal law school, you're still referring back to the fact that this is also something that lawyers do and that relates to practice. So I've set the table by the way I teach the most traditional legal doctrinal stuff for the fact that everything we're doing relates to being a lawyer, which goes back to something that was said earlier, which is that students come to law school with one kind of motivation and kind of forget it. They lose sight of the fact that the reason they're in law school, to a certain extent at least, is to become practicing lawyers and to be able to solve clients' problems. And that, again, is something that I remind them of all the time.
Let me dovetail with Howard. The Civ Pro simulation dovetails with all the traditional concepts, but I think that they understand why those concepts make a lot more sense. But the other thing is, I have one of my research assistants, like the dreaded Pirate Roberts, each new, I don't know if you know Princess Bride, but each year a new RA becomes Ms. Noble, although Ms. Rossi is the new one. In fact, my research assistant, just graduating, wants to come back, even though she'll be practicing at one of these high-powered firms. But one of the interesting things is that students will spot my research assistant around campus and go up to her and say, oh, you really are a law student. And then at the end of the semester, on occasion, they've said, well, what happened? How did the suit get resolved? One year when I had 6 units, now I have 4. Talk about curriculum reform. Yeah, don't get me started. I'm too old. I'm apoplectic. But they wanted me to try the case, and we actually tried the case in the last class, and because they were so interested in it. So I think that's the response. And then the other thing is, because they're first semester law students, they don't know what it's supposed to be like. So the fact that we're doing something different, I think works. There you are.
Thanks to all the panelists for great presentations. I have very specific questions. The first one was coverage. So I think we're going to address that tomorrow, but that's immediately the thing I think about is I love these exercises, but you can't do these, at least in my mind, these robust exercises and cover the same amount of material. So how you make those decisions. So I'll defer that question until tomorrow. But another very specific question, I think about grading and assessment. In some of my classes, I have not this detailed of exercises, but things like this, and people say, you're killing yourself, you're giving all these additional assignments, and you're working yourself to death with this grading. So how you handle that, both practically, do you do the grading? Do you have a TA that does the grading? And how you assess it? Is it graded with a letter grade or pass, no pass, high pass?
I can do this quickly at least on mine, it's high pass fail. The first couple ones, they're so new to law school, what I look for is effort. It's very easy to go through 71-page letters and decide who actually spent an hour and who didn't. I have, just this semester, I got a teaching assistant, which is great. She tracks them all. She's a third-year student. I give her criteria to look at. She sends me the ones that she thinks are questionable, and I do the final evaluation. So that's made my life a lot easier.
On the coverage question, by the way, I know we're not supposed to talk about it now. Look in the teacher's manuals to the books. At least in the ones I've done, I explain how you can integrate it and not lose too much. That was one of the things that when I met Lewis and he let me talk him into the Bridge series, I had to convince him. And there are ways to make sure you do it both, because you can really get a lot of bang for the time you spend. The cases make a lot more sense in that practical context. On the assessment problem, because I'm having groups work together and because my RAs, I'm not allowed to use them for any kind of grading, I'll do representative examples. I'll pull out models and then send them an explanation for why this worked, why it didn't work, so that I'm painting with a very broad brush. But that, of course, is always going to be something where I've got to trust their internal motivation and their collective responsibility with the group they're working with to be able to say, I've got enough commitment to do it well.
For mine, I don't grade at all. I just do participation. For me, it is like them finding their voice, just become like being invited to the table, to the to become a lawyer. So I just give them points, and it ends up being a complete wash because they all get the points. I don't think I've ever had anyone lose them, and I think it's like 10% of the overall grade, which just makes it only something that you're incentivized just to show up and participate.
One thing I've done, if you can't use a research assistant, is on my more sophisticated exercises, like I have them draft an easement, I have them draft it, then I have them look at the exemplars, then their final work product, they have to submit an edited version with track changes and comments, so I can see how they changed it in response. And so I'm not looking at, how perfectly did you draft an easement for the first time in your life. I'm looking for the leap in understanding, and oftentimes the comments directly relate to a substantive rule or requirement that they just totally missed.
Thank you all. Time for a 15-minute break. We're going to make it a 13-minute break.
All right.
So please be back at 11:03.
That's a great idea.
Yeah, very nice to meet you.
That's such a great idea what you're describing with the
All right, everyone, we are going to get started. I am Danielle Marshall. I am a 2L here, and I'm one of the associate editors. The second panel is going to focus on professional identity formation through pedagogical structures. We'll hear from Professor Lindsay Gustafson with the William H. Bowen School of Law, Professor Chris Bryant with the University of Cincinnati College of Law, Professor Kendall Carew with Georgia State University College of Law, and finally, Professor David Thompson from the University of Denver Sturm College of Law. As with the previous panel, please take a look at all their accomplishments in the biographies section of the Symposium program. And as with the previous panel as well, each speaker will have about 15 minutes for their presentation, and then there'll be a 15-minute period at the end for questions and answers.
All right, I'm really happy to be here. In the last panel, I was taking some notes on kind of ideas I was going to connect to and people I was going to credit for, and the list became so long. I assume that you guys will understand that there will be a lot of overlap, and certainly we'll be talking about similar themes, and I'm grateful for some of the things that have already been said. So I know that probably everyone in this room is familiar with this study in 2016 that asked more than 24,000 attorneys to identify and rank competencies, but also values. And so when I speak about team-based learning, this is a question that I ask early. What percentage of attorney respondents viewed it as an essential professional competency that attorneys be able to work collaboratively in a team? This means the answer is 91%. But that means that in the short term, for sure, all of the lawyers agreed, well, 9 out of 10 agreed that this was an essential professional competency. Now, here is the participation portion. I want you to guess what percentage of these surveyed attorneys said that it was essential for our graduates to have this skill. So write down a number in front of you. Commit to something. Do you guys not understand the question? Look at me. Okay, got a number? 73%. That means 3 out of 4 were looking to hire students who already had this competency or could demonstrate this competency. So as I've talked about team-based learning, what's actually, how many of you got pretty close on that? Pretty close? I'm surprised how many people actually get that number, right? So we understand that this is kind of some more drill down on those numbers. We understand that being able to work collaboratively with a team is an essential competency of practice. We don't always teach and assess it. At Bowen about 8 years ago, Bowen's my law school, about 8 years ago, we looked at some surveys from employers, and the employers said that our students lacked this competency. So in response to that survey and the information that we received from this study and some other kind of just intuitive understandings of what attorneys needed to do, we decided to build team-based learning into our 1L curriculum. So our property course right now, the course description includes that language. And so all of our property courses to the 1L students are taught with team-based learning. So I began this, I came at about 7.5 years ago. It was going for about 1 semester before I joined them. So my experience initially was just using team-based learning as an instructional structure. I mean, I was assessing it in fairly narrow ways. So I can tell you that since we've begun teaching with team-based learning, the students who were taught property this way have taken several, so we have 5 years of bar results, and every single year, they outperform in property, they outperform the expected outcome, and they do better in property than they do in any other course. So when we talk about course coverage and we talk about how well students learn the material, those are pretty powerful kind of statistics to talk to our faculty about. So my purpose today is a little different. Usually when I do my song and dance, because I have become evangelical about this, I teach team-based learning. That's what I talk about, and I have the participants do kind of a mock portion of it. But I have, since going to Holler in, I don't know, pre-COVID, I have thought and recognized a little more directly how this impacts my students' development of their professional identity. So I want you to think about, I'm going to try and describe how team-based learning is different from group work. How many of you in here teach with some level of team or group work? Like a ton of us do. I certainly did even before this. So I'm going to describe how this is a little bit different than that. The meat of my presentation is really how have I seen how team-based learning impacts the student's formation of professional identity. And you know, this is a structure that has been used in the medical field, in undergraduate education, and other master's programs. So there's a lot of data out there about how this improves students' motivation and their understanding of their place in not only their class, but in a profession. But while I'm talking, I want you to think about how much of what I'm talking about you could use in your group classes. We're hearing a lot of great ideas today, and what I'm doing and what I know you're doing is figuring out how I can integrate these good ideas without trashing everything that I have, already tried to build up. So I hope you engage in that kind of reflection of what you could do. So here is the basic understanding of how team-based learning is different from regular group work. The big obvious difference is when students come in their first day, they sit with a group of 5 or 6 students in property, and they stay there the whole semester. They create their own team rules, they take roll, and they almost every class period have something to do together. So that's a big obvious difference to students. In property, well, in any team-based learning, you divide up the substance in units. And so our first unit is adverse possession. Every unit starts with a quiz. Students prepare for class learning material, and then they take a quiz individually that counts as part of their grade, and then they take that same quiz again as a team. When they take the quiz as a team, they can see the right answer. I used to use little scratch-off cards that were kind of like lottery cards that got some excitement in the room, and now we use a platform, same kind of excitement, when they as a team work through, this is our answer, and they check that and it's right, you can see that excitement in the room. The third characteristic is that every unit has application exercises. I always end a unit with an application exercise that I tell them is exam level difficulty. And we'll talk about why that matters in a minute. But throughout, some sort of application exercise. And then the last one is, to me, the really critical piece in the connection with professional identity, and that is there are real structures in place that hold them accountable to their peers. And I'm happy to talk through those structures. My purpose is not to kind of define those structures yet. We'll talk a little bit more about them, but they're there. So, what have I noticed? These are the themes that I have noticed and the ways that our use of team-based learning has impacted students' formation of professional identity. So we're going to take them one at a time. Okay, so students in the room, when I ask my students, okay, welcome to law school, this is property, you're going to be in teams for the whole semester, and what your team does impacts your grade, what is your first reaction? Yes, not a chance, right? Because every single one of you knows that when you have been in a team, who does all the work? Yes, exactly. That's always true. So how do we answer concerns about autonomy? This is always the biggest concern. How do we resolve those concerns for nervous first-year property students? Also, how do we pay attention to competence and relatedness? We know that these three together really impact students' motivation and student wellness. So how can we address these concerns directly? So there's a lot of interesting studies on this in other fields that actually team-based learning builds all three of these. Now, it doesn't happen automatically. It takes some time and care. So autonomy. Autonomy, students lose autonomy when the professor at the front of the room dictates how they will learn and how they will perform. And students lose the ability to explore and control their own learning. So I hope you guys can hear that a traditional law school classroom can often make a student feel that she has lost autonomy. Team-based learning can give autonomy back to a student. Autonomy is built with a very clear structure. Someone is still very much in charge, the professor is still very much in charge, but the structure and the protection is clear to students. So shifting a little bit of control to students so they understand their role in their own learning, but also reassuring them of the structure of team-based learning. Part of what team-based learning does is called peer interdependent. So instead of like a traditional group project where you'd say, okay, Kendall, you do this, and Chris, you do that, and I'm gonna do this part, and we'll come and we'll pull all the pieces together. All of the students do all of the work. And all of the students assess the other students' preparedness and team kind of contribution. So peer accountability is really important. And they can tell, if a student comes and has not done the work, the rest of the students can see and will have an opportunity to give feedback on that. Competence. So we've had some interesting exploration with competence. Competence is a student's feeling that she is making inroads and building her expertise in an area, her understanding. I noticed several years into using team-based learning that students, in fact, a student said to me when she didn't do very well on the final exam, she came and she said, well, all of those little quizzes that we take at the beginning of a unit, I do really well on those. And I realized that she had misunderstood the role of those quizzes, right? The role of those quizzes at the beginning of a unit is, are you ready to learn? And so we have to have talks in class in a very, in an open way. Here's what this quiz means for you, and here's what the closing exercise means for you. So if you do well on that closing exercise, that is actual competence. Another thing that we've had to talk about, anytime you use group work, you should have students pay attention to their feeling of what they can do themselves and what they could do as a team. And so students do an exercise themselves, they turn it in, they come and they complete the same exercise as a team, and then I ask them to reflect back on what they were able to do individually, because of course they do not take the final exam as a team. The third piece that's obvious here that maybe all of you heard is they are put in a team their first day of law school. And this really has built some nice connections and social support. What I've had to watch for here is aggressions that I can't see so visibly. So one year, the teams are randomly created. One year, I sat them all in their teams. I stood at the front of the class, and right in the front of me was a team of 5 white males and 1 black female. And they were sitting just like that. And despite my best efforts really through that semester to try and pull them together, that line was always obvious. And so this is a real opportunity to talk to students about how they include. All right. The second piece that I've noticed here, of course, is the obvious. How are they developing their relational core values and skills? So when we say that ability to work with a team is an essential competency, we have to teach it and we have to assess it. And so we do. The big one here that I wanted to talk about is conflict. Students frequently will come and say, what do I do when there's conflict? And I tell them the purpose of a semester-long team is to introduce experience of conflict with your team members. So we have a rubric that they use, and they assess each other, and we talk about what it looks like to work through conflict. We warn against kind of groupthink, working through groupthink. This rubric has really helped kind of draw their attention to the way they manage conflict. I'm going to skip this next piece right there. The third thing is self-directedness. I have seen an impact on self-directedness. Students, as I kind of discussed earlier, students need to go look at their team efforts and then look back at their own efforts and see what they could do. Because there's increased assessment opportunities, there are increased opportunities for self-directed students to excel. A lot of care needs to be given to the weaker students, that they do go through the reflection activity. So we make sure that they do that. The final thing here is client-centered problem solving. This is something that is difficult to do. I've been really appreciative for the stuff that happened earlier, the presentation earlier. I got some good ideas, but the assessments that they do need to be aligned with the final exam, but they also need to be client-centered, and it can be transformative for students. All right, my time is up.
Good morning, everyone. Is this working? Yeah. Thank you. I want to add my thanks to those who have gone before. I know everyone has to say it, but I really do want to say it because I am so very happy to be here. So thank you to Professor Hamilton. Thank you to Professor Organ. And this is my first experience with the Halloran Center, but it is my friend, senior colleague, former boss, co-author, is a frequent participant, and I know I'm very privileged to make this association, so thank you. So this is a presentation about a book that has been in progress for a long time. I am about 75 years ago, I'm sure it seems to Lewis, he took me to a baseball game in Cincinnati and said that he had this series called Learning Evidence, and wanted a volume in constitutional law. Would I be interested? And I said, well, what's this thing about? And he said, well, I'm paraphrasing. He said the kind of traditional model of law school is the sort of bramble bush. You come in, you don't know anything, you spend most of the hour trying to figure out what the point of the case or cases is, and at the end, maybe you sort of have a vague notion of a rule, and the point is, kind of learning to find the law in the materials, and that's extremely valuable. And I think it is, and Lewis said I think it is. He said, do you have to do it every day in every class, is sort of the question. Are there other things that maybe you could be exploring? And I said,
That part played into the direct question.
I meant to be a very faithful paraphrase, so I'm glad he's here to keep me honest. So I said, yeah, that makes a lot of sense. And then I started thinking about this, and I realized that in the constitutional law course I had been teaching, I had been preparing students as though their first job after walking across the stage would be to become an associate justice of the United States Supreme Court. Basically, we role played the entire semester. What would you do if you were the deciding vote on the Supreme Court in these cases? And I actually also think there's real value to that, and I'm going to come back to that. But again, might there be other approaches? And how might a book be structured to allow for other approaches? And so I'm going to use as an example the treatment of Congress's power over interstate commerce. on the left, and I used Stone's, I learned out of Stone Seidman, I used it for years, and I think it's a fantastic resource. I don't mean in any way to disparage it, but I just sort of picked from the table of contents. This is, the principal cases are bolded, the secondary cases are highlighted. These are the cases that have substantial excerpts in the casebook in the chapter on commerce. And the book is with Lou, so that's why it's Alexander Bilianis. Here's ours, okay? And so now, we don't, I hasten to add, we don't ignore the rest of it. The way the book is structured, and this is sort of a structure that carries through not just in this chapter, but generally, so we really tried to identify a couple or three key cases, treat other legal developments in a treatise-like fashion, as much as possible, with one major goal being to allow time in class for other things. That then has been supplemented in part in my classroom, in part as a result of experimentation in the wake of COVID, in trying to teach remotely, and then trying to carry some beneficial, I think, developments from that experience forward when we came back into the classroom. And I should add too that this is a work in progress. Okay, Louis knows it is not. He reminds me. First thing I came in the room today, he reminded me the book is not yet done. No, it is not yet done. So there is now the upside of that is there is time to improve upon what we're doing, and this is very much in the spirit of workshop. A vanishing window of time, Lewis tells me, but there is a window. This is very much in the spirit of workshop in that we're moving in this direction, but I'm very conscious, and I've learned a lot already today about ways in which we could do a lot better. So this really is, does this seem to be valuable, the direction we're moving in, but also how could we improve upon it? So the part that's carried forward from COVID is I do short lectures that are recorded, and the students are asked to, in addition to reading, to review those before class. And to a very great extent, those lectures are doing a lot of what I used to do in class time in this period. Who is Lopez? Was his gun loaded? Was it not loaded? He was indicted first in state court, then in federal court, and the indictment was dismissed, and that kind of stuff. And that's valuable, that's good, but we just kind of front load that. And stress, also the stuff that they used to finally get to sort of the end of the hour. The 3x4, these are the three major categories. If you're in the third category, you're supposed to consider these factors. And under the old method, by the end of the semester, and I love my students, and I'm constantly amazed at what they are able to accomplish. I also, realize the limitations of what can be done in a semester. And normally at the end of the semester, if students had a pretty good understanding of what a jurisdictional element was, that was a success. That you understand what is that, what that means, and let alone what might satisfy it, what role it is doing in this process, how significant it should be. Also, I always thought and I still think in some ways the most interesting question in this space is when the court went back into this area in Lopez, was that a wise thing? Okay, because the dissents tell us on the day Lopez is decided, this is deja vu all over again. We're going back into an area that we withdrew from out of wisdom, and it's folly to go back in. And I always like to talk about that question, and increasingly over the years I sort of felt students were kind of like that by the time you got to that portion of the class, that it seemed removed from their lives. And we can talk about the subsequent cases. So in the narrated, the recorded lecture, I talked a little bit about an example of a jurisdictional element, debates in the lower courts about what roles such elements might be serving in this analysis. And then when we come to class, The book includes a series of exercises that they are asked to read. When I come to class, I divide them up into small groups, assign a group a particular problem. They don't know ahead of time which problem, which group they're going to be in, which problem they're going to be assigned to. Give them some time they've already thought about this a little on their own. Give them some time to talk with their peers about the particular problem they've been assigned. And then we come together as a committee of the whole and work through each of these. And this is, these problems are really about what do these standards mean? How are they likely to play out in real life? What are the kinds of issues that are going to become salient as you go to apply these factors? And so here's one example based on a real statute, federal felony liability for anyone who intentionally defaces, damages, or destroys religious real property in or affecting interstate or foreign commerce. First of all, is that valid? Just as on its face, is that a facially valid statute? That's a question we talk about, and I think the answer is yes, but we talk about that and arguments back and forth. But then there's also, all right, so this is based on a series of real cases, a gentleman who self-identified as a practicing Luciferian, and he liked to travel around burning churches. And the case he was prosecuted for in federal court, he actually crossed state lines. But does he have to? Right? Would the jurisdictional element be satisfied if you change the facts and you had this sort of a connection with interstate commerce? How remote is it going to get? What do we focus on his conduct? Do we focus on the relationship of the institution that was the victim of the crime and its relationship to interstate commerce? How do we think through those questions? And I think that one of among the values of this experience is that it underscores the indeterminacy of the legal standard, which is not to say I think that it is without content, but that it is amorphous and ambiguous. The students quickly get to the point that there might be a role, the ideology might be playing a role in the actual application of this doctrine, and that judges with different ideological backgrounds might come at it differently. But yet they also see ways in which the doctrine, especially in the hands of lower court judges, can be constraining or at least channeling of their discretion. They practice, obviously, the analytical skill of applying the test, but also organizing because when we report back to committee as a whole, someone will report from each group, organizing how they're going to express the group conversation. And also, I think that this exercise, number of exercises also provides a role for beginning to recognize that ultimately, and this was something in my professional identity formation that took me a long time to develop comfort with. In fact, I'm still trying to develop comfort with. And that is the notion that part of what is valuable about what I can contribute, if value there is a judgment factor. That it's not algebra. It's not geometry. It is the product of reflection and your sense of the underlying values and the way that they play out in this space. One of the things I really like about this, no, it doesn't work. One of the things I really like about this is the second prong, because I'm a big fan of talking about history of doctrine and structural considerations like the role of the court in our constitutional system. But I found that if you sort of foreground those issues, again, there's kind of a eyes glaze over quality. But if you situate students in the context of you're an assistant United States attorney considering whether to bring a prosecution against someone who committed a crime like this, they very quickly, in trying to figure out what this stuff means, they very quickly start going to, well, in this case, what about the lottery case? I mean, doesn't the lottery case teach something about this? Or what about EC9? Does EC Knight have something to say about this? And so they begin reaching back into the history because they're trying to find something to grab hold of. And it makes it so you don't have to lead them to that material and tell them it is relevant. Students discover that in trying to make sense of these rather vague and amorphous standards. And then ultimately, it gives you a chance to come back after they've practiced what's it like to live as a lawyer in a post-Lopez world. And has that all been for the good, right? Now you see that there's been some uncertainty introduced, but also some role for protection of underlying values that maybe were not given judicial cognizance before. Is that all for the good? And I found that students not only are more engaged in that conversation, but say the most amazing things in that space. One of my favorites is not too long ago, a student said, all right, so is it all for the good? And they said, it's too early to tell. And I like that because it reminded me of apparently the PRC, leader of PRC, when asked about the French Revolution. Was it a socialist revolution? And the leader of the PRC said, it's too soon to tell. And I kind of felt the same way, that 30 years after Lopez, we're still trying to kind of figure out, how's this going to play out? What's it mean in practice? And then at the end of each unit, students prepare a written submission of an exam-like problem. And I am blessed with some excellent teaching assistants who help me give individualized feedback on those problems. And the one thing I will say is that I've done this now for 3 years, and progressively more and more in each iteration of the constitutional law class. And the outputs, if you will, the exams that I get are really significantly improved. And so I just got the hook. And so with that, I will stop there. But thank you for your kind attention. I really do look forward to your comments and questions.
Okay, thank you. I really appreciate the opportunity to talk to all of you about using technology as a tool to advance professional identity formation. I do want to also give my thanks and appreciation to the Holleran Center, to St. Thomas Law School. And in particular, I've had just such a rich experience being a Holleran Fellow and learning from Neil and Jerry and David and Lou and Barb and Tom Holleran himself. So I just want to say thank you for this opportunity to bring us all together and learn from each other. So I'm going to talk about tools that I use in my teaching methodologies and contracts. So as most law schools do, not all, contracts in our school is a first semester course. So I get law students right at the beginning when they're excited and energetic and just like full of possibility. So I do want to talk about that. But I also just wanted to let you know, and I'll be talking specifically about the Easy Retro board that I use and using videos for several different reasons. But I also teach 2 different upper level courses, and I do use technology in upper level courses, not so much as my teaching methodology as exercises. And so I just want to mention them. I am not going to go in depth about them, but I direct the externship program at Georgia State. There is an externship seminar that's required of all students who take an externship. That externship seminar is focused on professional identity formation, and I use a lot of leadership type exercises and try to foster leadership skills, starting with what are your values, all the way through teamwork, collaboration, cultural awareness. We cover a lot of different topics. And in teaching that course, I assign TED Talks for each one of the different modules. And then the very last class is the opportunity for students to do their own TED-style talk. And that is focused on their emerging professional identity. They need to center it on one of the Schultz-Zedek lawyering effectiveness factors. And a lot of times students want to focus on those ones that aren't explicitly taught in law school or explicitly explored, such as stress management or maybe community engagement. They also must, and it also needs to be something that's relevant to everyone in the classroom. So I have a generalist externship program. So that means that I might have somebody at a criminal prosecutor's office. I also might have somebody at a corporate in-house placement. And so really just trying to kind of broaden the idea of what can your colleagues take from these ideas you have, these new ideas about one of these effectiveness factors, and apply it to their professional career moving forward. And I've had some really interesting talks applying medical models to the law and providing bad news to clients, things like that. I also make them watch it back and assess themselves, which they say is painful, but also very helpful. I also ask them to do a kind of mini TED Talk, which is focused on Simon Sinek's Golden Circle, which is really focusing on the why. And so why are they in law school? Why did they want to be a lawyer? And why this particular externship placement? And those actually are really powerful, and students get pretty specific about why they're in law school and what they want to do with their lives. And so it's a really good reflective exercise in that way. And then the last thing I just wanted to mention about the upper level courses is I also, in my elder law class, I don't think this is new or novel, but it is really actually powerful. I taught my last class in elder law last night, and the students reflected on the entire course and said one of the most powerful things was the very beginning, where I have students go out and interview somebody 65 or older and ask just a set of 4 questions that really get to their perspective on growing older, what our country can be doing differently, the struggles that they might have, advantages they see. And the students last night, I wasn't going to mention this, but the students last night said that that was really helpful to know like who the client's going to be, and we were always centered on who that individual was, and coming back to some of those interviews who were usually people that they cared about, usually parents, grandparents, or other relatives or friends. So that was just something I wanted to mention. Okay, but I am here to talk to you about contracts teaching and how I use the Easy Retro board and videos. So the Easy Retro board, EasyRetro.io is kind of a tool that is a way to collect information anonymously from individuals. So what I do, and I will kind of tell you what the questions I ask, and if you do actually scan this, it's live, so you could see what it looks like live, but I put up at the end of every class this QR code, much larger, it takes up the whole slide, and I have students respond to 3 specific questions. This is from day 1 to day, I don't know, 28. So the 3 questions I pose are, first, what is one main takeaway you had from class? Okay, what's one thing that you learned? What unresolved questions do you have? And then, how are you doing or feeling? And the reasons I use Easy Retro versus any other method is because it is immediate. Right away, students see responses, and I see responses. It's anonymous. Now that's scary as a professor, I'm not gonna lie. Like that's a level of vulnerability I had to just be okay with, because students can put whatever they want up there, and then I have to deal with it, right? And it may be stuff that, is a little stinging, right, at times. It actually never is. So just if this is something that's of interest to you, it really actually is always constructive. And then the last part is the ability to like or comment on other posts. So if a student says something, you can just click like on it. And that helps me gauge, oh, this is something that everybody in this class is essentially sharing, right? If there's 20 likes on something in a class of 56 students, I know at least half the students have this particular feeling or this particular question. So that's really helpful. So this is what it looks like, not that you'll be able to read it, but just it's color-coded for each of the 3 different questions that are asked. And so this is after the first class of the semester. People are really excited in terms of like filling it out. I get a lot of responses. I don't require this. This is totally if you want to do this, but I say it's really helpful to my teaching and to your ability to learn. And so they do it and they say things like, wow, especially after the first class, they're like, okay, this is a good start to law school. I have, I think, a privilege that is just, I don't know, I just really see it as a privilege to be the first class they take in law school. And that is just setting the tone for law school. And I know that that can really be a powerful moment. It's a formative moment, and I don't take it lightly. And so what this does is after that very first class in law school, they're able to answer these questions, and I'll talk about what I think it helps them do, but especially in the how are you feeling or doing, it's like, I was really nervous, but I'm feeling a little bit better, or I'm still kind of stressed, or I think this is gonna be okay. So it's just, it ranges. And the takeaways are usually pretty right on in terms of what I wanted them to get out of class. And then the questions that remain, obviously there's going to be a number of them on the first day. Well, after the last class of the semester, part of the reason I added this slide is just so you could see the 3 questions that are asked at the top, because when I took that screenshot, I stopped taking screenshots of these things. I just kind of download them a different way. You can see how it looks. And even on the last class, students are still engaged in this and they're still responding to it. And this one's from this past semester in the fall. And what's interesting is that the well-being kind of is a little bit more limited and brief, and so are the takeaways. The questions become much more complicated, right, and a little bit more specific. So I think that's just kind of an interesting piece to it, which I think will demonstrate what I think it does to help with student professional identity formation, and in particular, self-determination theory. So thankfully, Lindsay went before me, and I didn't know she was going to be talking about the need for competency, for autonomy, and for relatedness. But I wanted to, as Jerry alluded to in his opening remarks about the Sheldon Krieger research, I know he's done his own research with respect to well-being and motivation and, just overall happiness. Lindsay gave, I think, a really good overview, so I'm not going to repeat what she said. But these are, again, fundamental psychological needs. And so I read an article that Doug Blaze from Tennessee wrote called Law Student Motivation, Satisfaction, and Wellbeing, the Value of Leadership and Professional Development Curriculum. It was published in the Santa Clara Law Review. And what I loved was the very first sentence that said, teaching first-year law students during their first semester is a blast, regardless of the subject area. And I absolutely agree. It is just awesome. But then something happens, and it falls off, and it's a little bit more jaded, and everybody's why is kind of lost and the purpose is lost. And so, I think part of that really has to do with this idea of not getting these essential needs. Law school really challenges those things. So those decreases in satisfaction happen, and they happen as quickly as one semester of law school. And so I think that the feedback board really helps address each of these 3 fundamental needs. So with the competence I think just saying, okay, this is the takeaway I had, and seeing somebody else had the same takeaway, right? I think that that gives students a level of competence, or a feeling of competence, that they are actually being effective and confident in what they're learning. With respect to autonomy, they're able to identify remaining questions. They're able to identify, where am I not really learning from your teaching style, right? What are the things that I need to be able to learn this better? And so they're able to name those needs. And then the third is relatedness. And I think that this is the biggest one, probably for well-being and motivation, honestly, and it's the one that I think this helps with most, is that students, without having to talk to each other, without having to talk with me, are able to see that they are a collective unit, that they are having a shared experience, and that they have a lot of the same feelings and thoughts. So what I do with this, I don't just take it and say, oh, well, that's nice, and file it away so I can talk about it at a presentation. I actually read them after every class. I delete all of the cards so it's fresh for the next class. But I download the responses and I think about them. And what I do is I identify, okay, are students getting what they need out of this class? Is it what I intended to teach? What questions remain? I start every class with the questions. Now, if it's just like one kind of random question, I might say, if you asked a question on the Easy Retro board and I didn't address it, please come talk to me in office hours. But for the most part, I start and do a short review, and I say, these are the common themes I'm seeing on the Easy Retro board. But the most important, again, thing I think I do is I address the well-being piece. And students will say, I'm just struggling really badly, like right now, or I'm just totally overwhelmed with my writing assignments. And, so we talk about it. I say, talk about my experience in law school. I normalize it for them, or try to. And I think that they appreciate that because they realize, okay, this is okay to feel this way. And that, I think, is really a helpful piece. Okay, I have 1 minute. So the other things that I'm going to just mention is meditation. I play a minute of meditation before every class. I think that that's really helpful to connect it to professional identity formation, not just because of well-being, but because there have been a couple of times where I've gotten really bad news right before I've had to walk in and teach students, and I'm able to do the minute of meditation, teach class, and then the next class I said, listen, I'm not just doing this to make you feel good. This is what you have to do to be present for the people you need to be present for. I found out that my aunt passed away right before class. I had to do that minute of meditation to be present for you. And you're gonna have to be present for your clients at certain points where you can't just take a pass. So this is why I'm doing these things, and try to connect it to practice. I do it before the practice exam. I tell them to do it on their actual exam. And my upper level students ask me to do it in the upper level, which I think I didn't used to do. I only did it for my 1Ls, and now I do. So I will leave it there, and I really appreciate you listening.
For 7 more minutes, I can say good morning, everyone. So I'll say that. And thank you, Neil. And by way of my thank you to St. Thomas and to all of you that have worked so hard to put this together, I will just say this. Do you all know how lucky you are to have Jerry Organ and Neil Hamilton here? These two men are treasures in legal education, treasures in the legal education reform space. Everybody who cares about this issue knows who they are. And among them, I am one. If either of them call and say, would you show up at fill in the blank? The answer is yes. Yes, I can. Tell me where and tell me when. I'll adjust my syllabus so I can do so. So, honored to be here, thrilled to be a part of the morning. I'm also acutely aware of the fact that I stand between you and lunch. You know, you are asked to do something like this, you get the program a few days before you look at it and you think, oh, great, I'm right before lunch. But actually, I think maybe I'm perfectly placed here today because I hope what I'm planning to offer you is a bit of a summary of the morning, and even will harken back to what both Jerry and Neil said to get us started. This morning, we've heard 7 different presentations, essentially what I would put in the category of what I call WID. WID stands for What I Did. And these are fabulous presentations. My goodness, on the first panel this morning, was your head ready to explode? These things terrify our colleagues. Absolutely terrify them. They're brilliant. They're fabulous. They're the end game, I submit. The question I think before us is, what can we do now to help our colleagues to understand that even a module in every class would be a huge step forward? And so that's what I want to offer to you this morning, briefly, quickly, as follows. Remember what the great jazz musician Charlie Mingus said? I actually brought it up on my phone. Let me quote it to you. Making the simple complicated is commonplace. Making the complicated simple, awesomely simple. That's creativity. I'm not suggesting that I've done that or that what I'm going to offer you has fit that model, but at least I'm going to try. My learning outcomes for this short presentation are there on the screen. To learn a 5-step sequence that we can teach our colleagues to integrate and exercise a module in their courses, to understand how to use it if you'd like to try it yourself or to teach to another, and then consider how to assess it. Starting as an introduction, some basic points, which may be ones you already know, but I think it's important that we understand and share with our colleagues that formation of professional identity from Chapter 4 in the Carnegie Report is not the same thing as professionalism. Professionalism is something we actually teach fairly well in a number of different ways throughout the curriculum. I call those expected behaviors of lawyers. Professional identity, though, from the Carnegie Report, is more about the formation that happens when students make decisions above the line. What line am I referring to? The ethical line. No law student goes to law school to go heavily into debt to figure out how to violate the ethical rules, right? But I fear, as Jerry has said in other words this morning, that what we're actually teaching them is that they should be a snake that slithers along that ethical line, that that's their role. When indeed, what we really have envisioned for our students and hope for our students is that they will live well above the line, that they will make decisions above the line all the time that are appropriate to the situation. So that's my way of introduction. Those clear lines, I think, are helpful for our colleagues, but many of them will mix up professionalism and say, well, wait a second, we teach the ethics class. What are you talking about? So let's be sure we share this difference with them. The thing about formation of professional identity that I think is really important to understand, we teachers think we can teach it. It's not something we can teach, actually, at least not didactically from the podium like most of what we do. Why is that? It's simply because you can't teach someone else to form their identity. They come to law school with their identity, as Jerry reminded us this morning. What we can do, though, is create situations, exercises in which students can practice making these decisions and reflect on them. That we can do as teachers to create an environment in which students are confronted with the experience of making those above the line decisions. That's how they will form. And you notice here, of course, the importance of reflection, which Neil reminded us of this morning. So here's my entire presentation on one slide. 5-step process. From the left, an exercise that identifies an ethical issue. The student makes a decision above the line, reflects on that decision, and is provided with some kind of feedback from the professor. That's a guided sequence for formation of professional identity. And this can be done in medical malpractice simulations that take a large chunk of a torts class, the kind that might scare some of our colleagues, and Jamie impressed us with so much this morning. Or it could be something so much smaller and simpler, where the professor assigns some kind of contextual exercise with an embedded ethical issue must be made by the student to answer the prompt. That identification is made, the student decides how they will resolve the issue in a way that's consistent with their forming professional identity. Then the student reflects on that decision, how it was consistent for them. And finally, they're given some feedback, not on whether it was the right or the wrong, right? Because it's all above the line, but rather focusing on the depth and thoughtfulness of the reflection. That's a guided sequence. It can be created in any first-year course. I hope tomorrow that part of our workshop time will be spent trying to figure out how to build these smaller modules that build up to the end game that we heard so brilliantly this morning. Two key components to these. First, on the left, students enroll. Second, confronting the ethical issue. On the left, the exercise puts each student in the role of the attorney, and we heard this morning how much that role playing is so central to this formation experience, where they have to make a decision, maybe several decisions, where there's no clear answer. It's a decision that they get to make that's consistent with their forming identity. And then the reflection is so important, as Neil reminded us this morning. On the confronting side, in the context, of course, of your course subject, ideally in a way that illustrates a key component of that subject, and that it improves learning, right? You're not just doing this for fun or for extra, you're doing it for a learning objective. It's important that we be explicit about what we are doing with our students so they understand, where we are actually stating our learning outcomes. Like, here's an example. Identify and evaluate ethical issues as they arise in the context of tort law, property law, constitutional law. Decide how you would resolve them, reflect on how making this decision advanced the formation of your professional identity. So what I'm suggesting is put it in your learning outcomes for the course. Second, of course, conduct the exercise as a module or several. Student describes the ethical issue, explains how they made the decision, reflects on how that was consistent with their professional identity. And then you must assess it, or a TA or RA. We heard about the role that TAs can do to help with this. Was the issue correctly identified? Did the decision make sense? and focus on the clarity and depth of the reflection. Give them feedback that that's the level of reflection that you're looking for. It is important that they have grade consequences. It may be a small amount of the grade, but part of students buying into a new way of learning for some time, this is going to be new. There needs to be grade consequences. So, yes, I have my own what I did, an example course, but this is just very briefly to describe also in the discovery law context, not in civil procedure first year, but as an upper level course that focuses on discovery law. And it's a whole course simulation. Simulations are a tremendous way to do this kind of formation work. Students are enrolled, right? It's very important that they be enrolled. They're either plaintiff or defendant in a mock litigation all semester, preparing discovery documents each week, serving their assigned opposing counsel. Last class, they settled a case. Ethical issues, nearly every discovery document raises ethical close calls. Students make decisions about how they will resolve them. They write a memo in which they describe that decision they make and reflect on how that was consistent with their forming professional identity. I describe that course only so I can show you the next 4 slides, which are example student reflections in that course. I won't read those. I'll take a moment to let you read them. So in summary, by creating learning sequences that place students in role, allowing them to practice identifying ethical issues above the line, make a decision about how they would resolve them, then reflecting on how that decision is consistent with their developing professional identity, we give our students opportunities to form their identity as a future practitioner. What I want you all to encourage is to get your colleagues, particularly in the first year, to try one of these modules, one of these sequences. It's that simple, really. It doesn't have to take over the course. It doesn't have to threaten coverage. It doesn't have to come out of the curriculum reform committee. I mean, do you guys know that at baby dean school, that the deans are taught to avoid curricular reform at all costs? It's known as a dean killer, right? That's what we're up against. We need to encourage our colleagues, explain that it can be done in a manageable way that will help your students feel like lawyers in the first year and not lose all the sense that they brought and commitment they brought to law school. Good to see you all today. We're going to continue these conversations. Questions?
Thank you. I wanted to ask about the retro board. I think that's awesome. But I know you said you haven't had problems with anonymity. I can imagine a world in which I would not have challenges with that in my classroom. And so I want to be thoughtful about it before I adopt it because I'm in. But I wonder what kind of foregrounding you do, like what kind of norm setting do you do around having that kind of access to something that's anonymous? Because I can imagine some pretty harmful things can be said there that can make things a little bit worse. And so how do you balance that? What do you do ahead of time before you put something like that up?
Well, I explain the reasons why I'm using it. I will say, I mean, there are times where they'll say, this particular mode of teaching isn't working for me or whatever. And, I either will adjust if enough people are having that issue, I might adjust and try to listen to them again, because I think that feeds that autonomy piece. But I think that it actually, even if it's something that seems harmful at the time, it allows you to essentially address something that's percolating anyway. So, for example, I started using this in 2020. In fall of 2020, I was in person, and my students were just kind of spinning out because they had nobody in the building to talk to about the normalcy of a lot of these feelings. And so there were things that they put up on the retro board that I think I just addressed straight up. I said, that's not correct. These are the reasons why. Your perception is inaccurate. And it shut it down. So otherwise, I think it would have continued that. I think the biggest one has been people who say, well, I feel like you entertain too many questions from people, right? And then the people who are asking the questions may feel a little bit like silenced or a little bit more hesitant. And that is just a real easy response. And I said, I'm going to keep calling on people. This is why I call on people, when they have questions. If I don't think it's something worth, I will address it in office hours. So we just have these kind of explicit conversations. And so, maybe next semester, knock on wood, I hope not, it'll backfire. But I think because I have an open rapport with them and I say, this is why you're adults, you're learning, but I expect you'll treat it in that manner, that we're all mature professionals here, and that this is for feedback purposes. And it hasn't been an issue, and it's actually identified problems before they really become problems.
Is it on? A second great panel. Are we on our second? Anyway, it's all been wonderful so far, really insight dense and wonderfully useful. My question is sort of primarily for Lindsay, but maybe for the panel as a whole, and maybe I'll be told that this is not the right panel for addressing it because it's sort of a systemic question. But the question is, and it may be different at all of our law schools, how do we think about issues of race, gender, ability, you could call it like DEI, MCAR, all the various different sorts of terms. And I think about it partly because we're teachers here, it's a largely white environment and disabilities are invisible, but we're all a lot of privilege just to be able to be in the room. And the little things that I've done around the edges to kind of work on these questions in my classes, I've experienced a lot of instances in which the fact that either first-gen students or students with other sorts of identities that are not in the mainstream or sort of centered come from a different starting point. And so when we're thinking about professional identity, whether it's in the group work, which is where I really, and your anecdote about that really kind of raised it for me, made me think that there are techniques and strategies that we need to have to be kind of nimble. And I'm just wondering if you can think through that with us. And maybe it is kind of an ongoing theme, like when we're thinking about professional identity formation, where are people starting and what do we need to do to help people along? Thank you.
Yeah, it's a big question. So I talk about it repeatedly in class. I teach property and it's all over property. So it's something that we talk about as we're talking about the substantive law anyway. I also have had situations where I've gone to teams or one member of the team on the side or a couple of members on the team and say, do you see that you're underusing this student, that this student is quiet while you guys are discussing? Because they discuss in front of me. And so I do watch them very carefully. Last semester, we had a transgender student, and he was in a team of it was an all-male team. And they were right in front of me. So I watched them very carefully and for any kind of anything. And I couldn't see anything. And the student mentioned later that community was helpful. So yeah, you are going to have problems. Students being afraid of conflict is kind of an obstacle that we need to clear right away. And then watching them carefully and trying to get in there before harm is done, because sometimes harm is done. So I don't have a magic answer. It certainly creates an environment where there could be problems, but I can see it. You really can see it when someone is being excluded, and I do take steps to try and help the team, not to do it myself, but to help the team recognize what's going on.
I just wanted to mention that I do think that one of the values of the anonymous feedback board is that the students who might otherwise be very quiet in class and not feel like they have a voice and not feel like they're a part of the fabric of the law school, honestly, can have a voice and speak up. And I found that since I've been doing this, more students have been, especially students of color, have been coming to my office for office hours. I think, find that maybe I'm more open to being just accessible and talking about anything, and I invite them to do that, but to actually get students to walk in the door is a very different thing. And I think that has mattered. It's to the whole belonging piece, right? But I do the same thing. Just, I was going to mention, I also use videos for to bring like the stories, and I know people are going to be talking about this later in other panels of the cases to life. But really acknowledging, in contracts, there's definitely things to acknowledge in contracts, the reasonable person standard, some of the cases, so.
Any last question?
All right, everyone. We're going to get started on our afternoon session for our lunch break presentation. I'm Abigail Seeley. I am the resident timekeeper of the day, so I'm sure all of you just love me. I'm also an associate editor on our journal, and I am glad to be the one to welcome Professor Martha Ertman, who is from the University of Maryland Francis King Carey School of Law. Her presentation on technology tools for teaching professional identity formation. So please, of course, see Professor Ertman's accomplishments in the biography section of our program. And the presentation will be about 25 minutes, followed by a 10-minute Q&A period. So please join me in welcoming her.
And I am welcoming you to lunch. I am so grateful that you are all willing to spend your lunch hour talking about teaching, and of course, spending the whole day talking about teaching. It is such an extraordinarily important time for techniques and the tasks that lawyers are doing to change. And of course, that means our jobs have got to change. So thank you, St. Thomas, and all the organizers and the law review for pulling this together. The material I'll be talking about is material I've created with West Academics. So thank you to Pamela Siege-Chandler, whose ingenuity and willingness to go with something new has been present at every step of the game. To Stacy Hare, who also has been willing to just think in new ways about how to convey material. And to Carol Logie, who I think is not here, but is the instructional designer who worked miracles for us. So in the image, you can see that I've sort of renamed the talk a bit to be videos, PowerPoints, and other teaching materials. The imagery is crucial. It seems to me we are at a moment where if you wanted to learn to do something, like put a harness on your dog, you would look at YouTube. We are in a visual moment. And legal education has just left so many tools off the table by not using images, not using color, not using video to convey the basic material that we need to convey, which then allows us to get fancy with applying it. So, not surprisingly, when we're talking about images and we're talking about the formation of professional identity, people need to see themselves in the law to imagine themselves in the law. So when I just recently listened to Dahlia Lithwick's book, Lady Justice, about women and the law and activism. And one of the stories she tells is about how she went to law school in the late 80s or 90s. And she says, I probably wouldn't have gone except for Sandra Day O'Connor getting appointed to the bench. There had to be somebody prominent who looked like me for me to imagine myself in that situation. So part of when Deborah Threedy, Billy Solstrom, and I set out to make a contracts book that was going to integrate some of the new ideas about how to teach and to convey the beauty that is contract law in an accessible format. One thing we set out from the very beginning was to have more pictures than law case books usually have, which is not saying much because usually there are none. So part of the imagery that we had is not only to break up the text on the page, but to very intentionally pick the pictures that will help the students see themselves in the law and then be well on their way toward that. That, of course, includes, as these pictures suggest, a recognition that law students and lawyers and people who are clients and decision makers at all levels come from all different identity categories. So it's really important to recognize that. Different professors are going to do it in different ways. The way we do it is sort of the way that the wallpaper works in this room. It is a seemingly neutral background that nevertheless shapes the experience of the entire endeavor. So looking at, I also hadn't realized that I had been thinking about and working in developing professional identity until I put together this this talk for today. And I found this article by Capelong, King, Reese, and Mills about anti-racism reflection and professional identity, really newly out in Hastings 2021. And one of the things they name, which I think most sentient beings would already know, is that the law is raced as white and neutral. And as a result, students of color often experience themselves as outside of that. So one of the things these authors do is they label professional identity formation as either bleached out if it doesn't recognize multiple identity categories, or inclusive. I think some other presenters are going to be talking about reflective measures in teaching. That won't be my focus, but what I will be doing is to suggest that in creating our contract materials, and I think you could do this for any subject, we tried to be conscious of all kinds of identity categories and be inclusive on gender, race, disability, and other categories. So the idea is, how many of you all have been to downtown Chicago, to Millennium Park, where the Bean is? How many of you all notice something sort of unusual about the sidewalks as you go over there, like ribbons that go over to an amphitheater? It is called universal design. There are no steps. Why do you suppose there are no steps? People with wheels can easily get around. But just like the ramps that are in, on the sidewalks, courtesy of the Americans with Disability Act, we passed the rules in order to facilitate inclusion for people in wheelchairs. And it turns out people with baby buggies and walkers and wheelie luggage all benefit from it. So Millennium Park is an example of universal design architecture. It does the job it does, but the structure is structured so everybody can participate. And I think that's part of why it's immensely welcoming, not because it has big sign that says everyone's welcome here. It is more because it is built to be welcoming. Everything is very wide, and you can see this is that kind of ribbon-like sidewalk that goes over to the amphitheater. So universal design is also an analysis of pedagogy, the idea being to structure your instruction to be as welcoming as it could be to all the folks who are coming into your classroom from different backgrounds. Now, I don't even pretend to understand all these circles, but I was happy to find the colorful graphic. What I can tell you is that when Deborah 3D, Billy Solstrom, and I wrote this book, we had in mind to identify potential barriers to students understanding contract law, to find ways to provide universal supports for folks so they could really get the material and be able to use it in their upper division classes, and to use guidelines throughout of accessibility. So when it came time to do videos that I'll talk about in a moment, we needed a lot of tech help to have closed captioning. But once you get the tech help to do it, it's available to all kinds of people. And once you start using it, you find out that the students who find things pretty easy can listen at 1 1/4 time. The students who are having trouble, or if it's a really thorny questions, are listening at 3/4 time. And so what it does is it meets people where they are. And that, I think, is a huge piece of inclusive identity formation, which is to say, you're the future lawyers. We need to meet you where you are and give you some tools. Now, I mentioned how what we do is the metaphor is the wallpaper. We don't have a lot of materials, a lot of examples about restrictive racial covenants in the casebook. What instead we do is we just try to build the wallpaper to tell a story about inclusion in law, that there is room for all kinds of lawyers. And so part of how we do that is we have a hard copy casebook. We have videos that are both online as part of the hard copy that are very fancy, and I'll demo those. Those are courtesy of Carol Logie and folks, but most people can't do that, although West owns those avatars. And if there are professors who want to do this, I see Pamela like, really, are you really offering this? I would love, we put so much work into them. I would love them if these avatars have a life in other projects. But what I want to do is spend some time talking about something along the lines of what I understood Chris Bryant to be saying this morning about making lecture videos in your kitchen on Zoom with PowerPoints that replicate what you would say at the beginning of a class and lecture on whiteboard. And that means the students can go back to them. They can use them to study. At the end of them, there are true-false quizzes. So one of the great ways to study at the end of the exam, rewatch the lecture video quizzes, see which ones you get right. And then the last one is in terms of having visuals in the classroom. I think COVID changed all of us in all kinds of ways. What it did for me is it put my PowerPoint and video game on steroids. We just had to come to life. And so what we had to do is to make more asynchronous time for the students who are stuck staring at the childhood bedroom campus of law school, to make that a little less painful, to have asynchronous stuff that they could look at when they weren't completely brain fried from Zoom. All right, so one of the things we did when Deborah and Billy and I were creating this book is that we decided to get rid of the buggy whip cases, literally cases having to do with buggy whips, in part because contract law changes. And in fact, we should have facts and situations that reflect the world we're living in now. So our goal with choosing cases was choosing cases that are decided in the lives of our students. Now, that is almost like yesterday in legal time. So we had to say it could also be decided in the lives of most of our students' parents. So at least it seemed remotely related. And remember, I said we wanted to use pictures to break up the text. So we have pictures, bios of the judges. Initially, we just thought this is breaking up the text, showing this is like human beings. The law is made by human beings. One of the things we found out is Because we're using non-buggy whip cases, the diversity of the judges is much more impressive. So one of the cases we have, Feldman v. Google, which was decided in 2007, has Judge Giles. In the case, he refers to a famous case called Spectrum Netscape that's decided by Sonia Sotomayor when she was an appellate court judge. We also have for Sparrow versus DeMonico, Justice Fernandez Van Dupley, who became the first Asian American to serve on the Massachusetts highest court in 2010. So part of the story we're telling is that there are all kinds of folks in the judiciary, they're making these decisions, and they got here about 10 minutes ago. There's another judge whose picture is not on here. His name is Denny Chen. He was appointed to the Second Circuit as an Obama appointee. He was the first Asian American named to a federal appellate bench, and he's outside of the Ninth Circuit, and he's an Obama appointee. So really important to get the sense of what's happening. As we're writing these, we're also aware that we have to, of course, get cases that stand for these core doctrinal points. And one of them on third-party beneficiaries of contracts, Doe versus Walmart, happened to be decided by Judge Gold. We did a bio on him, and I find out he has multiple sclerosis. And so he is in a wheelchair and works with a number of supports. And so my hope is that students who come from all kinds, sometimes visible disabilities, some not so visible disabilities, can see themselves and think, that can be me. And that's really, and I think that's a huge piece of identity formation, that it's not the law over there, but it's the law for that I can really be a part of, because of course our students will be. We also use naming in order to be inclusive. The goal throughout was both racial, ethnic, and gender inclusivity. It's a mark of how our thinking changed along the way. That when we started, I talked about it as gender and race neutrality. And then I realized there's no such thing as neutrality, because nobody doesn't have some kind of subject matter position. So we switched it to inclusivity. And so in chapters 1 through 4, our hypos all involve A and B, because the restatement of contracts involves examples of A and B. So there's always A is always on the left part of a slide, and there's always B. But who is A and who is B differs. Instead of having Adams and Baker throughout, and in similar examples, we have Adam and Bianca for the first few chapters. Then in 5, 6, and 7, we have gender inclusive language. Those chapters also refrain from pronouns in the material that we wrote. What was so interesting is in writing it, I thought it would make it clunkier. In the vast majority of situations, it made the writing more clear, which itself was immensely interesting. So we were Ali and Blair, and the demo I'm going to show you of some part of the casebook, that's the fancy animated videos that Wes created, has Ali, but now for our second edition, coming soon to a bookstore near you, is going to be Alex, that my 93-year-old mother said, oh, I don't know why your gender inclusive name is Allie, it should be Alex. So we all are still doing bad news and good news. We're still doing what our mother tells us to do. And then there's Andre and Babette, and there are for our last chapters. So notice they show up in the problems, they show up in the diagrams. And in terms of not hiding the ball, those diagrams are a huge piece of what we were hoping to build a scaffold to make people realize how fun contracts is. Okay, the only reason we could do this is because my co-author, Deborah Threedy, had 10 years ago made a series of videos about contract law with Terry Kogan. We all used to be on the faculty at the University of Utah. There's this guy, Aaron DeWalt, who was a crucial player getting a PhD at the time at the University of Utah in instructional design. Googled him yesterday to find out he's now a senior vice president of product at Quimby. So if you have ever used Quimby, he's your guy. There we go. Okay. This kind of cognitive science analysis about how to visually portray complicated doctrine in a way to facilitate the bottom line of what's called Bloom's taxonomy for teaching to transfer information. It's not going to happen just because you pick a color and like it. He carefully picks the colors and has the same voiceover and not too much text on slides, all of which they learned. So these videos, there are, I forget how many of these, they have more than 300,000 hits. So especially around bar time, there are tons of them, but they are way too long. Some are 60 minutes long. Turns out the average attention span is 7 minutes. So when we had a chance to redo it, we did our fancy academic, West Academic animated videos. Every single one is 5 minutes. So the idea is whatever we got to say, we're saying it in a small enough chunk that you can get it before you read a single word. So the idea is you open a chapter, you find out, oh, this is the statute of frauds about when a writing is required. And the first thing you do is you read, you watch a 5-minute video and you take some quizzes. Then you know the terms, you know the concepts, and you know what to look for in the writing. But if you look at this too, you'll notice that the characters are all white. And so part of what Deborah wanted to do is do a 2.0 version. And so we got to do that in our casebook. And because of COVID, we did much more. So in making these videos, I say to the fantastic West people, I want gender and race inclusive avatars. And so I get like Archie and Veronica back. And I'm like, really? That's not quite what I had in mind. We go back and forth many, many times. And then Carol Logie sends me this collection of characters that have from a variety of subject positions. And where we ended up out of these and life circumstances, which of course is about who lawyers are and also the people they work with, we end up with 3 major characters. So the one upper right here is, or your left, is Adam or Alex or Andre. There's Bianca, Blair, and Babette. I was kind of happy she's a little thick around the middle. We all ended up after COVID a little thicker around the middle than we were. And then when we have a third person, most of the hypos are simple and they have 2, it's Chang. So you'll notice that like the PBS Kids logo that is green, the idea is because no human has a green face, that we're picked the faces nobody has to be inclusive. Whether that works or not, I don't know. It certainly was well-intentioned. All right, so here are our videos. What I'd like to do now is demo really quickly part of one so you can see. This one is on statute of frauds, and it will be, this is my co-author.
Applies only in cases that involve the types of contracts that have to be in writing. Contrary to popular belief.
Blah, 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 blah. Then if you go down to the section that says the salon lease is where you meet our avatars.
Redoing the lease on the lease top. Say that Blair emails Elise saying, if you want, I'll renew your lease for 5 more years at the same rent. That's Blair.
So then you restart the attention and you engage in interactive material by having a quiz embedded. Can Ali enforce the emailed lease renewal? If you get it right, you get a satisfying little noise. If you get it wrong, you get a cheerful little bzzz. So it goes through and then there are quizzes. I don't have an awful lot of time, so I'm not going to continue doing that. But what I do want to do is let you know that most people won't be able to do that kind of work unless they have the tremendous support of the publisher, which is great. Ask to use our avatars. They are wonderful. They're very friendly. All right. But for those of you who are teaching and think that's more than I know what to do, during the pandemic, I started doing these canned lecture videos. And what I would do is have part of the lecture be the lecture piece, be online, and then the students can re-access it and do it at whatever order they want to. So this is one that's on the mirror image rule, which is about what everybody hates, the battle of the forms. So I had got a research assistant who pulled up the same music for me, beginning and end.
This is Martha Urban, and this is lecture video 2I, your image role. It's part of module 2.
Okay, so we go a little further. And
it requires us to resolve issues.
what are we talking about?
Keep in mind, this is a different approach than CCR2, which is known as forms. All right, common law mirror image role is exactly what it sounds like. Just like when you look at yourself in the mirror should reflect exactly what you are.
Okay, so the common law mirror image role should reflect exactly what you are and should not keep playing. And so in that moment of seeing a human being looking in a mirror, the student imagines consciously or unconsciously their own experience of looking in mirrors, and they have a something to help remember. The mirror image role is different from the mailbox role, is different from the battle of the form. So it really is pedagogical to take these complicated labels and give them places that they will live in the student's memory, and so they can go and find them and use them later. There is using these images throughout. There's a huge piece of this. This is another one I won't also, unless you ask me really nicely. There's another video about big breaches and little breaches in contract law. Some of you all may remember. There's material breach, which is a really big breach and has big consequences. And then there's substantial performance, which is a little breach and has littler consequences. And so, of course, the analogy is something we've all lived with, which is holes in our clothing. So a big breach is like the top left hole, hard to use those pants again. Probably this contractual relationship is over. Little ones, we can work with. And so in doing that and using these same images again and again and again, there's a concrete, often body-related metaphor from a common situation that all of us have lived in to give us a label for a complicated doctrinal idea, which is that not all breaches of contract are the same. There are little ones and big ones. These are the fancy labels for the little ones and big ones. And therefore you can talk about what the consequences are of labeling a particular kind of non-performance material breach or substantial performance. Similarly here, so we go through, and then if I were going to share the video, that's where it would be. But the point is that anybody can do this. I could only learn to do it because my co-author had done it and because of the fantastic folks at West. But anybody can do it at their house, at their kitchen table with a voiceover. We all know how to make recordings on Zoom and use PowerPoint. So my suggestion when I give talks about encouraging other people to do this, because my students tell me it's immensely effective. So first of all is free ride. Ask your casebook authors, ask your colleagues, do you have slides? So then you don't have to create it from scratch. Tailor those slides. Insert images. Those of you who are under 30 know that you can say on insert images, you could say transparent red check, and you'd get a lovely red check that you can put in. So you can you can get the kind of diversity you're looking to represent in your pictures that are in the color, in the domain. Good news is my first draft, I had pictures of I had myself because I thought, oh, they need to know. In fact, some students said, this is great. I felt like I got a private lecture. I had you in, I mean, it seems like terrible news, but I had you in my kitchen table telling me what the law was. But that it turns out pedagogically, it works better to not have a picture. It works better to not have your camera on as you're recording it. So you can do it in your pajamas. Not that I ever did. And then at the end, you have, I have simple true false questions. They're really easy to write, unlike multiple choice questions. And then that does the serious cognitive work of recall and reuse. So at the end of the semester, students rewatch all the videos and they retake the quizzes. And the grades they have for all these quizzes are 15% of their grade, but it's the most recent. So it's a much more effective way to study than rereading your notes or the materials, is to go back in and see it. And it could be that dorky music or the image is something that makes it hook. The best compliment I ever got about these videos was from a student who said, during finals period, Professor Ertman, I dreamt about that music from your videos. And I thought that was really great, because that means in his unconscious, when his brain was doing first of all, who doesn't want your students to like live and breathe and sleep your immensely important topic that you're teaching? But also it means that in that hugely important unconscious time where the brain is integrating stuff, this gets in, unlike 8 million more words on the page. So this is just the example of the slides, how they show up over and over again. Notice that the yellows always with the big breach, the blues always with the little breach. And the idea is to give a bunch of cognitive cues to make it easier to get these distinctions and to just hold on to them. Little tiny things, Easter eggs. Anybody know the grocery store H Mart? Korean grocery store. So I make it Huge Mart. So my hope is that someone who knows about H Mart has a little feeling of, oh, that looks familiar. Maybe I don't hate this course after all. Unless, of course, they had a bad experience. The last thing is for the professors is to give a shout out to James Lang, who I heard about at another conference like this a few years ago. He's now on his own, but he used to be an English professor at a little Catholic school in Massachusetts, and has a whole series of books that are about synthesizing the cognitive science of teaching in order to do our jobs better. And so what's wonderful about his book, Small Teaching, is that he recognizes that you're not going to go to a talk like this. And I mean, you go to a talk like this and you think, oh, I want to be just like Martha Ertman. Of course, who doesn't? But I didn't just do this overnight. It took years. And in fact, it took little bits. So every engagement is just over a period of time. Our tech support is fantastic. And so that those make a really, really big difference. The bottom line, which I think is good news for my students, is that when they ask me, can I come talk to you in office hours about fill in the blank thorny issue like the Battle of the Worms, I say, sure, that's great. First, rewatch the videos. And sometimes they watch the Fancy West animated ones. Sometimes they watch the do it at your own kitchen counter ones. But then when they come in, they say, you know what? I got my question answered from the videos, but now I have new questions. So the questions I'm getting are a much higher level of analysis. And the exams I'm getting are at a much higher level of analysis. So I guess what I would just offer you is that I think increasingly the fact that so many of you know Quimby is a good sign of that this is just the direction we're going in legal education, that we have left so much off the table in our romance with, black words on a white page, and that there's a lot more we can do to get to the good stuff of actually talking about what the law is and how our students will change it in all kinds of ways. So thank you.
Questions?
Yeah.
Martha, was spectacular, and so are all the other books that we've seen this morning. My question to you and to all of those authors and to our fabulous West reps. Are these books flying off the shelves?
That's what West can tell you. Ours is brand new. We just have a second edition coming out.
So let me give a little more context to this. First of all, I've texted both of my daughters while you were talking that I was watching the first racially disability inclusive law textbook I've ever seen.
Oh.
So congratulations, and they're both thrilled.
Oh, great. That's great.
One of them is in law school.
Great.
But how do we sell these to our colleagues is really where my question is going. I also am asking this question from the point of view of having 2 books with Carolina.
Mhm. Right.
To support experiential learning and
Right.
formation of professional identity.
Right.
They're not flying off the shelves, so admission here. How, there is no question, really, there hasn't been more than a decade, that if we're going to teach in a different way, we have to have teaching materials that support teaching in a different way, particularly for those of our colleagues and our new colleagues who come into the academy and are looking for a textbook. But what I see is my students still breaking their back carrying 1,300-page common law textbooks. And one after another, and it's not changing. Are we on the cusp of that changing with books like your own, or the ones we heard about this morning? Or are we creating the great right answer that we still can't seem to get our colleagues to adopt?
I think there definitely are a set of professors who laminate their notes. And that's just the downside of tenure. Let's be honest. But
at least they laminate them.
Yeah, exactly. But there are, and I think the good news is a lot of schools were not hiring right after the financial collapse of 2008. And then in the last few years have been doing a lot of hiring. That means there are a lot of, certainly at my law school, and I think at a lot of law schools, there are not a lot of folks for whom visual communication is in fact how they would like to communicate. So I hope, of course, that's why I do it, is to hope to be part of this change I want to see in the world. The way we did it, and this is, I'm looking at you, Colleen Medill, about my first book for a teaching book was part of the Developing Professional Skills series. Thank you, Lewis. And it was definitely prepared as a course in a box. So any middle-aged dog could come in and learn a few new tricks. So that may be it. It could be students fomenting rebellion. Students who say, listen, these are the kinds of materials I want. At least according, and of course, I wrote the book and then I use it. So take it with a grain of salt when my students say it's really very effective. But other professors have said that their students like it too. And so I think if they're all different kinds, now this is where I ask the West people, cover your ears. A lot of professors assign the old edition because that's going to be way cheaper. And I think that may be writing to have a bunch to maximize the number of materials that can be out there is crucial. So that might be it. It might be that the hierarchies are too set. I think at the higher tiered schools, the hierarchies are probably way too set. But I also think the next gen bar exam is going to change it because some schools are never going to worry about bar passage, but most schools are going to worry about bar passage and about preparing their students. And so these kinds of materials, we have a yacht sale, just to be economically inclusive. Our standard contract is a yacht sale agreement. And we have problems about the yacht sale just peppered throughout the book. And so the idea is maybe a professor doesn't do any of those problems the first time she uses the book. And then maybe the second or third time, it seems like, oh, I could take on those problems. Yeah.
When you were talking about student rebellion, I was thinking of my 1L property course.
Yes.
Because our professor refused to use slides. Like several students emailed and were like, could you please write on the board when you're talking about future interests? It's hard to follow. And she pedagogically firmly believed that 1Ls should not get PowerPoint. And she would use them in upper classes. So I'm asking, from a student perspective, what could we be doing to
Foment.
Market to our.
Foment. Go back to your childhood. Can I have a lollipop? Can I? Chances are eventually you'll get the lollipop. So what I do is I create 2 sets of the PowerPoint slides. There's the professor version that has the answers and the student version that does not. And so my hope, and it started in COVID, which is, it was so brutal for them. And so I felt like print out the slides if you have printing capacity, make your notes on the slides and do it that way. So, and if professors cannibalize from their colleagues, which PS, anybody who teaches any topic, I am so happy to share any of these. Once you have a template to work from, it's much easier. Also, once you get that, everybody responds well to positive reinforcement. Gee, I'm so happy you posted those slides. Thank you. Who doesn't love that? But foment, absolutely foment. There are so many of you and one of us in any given class.
I was really fascinated by the conversation about like collective access, like
Mhm.
the analogy to Millennium Park.
Mhm.
But I also see a lot of the legal field seems to be very, that's your job to figure out. If you
Mhm.
need access, then you need to advocate it. Kind of that pull yourself up by your bootstraps mentality. So how can we as students and professors go back to our schools and advocate that everybody should have access, like advocate for that collective access through use of textbooks like yours?
Oh, well, yes. I think, first of all, every school should mandate our textbook. That should be the first thing accreditation requires. I think in a lot of ways, and this is a key question, there was the Arkansas professor who said that you studied how bar passage was based on particular methods. So I think that kind of empirical data is immensely helpful. The zeitgeist, at least from my perspective, seems to be all about inclusion. A huge piece of the next gen bar development has been to make the practice of law and the exam more inclusive. And so that certainly goes to inclusivity based on disabilities or range of abilities and on race, gender, class stuff. So I think it's in the air. The question is, how can it be made easy? And I think that's the idea of the small teaching, that there can be smaller interventions. Our faculty at our annual faculty retreat is going to have a section on disability. Apparently, there are particular pens that can be used that essentially transcribe a lecture. So their technology, not surprisingly, is pushing up, as ChatGPT is, pushing up against all sorts of things. And our job is to be teachers and to get that done. So it seems to me, I don't know, am I wrong? I think the deans are really responsive. They assume when they hear from one student, there are 10 fomenting outside their doors. Yeah.
So I appreciate the design elements that you're including to create so that folks, whenever they look at the textbook, they can see themselves in the law. And I think that that's really, really important. And that goes into our entire topic today around like professional identity formation. But my question is slightly different for those students who the law has been reflected as them for their entire lives. How do you get those students to engage with that material and do some perspective taking? The Holleran Center talks about this in some of the competencies and the models that they have around cultural awareness and things like that. But how do you get those students, especially ones who might not be willing to engage in it or just see it as you using another ploy for inclusivity?
Right. It's so woke. I guess I don't understand what the features of being asleep are so great. I mean, other than your brain is doing good work when you're asleep. But I have lots of pictures of the old guard. There are lots of white male judges in our pictures. For purposes of the slideshow, I pulled out the DEI elements. And indeed, so that is, that's part of the wallpaper without us doing anything. And I think part of the advantage of making it wallpaper instead of big conscious frontal lobe activity is that it's just in the background. I have not had anybody push back. My guess is that it's kind of invisible, because students are so busy figuring out like what's a statute of frauds, what counts as a writing, what counts as a signature. And so the idea is that it gets in it's kind of subliminally, but I haven't gotten pushback.
my question isn't really about pushback as much as it's about them taking the perspective of someone who looks different than them. And so if you're thinking about a contract, whenever you're thinking about the reasonable person standard.
Yeah.
In contracts, is the reasonable person standard just what you would think as a lawyer, a person who's been overeducated, who maybe has families who have businesses and things like that?
Yeah.
Taking on the perspective of the client, the person in front of you, and their cultural awareness, their cultural differences.
Right.
How you can think about contracts from their perspective.
Right.
A way to make our practice at least a little bit more accessible, but also to build competencies and professional formation around perspective taking.
Right. I think that does show up certainly in our discussion. And I confess this is the coverage question we'll talk about tomorrow. I tend to say, hard question, really, really important. What I want to do is just get you the basics of doctrine, and then we can worry about the other stuff. I think reasonable minds can differ about whether that should be all through, and it might be some professors will weave it all through and others won't. I've been just given the red light, like when you're doing stand up and the light goes on. So thank you. And I'm so happy to answer any questions you want.
All right, welcome back, everyone. My name is Mariah Glinsky. I'm a 3L here, and I'm one of the senior editors on the journal, and I have the honor of introducing our next panel. Our first panel this afternoon will focus on professional responsibility through reflective journaling. We will hear from Professor Timothy Floyd with Mercer University School of Law, Professor Neil Hamilton from our own University of St. Thomas School of Law, and finally, Professor Sandra Simpson with Gonzaga University School of Law. I encourage you to review their accomplishments in the biography section of the symposium program. And each speaker will have 15 minutes for their respective presentations, followed by 15 minutes for Q&A at the end. So please join me in welcoming our next panel.
David bemoaned being right before lunch, but I'm not sure being right after lunch is a real improvement in time spot. But I'm still delighted to be here and great to see everyone. And I do have to add my word of thanks, but truth is my work and my life are just always enriched when I come to St. Thomas and do work with the Holleran Center. So thank you for this and for so many things over so many years now. Our panel is going to focus in particular on the professional responsibility course. Every school has one, whether they want to or not. Every law student takes the course, whether they want to or not. It's an accreditation standard. The truth is, the professional responsibility course ought to be a prime vehicle for professional identity formation. It is, keep it up. It's a course that's explicitly about the norms and values of the profession. Which is what the third apprenticeship in the Carnegie Report said identity is all about. But really, even more importantly than that, it's a course that's about our students. As opposed to thinking about law and arguments on behalf of their clients, they are analyzing law that applies to them directly, and their very livelihood might be at stake on how they learn it. So it's really a great vehicle for professional identity formation. And in my case, I've been teaching this course for longer than I care to admit. I've also been writing and speaking about professional identity, not always in those words, but for a very long time now. But I've got a confession to make. I do a lousy job of professional identity formation in the professional responsibility course. I have several good excuses, but I won't go down that road. The truth, though, is those of you that teach professional responsibility in the room, and I know we have several, you'll know what I'm talking about, and I know the students will resonate with this. My students want the course to prepare them for the multi-state professional responsibility exam. The course, the way I teach it, focuses very much on the ABA model rules of professional conduct, because that's what the test is about. They have to pass the test to be a lawyer. That's part of the formation of being a lawyer. If you don't pass that test, you don't become one. Early on when I taught this course, I loved moral philosophy and the big picture questions. I was not getting good evaluations in the course when we focused on that. But I have I started to use the verb surrender. That's not really right. I have accommodated my students where they are, Neil. They want to learn the model rules, and so I spend a lot of time getting them ready for the MPRE and focused on the model rules. After all, it's very important. They do need to know that. It turns out that doing multiple choice questions and short, simple problems are really a very effective way to teach the model rules. What is a lawyer required to do to avoid discipline? What is it a lawyer needs to avoid in order to keep from being disciplined? That's what the MPRE is about largely. That's a large part of what my course is about. But we spend time in my class on this case, Spalding versus Zimmerman. I think it's fair to say that probably a majority of the books, a majority of students who take professional responsibility, or at least exposed to this case or the factual scenario in this case is taught largely because it's about the duty of confidentiality and exceptions to confidentiality. It raises many other issues that we're not going to get into here today. What it is focused on, though, primarily in the books, is this. In a nutshell, for those of you that don't know it or don't remember it, the case, and it's a personal injury case. The young plaintiff, who was a minor at the time of the accident, files a lawsuit, got fairly serious injuries, but temporary, recover from them, it seems, according to his own doctor. Turns out the defense lawyers get a medical exam under Rule 35 of the plaintiff. They discover he has a life-threatening condition, an aneurysm that could burst at any moment. It's quite serious. His life is at stake. They don't tell the plaintiff about that. They settle the case for a much smaller amount than they probably would have had they told him about this. We'll talk about what happens in the case a little bit later, but it's taught primarily in law school classes about Rule 1.6, 1.6b1 in particular. Under these circumstances, could a lawyer reveal this to the other party even if the client didn't want to? It's about the rules. That's the way I've taught it a lot. But here's the thing about Rule 1.6b1 in particular here. The way the ABA model rule is written, a lawyer, the correct answer on the MPRE would be, under this factual scenario, a lawyer has discretion basically to breach confidentiality and to reveal. But the lawyer also has discretion not to. The rule doesn't require you to reveal. It doesn't require you not to reveal. It's up to the lawyer. But the lawyer has to make a decision in the real world. To pass the MPRE, you just have to know that I have discretion to choose one way or the other. Good, you pass. But if you face a situation like this in the real world, what you're dealing with is the duty to decide something. We use problems, I do, and I think most people, but if the problem is mainly about helping you understand cognitively what the rule is, it does tend to separate students from who they really are and the decisions they make and the consequences of those decisions. What we really need to do, I submit, if we're going to use problems, is enrich them. What we need to do is get them to see the people involved, get them to think of their own role in it. And so, this is just one example. The great Roger Crampton we've talked about wrote an article that became a book chapter where he did some deeper research into the facts of this case. A colleague of mine and I did some further research and actually found David Spalding, the named plaintiff in the case. Briefly, this is what the case is. It takes place in the 1950s. David Spalding was 20 years old. He was a student at University of North Dakota. He was home for the summer at the little town in northwestern Minnesota where he lived with his family. He was working on a road crew for somebody named Ed Zimmerman. The end of a hot working day in August, the 6 people, Ed Zimmerman, his 2 sons, David Spalding, his brother, a friend of theirs, piled into their cars. 1950s, it's no problem getting 6 big adults in the car. They start driving home. At the same time, there was another family from northwestern Minnesota, the Letterman family. They're a farm family. The parents and 4 children. 15-year-old Florian Letterman and his 3 younger siblings, they're going to the county fair. End of the workday, about 5:30, they pile in, 6 of them pile into the car. And the county fair, I mean, who doesn't? A lot of younger people don't really know, but at least at my age, I still have such fond memories of once a year. And man, it's that food that I really liked. Elaine Letterman was the 12-year-old daughter. She was going to show her prize cow there at the fair. That's part of what happens, right? As they are driving to the fair, as Ed Zimmerman is taking his crew, including David Spalding, home, they come to what probably should have been a 4-way stop. Turns out there wasn't a stop sign in either direction. At in excess of 50 miles an hour, both cars hit it at exactly the same time. And of the 12 people in the 2 cars, 2 died. Jack Zimmerman, the 19-year-old son of Ed Zimmerman, was driving. He died. And young Elaine Letterman died the next day of her injuries. But a lot of other people went to the hospital, including David Spalding, who was there in the hospital for 3 days, lost consciousness for about 24 hours. But it looked like he was going to recover. They didn't want to file a lawsuit, but they had medical bills. Talked to David about this, and that wasn't something you do. And in fact, a defendant would be his employer and their family friend, Ed Zimmerman, and this other family that had lost a daughter, but they had insurance. Okay, we can file a lawsuit and we'll get it settled. And they did. They did settle the case. And I think they got David's share was $6,000, which didn't quite pay. But by the time his lawyer got some and the medical bills, he didn't pocket anything, but that's what it was. But this is what during the pendency of the discovery part, the defense retained physician discovered the aneurysm, told the insurance defense lawyers about it. And it said it's very life-threatening. If this burst, you would die within a minute. You bleed out. And it was you could see it ballooning even on x-rays. 2 years after the accident, David Spalding was suffering pretty severe chest pains, and it was discovered, finally, his own doctors discovered this condition, rushed him to the emergency room. He ended up having surgery, and it saved his life. They repaired the aneurysm. Okay, that's good. But they also had to go in such a way that it permanently damaged his larynx, or the laryngeal nerve, I guess, there, so that he lost his voice largely. He had a very, very soft and very squeaky voice for the rest of his life as a result. At that point, they thought, this must have been something to do with the accident. So his earlier lawyer actually goes to see the doctor and says, the defense doctor, didn't you know about this? He says, well, yes, but my duty was to the insurance company. It wasn't my duty to tell you anything about it. But they moved to have it reopened. The trial judge actually reopened the settlement, and they settled it for more money. Not a lot more money, but some more money. Not on the grounds the defense lawyers did anything wrong, on the ground that David was a minor and the judge had extra responsibility to make sure that it was a fair settlement, and they had not informed the judge. Not that they didn't inform the plaintiff, that didn't matter, but the judge wasn't informed. The insurance company appealed it to the Minnesota Supreme Court, who affirmed, but went out of its way to say, we find that the defense lawyers did nothing wrong in this case, nothing unethical or in bad faith, that is. David Spalding himself, he was in school to become a high school teacher. He tried that the first year out, and he couldn't command a classroom. And he went on and got a master's degree, became a school counselor psychologist, and had a long career doing that. In my class, this is one place where I think I do it right. We use this as a reflective exercise, and we use many of the steps that David Thompson talked about. We use all 5 steps. And that's what we do, but we get the students to focus on what would you do, as opposed to, all right, I know the answer. I can either reveal or not. Okay, I'm good. No, you got to decide. If you don't decide, that's a decision. Inaction has consequences. We want our students to be prepared if they ever do face something that's difficult. And reflection on this case and their values can really make a difference. But you know, it's more than just deciding what you would do. You also have to decide how to go about it. I've become a big fan of the REST 4-component model for moral decision making. Some of you are familiar with it. But briefly, in addition to just understanding and seeing that there is an ethical issue, reasoning to a good solution, good moral action requires moral motivation, deciding I'm going to do the right thing and I'm not going to let other things like my self-interest get in the way. And it requires implementation, which can be the courage to do the right thing even in the midst of terrible consequences to you, or it can just require good judgment, wisdom about how to go about it. We have an exercise in which we get our students, after learning a good bit about what this case is about, to write reflections about what they would do in this case. And what we have them do is, first of all, remember there is inherent, really irreducible uncertainty. It's one thing to reflect back on what happened before, but when you're talking about the future, as Yogi Berra said, it's kind of difficult to predict. But you've got to play out in your mind what the possible scenarios are. One of the big issues in this case is, do you consult with your client, that is the insurer? Do you just talk about the insurance company who hired you? Well, the clear answer is you should consult with your clients, which the real lawyers didn't. But we want them, if you do that, how's that conversation going to go? Imagine that. What if your client says, no, it would cost me, don't tell him? How do you play out that scenario? Say what if at every step of the process. The most important thing here is reflection. And reflection is a skill, it's a habit. The more you train people to engage in good reflection, the more they will do it. And so journaling and reflection is just essential throughout law school, I'm convinced. And a lot of it is reflection on your own values, your own interests, your own goals, including your own self-interest. Recognize that there is tension between your duty to your client, your duty to the law, your just personal morality about somebody's life being at stake, and be aware of rationalizations. This is what we want our students to answer. We want them to be thinking all along the way, what kind of lawyer, what kind of person, what kind of lawyer as a person do you want to be? Thank you.
Well, I'm very grateful for all the presentations. One problem is that so many creative ideas here. I thought I had my summer worked out as to what I was going to do, but now I can see a lot of changes coming up in my approach to some of my PR course that many of these students have taken. Especially grateful, I thought Lindsay's discussion of team-based learning. I like team-based learning, but I thought she had some wonderful new models that I can look to. I'm going to build off David's point that professional identity formation is taking the high road, really trying to acculturate yourself that you're going to take the high road and not just the minimum rules compliance road. I mean, so that's a lifetime of work. You get better. I mean, if you're not getting better at it as you age and get experience, then you're not reflecting. To go to where Tim was, because as far as I can tell, the only way adults grow is reflection. If you know people who are not reflecting at all, they're pretty much stuck in their current position. So let me just run through some slides. And also, I use your Spalding v. Zimmerman, and I knew the one senior lawyer on the defense side back earlier. And I'm also building off Tim here. What's the coverage of the standard PR course? What curriculum do I add? What assessments am I using? And this is going to build off of a lot of what Tim Floyd just told you. Well, in 21-22, I did a survey of all law schools. About the significant majority are requiring a 3-credit. 20% 2-credit, 10% a 2 or 3. I think that the choice of the credits is, do you do a paper? That 3rd credit would be some sort of a paper. Small minority of other options. Vast majority require students to take the course in the 2L or 3L year. Here at St. Thomas, we are requiring it in the 2L year. That's with intention, because remember my earlier point, my last point in my talk this morning was you need a progression and a coordination. Well, PR in the 2L year is an ideal place for it, right? Especially in our environment, our culture, because you had moral reasoning, serving clients well, business basics, and PR would be a next step. Meanwhile, you've got mentor externship in there also. Standard PR course is what I would call, because I teach the capstone course in our ethics and compliance. We have a concentration, we have a degree program. Standard PR is a compliance course. It's just a straight compliance course. Every state except Wisconsin requires the grads to pass MPRE, 60 multiple choice, 2 hours, passing score is 60% correct. You know, so many things out of my control in life, but this is one of them. I mean, if that you pass 60% on a 60 question multiple choice and I'm going to certify you as ethical. Okay, well, let's move on, because some things we are not really making progress. But the goal, what then translates there is that the goal of significant number of students is to pass the MPRE. That's how they see my course. And any deviation that I make, it's into fuzzy baloney territory. You know, why, anyway, won't go into some of the comments you get on the student evaluations that they don't, also, and I don't know if we have good, I'm trying to find good data on this idea of reflection and the stage development that each adult goes through to go to reflection, because some people just don't like it. And my oldest brother's 10 years older than me, and he thinks it's all just navel gazing. And he'll say to me, I'm a man of action and you're a navel gazer. Okay. So there's a certain hostility to it among some people, which I think would be just interesting to know. I believe there's some stage development process that people go through here. But what's happening in a required course is that you'll have some subset of students who are skeptical about reflection. So my goal has been in recent times can I convince that subset in particular to understand it's highly in their enlightened self-interest to join all of us on this journey. So and how do I do that? Well, I'm 2 generations from you. So I think I've got this fall semester, 2L year, 60 to 75 students. I'm trying to reach that one. Why am I so focused on that? Because if I lose some students, I feel badly. You have to know, meaning on the student evaluation teaching, I see, oh, I lost some number, right? Meaning they just didn't want to go where I hoped they would go on reflection, is essentially what that means. Well, those of you that are teachers or have been teachers, I mean, you feel badly about that somehow I couldn't connect. So my most successful effort was this past fall. It's what I've discovered is, I can bring in Supreme Court justices, general counsel, CEOs who are lawyers, their 50s and their 60s. It's too many stages away from the students in the mid-20s. So the most credible people I've found are successful reflective alums about 3 to 15 years out. Successful, and I've been teaching a long time, and we have a lot of alums who are like that. A lot of your mentors are like that. So before the class begins, I survey the students on area of practice they're most interested in post-graduation, put them in teams of 4. Talking to Lindsay, she says better 5 or 6. I'll have to think that through. Select an alumni coach in the practice area for that team, each of the teams. First learning outcome for the course is you got to understand the rules. You got to pass that MPRE. But the second is, now here's taking the high road. You have to understand really what you want to do is live a life of purpose above the rules of professional conduct. I mean, there is a low floor. If at the end of the day, on the day of judgment, you say, well, Lord, I can tell you, I did not, no, at least nobody charged me with the professional responsibility rules. I mean, that's going to be a fairly modest achievement. So a sub-theme of the course is a lot of discretionary calls in the rules every day. You have to internalize this idea of dialogue and reflection, dialogue with others, especially experienced people and others, listen, reflect. And that's just a habit you're going to develop. I want to give you examples of many very successful alums of our school who are supporting their families and have taken the high road. So I want you to know that it's your choice, the road you're going to take. And if you take the lower road, just any practice area of any sort, ask people who are the jerks. And they know. I mean, the same names will come up. Who are the jerks? Who don't you trust? So that, I mean, I'm arguing. Actually, the best news I was one of the founding group here. The judges tell us we aren't seeing UST grads who are jerks. You know, I'm happy. I'm very proud of that, frankly, because there's a lot of jerks out there. So I mean, they're telling us, well, good going over there at UST. You're not bringing out jerks. Okay, 4 team graded essays. 30% of the final grade is based on the 4 essays. So the first essay is, and then here this goes to what Jerry and I talk a lot about. How do we help the students reflect on the experiences outside the building? Because a lot of what we're talking about here today is happening outside the building. So I ask, what are the most important lessons learned from your summer that you're just coming off of? Rank them in importance. What's the next step for each team member? Okay, well, I'll come back to this. I just want you to see the 4. Second essay is building relationships with clients. I can see, listening today, I can do some drop-in modules to bring the client in the classroom more than I have, but the team should talk to the coach. In each of these, the team is talking to the coach, getting the coach's experience. And then what are the team members observing? Third, on that one, I ask you to go back and look at the roadmap book, which all of our students do in the 1L year on building trust and relationships. Third essay is relationships with adversaries, litigation or transactional work. And what is the coach's experience? What are you seeing out there in your outside the building experiences or your clinics? And then the third one is, on the third one, what are in your negotiation course, your mediation course, conflict resolution course, what norms are you seeing there? And then this fourth essay, and so this is where I get some pushback from some students. I'm asking you to think through what tradition did you bring to us on the question of what are your responsibilities to others. And I'll talk to you a little about that data set because I have about 7 years of data on that. What faith or what philosophical tradition, either a faith tradition or secular tradition, do you bring? And essentially you can see what's happening here is that we, the school and the profession, are asking you to internalize the core values of the profession into the values that you brought here when you walked in here. And again, that happens over a lifetime. So let me just give you a sense of, I have a lot of data over there that I thought, well, a presentation with too much data is numbing, but just a couple of things. On that first one, most important lessons learned from summer, helping you grow from being a student to a lawyer. So this is my last fall's class. The number one, this is 21 data and 22. Number one is just variety of organizational skills, time management, project management, and total reliability. That comes up most often from your summer. Second, versions of interacting productively with the experienced attorneys giving you the work. See, essentially what's happening is the experienced attorney is your client in many ways. and giving you the work, and you're trying to figure out, and this would be a teamwork type of, or a cooperation with them. So in the ideal world, you're asking, as you would with a client, what helps them be successful, and you're meeting their needs. You stop being a student, because a student is passive, doing what is asked, but then you go proactive into, well, what does this person need? How can I help them beyond just technical? And I couldn't keep it going. On building trust with clients, the teams in both years, most strongly active listening. Active listening is really the heart of understanding the other person. On the third one, major themes on norms that guide lawyers in their relationships with adversaries. And this fits with some earlier presentations. Respectful, courteous behavior towards adversaries helps the client, contributes to solutions. And actually what goes around comes around. That came up earlier, right? I mean, if you're a jerk, you're just inciting jerk. But if you ante up, most, really vast majority of people are going to act respectfully and not go the low road anyway. And the last one, you know, we basically, out of 454 total students over the years, I didn't do the percentages, but a faith tradition, Catholic, Christianity generally, is going to be about 45% of our students go there. And then close, golden rule, platinum rule, and then some form of utilitarianism. And then in most recent years, this ethic of deep care, empathy for others, understanding of others. It's not, I don't have any specific tradition for that. I would call love of neighbor in secular words lived out, right? Deep care for others is your ethic. And obviously there are many sources you could turn to for that tradition. Virtue ethics is next, and so forth. I mean, the funniest one was a couple of years ago, I got a paper and the student said, I am in the wing it tradition, the wing it tradition. I thought that was a very creative, I'm making it up as I go, I think is how that one works. Anyway, thank you very, very much.
Is this yours? This feels very much like, may it please the court. So as I was introduced, I'm Sandra Simpson, I'm from Gonzaga. I do not teach PR. I think Jerry probably said, just put her in that group, she'll be fine. I have taught PR, but I currently teach civil procedure, real estate, and legal research and writing. I feel a little humbled to be up here with these giants. They are, in my last slide, their books are things that I use and that I've read. And I was at the table with Daisy and Tim, and I was like, wait, you guys wrote that book? And so that was my realization. As I sat here today, I was thinking, someone else had mentioned that the first panel was the end game, and I was thinking that, like, wow, my presentation is really about the small things that you can start to do. And so I was feeling a little intimidated, but hopefully it'll speak to you that these are little things that I'm starting to do in my class. I'm starting to I feel like it allows for the mentorship and opening the door, just a peek into forming your professional identity. As I mentioned earlier, I'm in charge of curriculum coordination and reform at Gonzaga, and I'm not only honored, but I'm completely terrified by this job because I feel like my role is so important as the students in creating their curriculum. So we've all talked about this, but I thought for the students in the room, they might want to know that we're talking about this because it's important, and the ABA has finally said it is important and that we have to put it into our curriculum. And I thought it was interesting what what David said when he was up earlier, and it reminded me, because he was saying you can't teach identity formation. You can't teach that. And it reminded me of a parable I think my father told at some point as I was growing up, that teachers are shepherds. We provide the grass for the people for the sheep to feed. We make sure they get food, we make sure they get water, and we protect them from wolves, but we don't turn them into dogs. Like a sheep is not ever going to be a dog. It's always going to be a sheep. So I felt like that when David was talking that, yeah, we can't change anyone's professional identity. We can only help to form that and to give them that space and the opportunity to think about it. So some examples of identity formation subjects that I started to look at for purposes of deciding what I was going to incorporate into my civil procedure class was mental health and well-being, identifying core values, self-regulation, being a good employee, communication, collaboration, team building, things that we've really talked about today. And it occurred to me that there's a couple ways we can go about this as schools. Well, we can have a course, and people have talked about those courses, and LSAC and others have courses ready to go. You can look them up on their website. You can download their slides. And then we also can reflect across the curriculum, or we can do both. So across the curriculum, I looked at both of these, and I'm looking at it for Gonzaga, what should we do? And I think that there's some consistency, there's some good and bad at both. I think that across the curriculum, if it's that, it allows that, it allows that consistency. It's better if it's just one course because you have better control over the presentation of materials. But again, we can't teach professional identity formation. We can provide the space for it. And so I think if we do reflections in a doctrinal course, I also teach skills courses. And so I know the difference that students see about skills courses versus their casebook courses. So I think when we do these types of skills-based in a doctrinal class, it lends some credibility to that. So one way is we could do the reflections in the 1L doctrinal course, and we can continue those through our 2L and 3L years and culminate in a portfolio. And that's what Gonzaga is leaning toward. The other way, which is what I've done in my classroom, is I'm doing reflections in my casebook courses. And I think it connects their old experiences with their new experiences and gives meaning to that student experience. So here's some reflection skills that I work on that build confidence, resilience, management skills, lifelong learning, and self-regulation skills. And E. Scott Fruwald is one of my, an author that I use a lot, and he lists these 10 ways of thinking about professional formation. And so I highlighted the 4 that I use in civil procedure. So let's walk through that. Oh, sorry, gotta go back. Example questions, I base them on the individual professional identity, becoming a self-regulated lawyer, attorney well-being, and my role, their role in the legal profession. My reflection questions are designed to glean this professional healthy identity, and they're often tacked onto and included with when we talk about many of our cases. I have gotten some great ideas today, like that QR code thing, I gotta do that. That's amazing. Because I just use note cards, really old school. I have so many note cards, and when I bring them into class, the students are like, yes, we get to, and the other thing I use are those big 3M note things that we can stick on the wall. And my favorite thing is my students love to color. So whenever we have like a project, I'll like have them draw a house in real estate, or, just draw for me this boundary dispute. They often argue about what color they get of markers. So now they all get black because otherwise they spend 3 of their minutes arguing who gets the green one versus the orange one. So I use note cards because it's simple and really inexpensive for them to reflect and to write on. So here are some questions that I incorporate through civil procedure, and I call them my growing up questions. And I thank Scott Fruwald for these questions. Now, how did you handle problems in elementary school? So what I want to take a moment just to think about that. When you were in elementary school, how did you handle problems? You don't need to share. I'm not going to cold call anyone. I'm going to give you a second to think about that. Now, when you got to high school, how did you handle problems? And how was that different? Did you handle them a little bit differently? So think about that for 10 seconds. Okay, now how did you handle problems in college? And then I ask my students, how do you plan on handling problems in law school? And then how do you plan on handling problems in the profession? And I think as a parent, I've watched my kids move through this, and then I've thought about it. And for me, it was always mentors that helped me solve problems. It might have been my parents, it might have been peers, but it eventually got to be more me. Like I had to solve that problem and I had to think about that, but I was still using my mentors. I had to step out of the lunch thing because my son was calling. He never calls me. He's a sophomore in college. I thought, uh-oh, what happened? It was actually good, but it's either good or bad when he calls me. There's nothing in between. So I think I have them think about this because that helps them to connect their past to what they're going to do in the future. So the second thing, this is the professional identity continued series that I have. I often ask them, what's your biggest mistake you made in college? I can tell you exactly what my biggest mistake was in college. I'm not going to tell it to you, but well, all right, I could. I always tell my students, I'm not going to tell them, and they go, oh, tell us. So when I was in college and I was not good at math, shocker that I was not good at math, which is why I became an attorney. And I thought about cheating because I had all these formulas to memorize and I was not good at that. Turns out I'm pretty good at memorizing, but I didn't know it then. And so I almost cheated. Like I almost did, like I had the cheat sheet and I took it and I was about to enter the classroom and I couldn't do it. So maybe it wasn't my biggest mistake, but it was my biggest lesson, because I just couldn't do it. I thought there's no way, because if I get caught, that's going to change the trajectory of my life. So I had that thought moving into that class. So we talk about that. I let them share if they want to share, but typically they don't. Then I also ask them, did you seek feedback from your professors, and why or why not? I often ask this around midterms. I want to know, why are you not coming to see professors? I do collect these cards, but it's anonymous so that I can see, like, is there something that I can do that can help that? Do you go above and beyond what's expected, or do you just sneak by? I like them to talk about that, to think about that. Think about the professor you respected and what qualities did you respect about that person. Think about professors you didn't respect and what qualities didn't you respect about that person. And the last one's one of my favorites. Did you take charge of your education, and why or why not? So I like them to think about those things, and I like to hear them myself because I think that helps. And then I address it usually the next day. We talk about that. Okay, so here's now where I am today, a group of questions. How do I solve moral dilemmas? I think we've talked about that. Do I think about how my actions affect others? What's the most important value? So I won't go through them all, but these are some of the questions that we ask. And I have reflection day at least once a week, sometimes twice. So here's how I've connected it to the class itself. If anyone has taken civil procedure, I think everyone in this room probably has. Ashcroft versus Iqbal is a very difficult case to teach. It's a very impactful case. And so before we get into Iqbal, I ask my students to write down how the values of your generation differ from your parents' generation. And why do you think those differences exist? And we have a long discussion about that. What are the differences? We also talk about, write down how your values would be different if you were a member of a different gender or a different class or a different race. And we have pretty open conversations about that. And then the last thing I talk about is, what is your personal moral code and how did it develop? And those are some really sticky questions to ask. And I do ask my students to really be hard on themselves and really think about things like, why has it developed the way it has? And by the way, when the first time I taught Iqbal, it did not go well. And I thought that my students asked me so many questions I didn't know the answers to, which is normal. A lot of times they ask great questions, I don't know the answers. And so I went back to my office and I figured out the lawyer on the case, and I sent him an email. And he was now at Cardozo teaching, and I thought, he's never gonna write me back. Man, that guy wrote, and he wrote a whole page response. And then he said, I'd zoom into your class and teach your class about Iqbal. I thought, So he did, and he has every year since, and my students, it's the most, every time I ask them what's the most impactful thing we did in class, that's it. I'm like, great. When I wasn't there, that was the most impactful thing. But he gets all into he brings Iqbal to life, and it's amazing. So then, again, if you've studied civil procedure, you've probably read the Ford Motor case, and it has a lot to do with businesses and what we should be doing as a government. And so I ask my students to reflect on the role of courts in our society and what should that role be, not just what it is, but what should that role be, and how paternalistic should our court system be, and how much should the court regulator control businesses. I often put into that, how many people do you know in your life that's owned a business? What do you think it would be like to own a business? What do you think it would be like to own a business and have the government control anything that you're doing and the livelihood? So I try to talk a lot about the cases and try to connect them to their professional identity. And the last thing, these are just general category. I often ask my students, aggressive or assertive? Do you know the difference? Tell me what it is. And I usually follow up, do you think that's gender related? Is aggressive or assertive, is that a gender related subject or topic? And then, are you the person today that you want to be? Why or why not? How can you get there? Ethics versus integrity. Do you know the difference? And then we do talk about that after they reflect it and I've read their answers. We do talk about that in class. I think, and here are my resources, very, very small, the resources aren't very small, but the print is really small. And like I said, I was honored to be here, and I was honored to be on this panel with the bigs of this department. And thanks.
Thank you all for your presentation. I think this is really important. As a student, I just had a question. So I wanted to know what your strategies are for helping students understand the why behind these reflections, just so that we don't see it as busy work and we see it as something really valuable for our education.
I think that is actually one of the hardest parts of this, and I think some of the stuff that Lindsay brought up, team-based learning, so you try to get them to buy in by saying, this is a skill you need. And so sometimes I use data from that the IAALS study about self-direction and self-reflection and how important that is. And I think Neil's point that you got to see the students who do think it's busy work, and that makes me sad, right? So I do try to inculcate that. I do it. I reflect. So I try to model that as something. I feel like I went through law school not doing any of this, and I did not have a very good first 5 years of lawyering because I had no mentors and I did not understand what I was doing, and I didn't know how to be a healthy person myself. So I do share a lot of my own, probably an overshare, but I do share a lot of my own experiences to help with that.
Well, that's my strategy. It's a great question. That's my strategy would be alums learn much closer to yours. They're only a few years out. And they are saying, I think I've had a number of you in class, I think your alums are saying reflection is, well, actually, how do you get better as a lawyer? Just the technical skills of being a lawyer without feedback reflection loops. I mean, you do things, you got to get senior people to give you feedback, you have to reflect on it, action plan, let's get better. So I think that's affirming. Clearly the data I got from this last class is that they really like the coaches. I had nobody who was angry with me because we did coaches, so that was good. So the vast majority of the students were giving me that the coaches in particular were a valuable piece of my class. I'm still working on it. I mean, I need ideas, so if some of you have better ideas than what I've got, I'm am open.
So I have a question. It's been sort of like, I've been thinking about it since the presentations this morning and then Sandra's reference to Iqbal. And I'm wondering, it's a difficult question to ask, if by well-intentioned development of professional identity, which we sort of define as making people comfortable and think about how they fit in and they sort of comport with the norms of the profession, is actually buttressing the systemic racist nature of the profession. And what I mean by that is a lot of these norms that we rejoice or that we celebrate, like civility, for example, is a very different norm if you're a white male than if you are a person of color, because people of color see civility as a way of making sure nothing ever changes. And then we have these expressions like, are you a jerk or are you not a jerk, right? Well, to me, jerk and maverick is the difference between welfare and farm subsidy. So I'm wondering if by trying to get our students to conform and excel in the world of law as it is now, and by showing examples of people of color fitting into this norm, we are accidentally reinforcing a norm that we should be making much more unstable than it is.
Oh, that's a wonderful question and a powerful critique of the whole professional identity formation movement. And I've struggled with that question myself for a long time. In addition to teaching professional responsibility, I teach the first year criminal law course, and I don't think there's any course in the curriculum that reveals the systemic racism at the heart of our system than criminal law. It's there everywhere. But I guess what I would say right at the outset is I reject the word conform. That's certainly not what I have in mind when I'm talking about cultivating their professional identity. We're not trying to indoctrinate them or to move them in a certain direction. There are some fundamental values about respect and dignity and equality that I think are non-negotiable. And so I do think we do need to be normative, and there's nothing wrong with that, but we do need to be very sensitive to the way that language can be heard differently, that concepts are experienced differently by different people. I think the best way to do that is to be very transparent and explicit. And so in criminal law, when we're dealing with self-defense, or particularly if we're dealing with, the defense of force by law enforcement, I mean, how could you possibly talk about that without spending a good bit of time talking about you can't even say all their names anymore because there's so many people who have been the victims that finally coming into consciousness, but transparency and just being very upfront. And I get accused also of sharing more than I should, but I talk about myself, I talk about what I feel about things in a way, I hope, that doesn't come across that I want you to feel and believe the same things I do. I'm trying to model that we all need to be thinking and reflecting about these issues, as opposed to, oh well, those are not part of what law school is about. I think they need to be at the heart of law school, but reflection on who you're becoming, who you're going to be as a lawyer, in some ways is one of the best ways to get at that. That's my view anyway.
Well, it's a wonderful question worth a lot of reflection, but I thought David, in his earlier remarks, talked about professionalism versus professional identity formation. So, for decades, I was very active in the professionalism movement, and a lot of it ended up with the civility, no Rambo tactics, right? I see your point that that's overlap into how, because I'm asking my students to talk to coaches about, say, norms of negotiation and who are jerks. I get your point that could end up disadvantaging people who are taking on the system in a very direct way. I get that. The two main points for professional identity formation, though, are internalization of deep responsibilities to others, especially the client, but also in widening circles, the profession, the rule of law. And then the second one is taking ownership over your own development so that you grow towards excellence at the skills needed to serve well. Those are two norms. Those are two norm claims, but they do cross all the professions. That was the Carnegie studies found that all the professions have those two basic norms. I'll leave it there.
I think it is a really good question. And I think in my reflection on not only the question, but on the teaching of civil procedure, I think it came up earlier that civil procedure is meant to level the playing field. It's not just a group of rules. It's meant to, but does it? And we talk a lot that for whom does it level the playing field? And it doesn't level the playing field for everyone. And access to justice, which is connected to what you're talking about. So I try in some of my questions, which aren't up here, to talk about that, so students to reflect about to whom does this level the playing field? Because I do think the lawyers we're training today have a lot to take on. And one of them is that, we can no longer and should never have accepted it as is, the system as is. And I think every professor has the job to do that. And I think people approach civil procedure, it's just a bunch of rules. Actually, we can have lots of really deep discussions about civil procedure and race and equity.
You do it in every course.
Well, that's what I mean.
And
It should be
probably
across and it should be done across the curriculum.
I think I'm going back to the students' question, but this also addresses Rory's question as well, is that I think some students feel like reflection is busy work because, well, first of all, some students don't like written reflection. It's like keeping a diary, and that's for 13-year-old girls. And so you get some cultural pushback on that. So I try to really emphasize to my students that there are lots of ways to reflect. This is a way that you can communicate with me, right, and get some feedback, is in written reflection, but you can talk with each other. That's reflection too. You can sit and just think, and that's reflection too. But the idea isn't the product, it isn't the way you do it, it's that you do it. And then the second thing is, the other part about reflection in dialogue is that it gets at these kinds of the differences among us, because we have to integrate our professional identity into our many, many, many different identities. And so there's tension there. Some of us fit real nice and easily into, that journey to a professional identity is much easier for some of us than for others. But we can help each other, and we can appreciate the different ways that one can be a professional through dialogue. And so I think that when we go back to Neil's first presentation, it's not just reflection, it's guided reflection. And we don't have to be the ones guiding it. The students can guide themselves, they can guide each other. And so I think if we think of reflection as more than just the reflective essay as a writing exercise, and more as a skill that we're trying to inculcate, and we talk to students about this as a skill that good lawyers use. And no, they don't all keep a diary. It's okay. Sometimes, but go to any professional conference and listen to what lawyers talk about, over lunch and in the bar and stuff. What's going on in those conversations? Reflection and dialogue. And why do they do that? Because it keeps them sane. It makes them better lawyers. It helps them to understand different perspectives. So that's how I address that question. But I still have students tell me that it's busy work, so.
If I could follow up on that, first to thank you, Barbara. I've learned a lot about reflection from you, and your professional responsibility book has excellent reflective prompts for reflective writing, but they are also excellent prompts for discussion, which is your point. We cover actually the issues in the Spalding case in a separate course we have at our school that I didn't mention. We have the great luxury at my school of having a 3-hour required course in the first year just on professional identity formation. And then when I teach professional responsibility in the upper level curriculum, I can sort of assume they've already been through a lot of that and they're reflected on professional norms and their own identity. But a central part of the exercise we do on Spalding versus Zimmerman is students discuss that among themselves, and that's the richest part of all. And students learn so much from each other in that. And they do see the diversity of viewpoints, and we often ask them afterwards to reflect on that, or how did your mind change after you talk to other people? And it's always gratifying to see how open they are to changing their mind after a good open discussion about that. But thank you.
All right, so this is going to wrap up this session.
Actually, Jerry, let me have 60 seconds. You can have 60 after that. That's all right.
I'm going to yield 60 seconds to the young man from Georgia.
This is on behalf of our co-sponsor, West Academic. This book, which was referenced, and it's about 3 people long and Floyd. It's called The Formation of Professional Identity: Path from Student to Lawyer. There are free copies of that, and there's still a lot of them out there on the table. So take one. It's not a West book, but it will be soon. This is the first edition by the wrong publisher, but the second edition is coming soon from West Academic. And it's a good book if you want to have a standalone course on professional identity. I think that's why we wrote it. That's how we use it. But it could also be an excellent supplement in any other course you want to do that in. So thank you. And thanks to West Academic.
So I'm going to take host facilitator's privilege. Rory, I think your question is a question that we all have to just live with, right, on an ongoing basis. And when I say all, I really mean all. So here's how I've had this conversation with a number of our students, and and there's not a right answer, I don't think, right? So I look at this functionally. We're being trained to be advocates. Advocates have to be persuasive to an audience they don't get to choose, right? And so there's a question each of us has to embrace on how much of me am I going to bring forward if I think that may not be received by the audience I'm trying to persuade, right? And that's just a challenge, right? And part of that is, if it's an audience I'm going to be with for a while, I might do that incrementally so that I build their trust and then they're ready to accept who I am and I can be more fully myself. But that's just I think that's just an embedded dilemma that we all have to deal with, right? When we're talking to an audience that might not fully accept our full self if we blossom fully in front of them, then to some extent, we have to make a choice to suppress some of that to be persuasive to that audience. And all I can do is describe that reality. I can't prescribe how to solve it. I can just describe it, right? We have a 15-minute break, and I'm going to give you the full 15 minutes. I thought we might have water, but I have no idea where it is yet. So if I find it, I'll bring it here. But for now, plan on being back here at 2:40. I'm going to say it's a 13-minute break, 2:48.
Good afternoon. My name is TJ Bowman. I'm an associate editor with the St. Thomas Law Journal, and I'm a 2L here at St. Thomas. And I have the luxury and the pleasure of introducing our second panel of the afternoon. So our second panel this afternoon will focus on professional identity formation through teaching values, leadership, and wellness. We will hear first from a contingent from Baylor University School of Law, Dean Stephen Rispoli, Professor Leah Jackson-Teague, and Professor Elizabeth Fraley, followed by Professor Kenneth Townsend with Wake Forest University School of Law, and finally Professor Andrelli St. Val with the University of Pittsburgh School of Law. I highly encourage you to look at their credentials in the program. And our friends from Baylor and our 2 other speakers will have 15 minutes for the respective presentations, followed by a 15-minute period at the end of the hour for a Q&A discussion. So please give it up for our second panel.
Well, 3 have become 2. Our colleague Liz Fraley, weather got her, DFW, well known for its difficulties in travel. She did not make it here today. So Stephen and I are going to be, I'm just going to apologize. Liz Fraley is our show pony. So we trot her out. She puts this, whatever we need her to put together, she puts it together, wraps it up in a bow, and does a beautiful job. So I hate that you are not going to have the pleasure of meeting her, but we're going to carry on. Stephen and I and Liz, we come at professional identity formation with a leadership perspective. Lots of conversation can occur and has occurred over the last 10 years about how do those two things fit together. We know they fit very nicely. And what we will tell you is any well-developed leadership development program has all the elements of professional identity formation built in as a foundation, and then to begin to introduce the lawyer as the leader. And we all know lawyers are leaders. So that is who we are. That's the perspective that we bring to you. We're going to cover sort of 3 areas from Baylor Law School perspective, and to make this fit very nicely into this incredible program today. Thank you, Neil, Jerry, all of the law review. Again, y'all are just, I always come away so inspired at everything the Holleran Center does. So thank you, thank you. We love that you're focusing on doctrinal classes. So we decided to bring to you an introduction, and this is why we're going to miss Liz greatly, an introduction to a part of our program that is very unique. Our practice court program. It is a capstone. It is a 3rd year, very intense, and we need clicker help again. Very intense 3rd year. It's a capstone. It is designed to take students to prepare them for the practice of law. So as the Carnegie, as we all go back to, we are supposed to help our students not only think like lawyers, but to have skill training to be lawyers, and then professional identity. How do you actually accept, own that responsibility of being a professional? Our practice court program wraps that all up in a very intense 6 months. The first 3 months are an immersion into, they do nothing but this practice court experience. We actually we put professional responsibility in there as well, so it all becomes a package. And during that time, they are working so very hard. They are in class all morning, 7:45 to noon with a short break. And it's intense, lots of reading the night before, and if they're not prepared, there are memos to do on top of the reading for the next day. So it is a very intense, obviously very required course. And then they begin to introduce the skills building in the afternoons. It's trial advocacy is the subject matter. So they're doing procedure and evidence. Truthfully, you could take any other subject matter, because the greater, larger purpose of our practice court program is not to produce trial lawyers. Only half of our alums do trial work, but it's to give them that experience, that immersion, and for it to be intense, for it to go deep, not broad and shallow, go deep into a subject matter, and then to do it in a very experiential way. It's all simulation, so we can control what's happening in the courtrooms. They start with opening statements, they go to direct and cross, they do full-on trials in pairs, so there's team building. So what are the extra benefits of our practice court program? Obviously, it's advocacy. So as mentioned here today, all lawyers, we're advocates. Regardless of the practice area, we're advocates. So absolutely, they're learning advocacy. They're learning to work well with others. So time management, stress management, conflict management, conflict resolution, communication skills. And for me, one of the biggest benefits of our program was building my confidence. I didn't think I could do that. I was forced into it, and I found, okay, no, I can do this, and I can do it, and I can do it well. Responsibility, emotional intelligence, work ethic, all of those things are things that are really important as the practice court program. And then we get to the hidden curriculum.
The hidden curriculum of practice court, and we've got a few up on the screen, but practice court has been around for over 100 years, and it is every Baylor lawyer living has been through practice court. And so the what you see on the screen about what we teach, procedure, evidence, trial advocacy, that's what every student knew that they were getting. What they didn't know that they were getting for decades was the grit, the growth mindset, resilience, how to fail gracefully, how to work well with team members, how to manage stress and the tribulations of a trial practice while in law school. Those were all things that they were learning that they didn't necessarily, nobody said that that's what they were learning. So in the last few years, we started to work that in. Professor Fraley gives specific afternoon discussions. They're not just lectures, there is discussion-based. There are some experiential components where they are, discussing these facets of the curriculum with their colleagues. But the point is, we really want to drive home, why are we doing this? And so while practice court has been grounded in these substantive topics, it could really be anything. And so we bring this to you all as a sort of charge for the rigorous courses can allow for some of these concepts to be discussed and for these things to be experienced by students and to help them learn these skills now before they get into the practice of law. There is also an emphasis on professionalism and civility. I think so many people have seen trial lawyers on television that they expect that that's what they are supposed to be when they get out. And in practice court, what we really help students figure out is who they are as lawyers. I will admit that when I I went to Baylor on undergrad and law school. And so when I was in PC, I tried to figure out who am I as a lawyer, and I emulated the professors that I saw. And that wasn't right. I realized later that what they were trying to do is trying to show me how do I mold what they're modeling and layer it onto my own personality and my own strengths and my own values to be an authentic lawyer, and that how that connects best with the jury or with any other group that you're trying to persuade as an advocate. So that's what we started doing with our PC program, is explaining more of that more intentionally. The PC professors have lectures on grit, on growth mindset, resilience, those topics and how they fit into the course, but then they also bring in a group of lawyers. And so the ABOTA, the American Board of Trial Advocates, is a pretty famously neutral group of high-profile plaintiffs and defense lawyers that come to talk to the students about how to be a good advocate and how to do it while being respectful and showing dignity to the other side. You can still be a very, very tough trial lawyer, but be kind and smile. There are also times when you can give accommodations to the other side, and you should, and there are times when you can't, and how to figure that out. The advocacy exercises. The advocacy exercises that Professor Teague mentioned, they're experienced trial lawyers in the corner of the room that are either tenured professors or Jaworski fellows that are advising law students on their trial skills. But they're also showing them how to do it. And they're showing them how to do it the right way, how to persuade the jury, how to bring the right argument at the right time for the right reasons in order to carry that. Professionalism evaluations. This culminates, and they're told this at the beginning of the course, but this culminates in professionalism evaluations. Every juror is going to be evaluating the lawyers. The judges will be evaluating the lawyers will be evaluating each other, and they'll also be evaluating their partner. So it's kind of a 360-degree professionalism evaluation of how did they do in that setting. We also talk about wellness in the profession. I have gotten comments like this. I know for a fact that we will never have to work this hard in practice. Get those comments. I've also gotten comments such as, you are making this so hard that it's affecting our mental health. Law students, and so for the law students in the room, I'm not saying this about any of you, but there are law students that will come to me and say that. But they don't believe me when I say that the practice of law is hard and that holding your client's problems as your own is hard. That the work that you're going to have to put in is hard, that the hours are long. When the brief is due Monday and the partner calls you on Friday and says, hey, we need to get this done, the expectation is that you're in the office to do it. but law students don't believe us. So we bring in experienced trial lawyers to talk about the realities of the profession, ways to make it better, but we do try to set those expectations early on. We also have lots of skills training. In practice court, even though it is tough, Professor Fraley has an exercise log that if the students do enough exercise, go do their exercises, go for a walk, go to the gym, do whatever it is and bring that in, they get immunity from being called on one day. And in practice court, that's a big deal because it's a 2-hour class. And if you get called on, you don't get it right, you get kicked out and you have a memo and you're going to be called on the next day. So there's a lot to having freedom to say, can't call on me today. But we talk about those skills. And so then there are also presentations about healthy eating, healthy exercise routines, how to deal with stress and how to deal with stress in a healthy way so that students are learning it now and not having to deal with it for the first time in a stressful trial practice where it's not just time pressure and workload. Now you have a real client with a real issue that needs to be solved.
Okay, so how are we able to ask that much of our students in the third year? How are we able to do all that we ask them to do all 3 years? Well, we do that by being very intentional about setting a culture of expectations. So professionalism means expectations. And what do we mean by that? It means that there will be work, there will be a lot of times that ahead of you. So we start in orientation because we want to begin with the end in mind. We want to set those expectations for what is that we want them to be able to do. And we're going to preview all the demands that are going to be on them. And as we're doing that, we are giving a lot of emphasis to this concept of professionalism. You will treat your classmates, you will treat your professors with respect. We will be part of a team, all of us. We're part of this legal profession. It's a service profession. Keep in mind the why. Why are we doing this? It's all about service to our clients. Wellness is also very intentionally emphasized in the very beginning. We don't end there. We know that you cannot just say it at the beginning because they're not going to remember it. And we can't expect it at the end if we haven't also said it at the beginning and all the way through. So in the first year, we have a series of lectures, required lectures, so much is required at Baylor, where we're introducing them to the lawyer as, the role of lawyers. So the lawyer as protector of the rule of law, the lawyer as public servant, the lawyer as an instrument for social change, the lawyer as leader. We want them to set the expectations that they will understand the responsibility, the various roles that lawyers play, and that they will own that responsibility. And then that will allow us to work with them all 3 years to prepare them not only to think like lawyers, but to do the lawyering skills that will be expected of them to represent clients. But then really importantly to us and to everyone in this room, how do you then accept that responsibility that we all have, not just to clients, but to the higher, greater justice system of rule of law, all those things that are part of who we own. And we go back to the very preamble of the model rules. It tells us those things. It's more than just representing a client. So as we extend into the orientation, if you go a couple clicks, we do those things through what we call an intro to law class. We have just last year introduced, it's civil discourse training, but it's different. It's public deliberation training. We do that in the second week of law school for every entering student so that they can have a conversation that is civil, that is respectful. And there's no intention of getting to an agreement. It's how do we do this? And it's a skill set that we don't want our students to then take out into their community so that they are serving. They can also facilitate conversations that will lead to understanding. We're not trying to get to agreement. We're just trying to get to some sort of sense of understanding through that program. Then we reinforce all of that throughout law school by doing all we can to work with our colleagues to incorporate some of this. Love these great ideas. We're going to take back them and share them. But then we have a required professional development program, which is like CLE hours. Just you have choices, but in 3 years, you've got 18 credits Nope, 21 credits. 21 credits you have to get, and we give them all sorts of options. Wellness is part of that, leadership is part of that, diversity, equity, and inclusion is part of that, along with skills building, and then just what is it like to practice in a particular area. And then Stephen and I created a leadership development program, and that program, we do have a leadership class where we have such fun in incorporating all of this into it. We have a leadership fellows program to train up some of our specific students, but really our purpose is to support all of these concepts all the way through the curriculum. What else? Is that it?
That's it.
All right,
Thank
we're
you.
done, right on time.
All right, so we're clicking with the mouse. Is that what we're doing here? All right, so as my slides get put up here, I assume, by someone, let me say thank you. Thank you to everybody. This is an absolute treat to be here. I'm feeling really energized. I don't know about y'all, but I don't feel like on a daily basis I get to have these kinds of conversations. So it's a pleasure to be with folks here. So thanks Holleran Center, thanks Wes, thanks to everybody here for making this possible. And there we go. I see Townsend. There we go. Perfect. Or I saw it briefly. This gives us a time to stretch, maybe, right? That afternoon stretch time. Or I don't have anything to clean, but maybe I could clean something like Jerry did earlier.
Okay, well, let me take 10 seconds.
Okay, great.
I was supposed to tell you what we handed out to you. This is our work in progress. This is how we are trying to be reflective and guide our students all the way through law school. So I can talk about that later if anybody has any questions, but that was what we handed out to you.
Great. All right. Looks like my slides are up there now. So again, thanks to everybody for being here. And so this is what we're using. Let's see. Yeah, look at there. Why are we here? We know at least one of the reasons why we're here. 303B, as has been discussed a few times, this is not new information for anybody in this room, but it is a reminder that this conversation is spreading out into new contexts. And I think that's really good for many of us here today. We have to think about this. We have to do this. But why else are we here? I'm preaching to the choir, I know, so I'll go through this kind of quickly. Anytime I'm given a platform, I like to start with some of these why questions. This has been a theme today, right? Keeping a sense of your why, your purpose, and so forth. I think we need to do the same thing. Why are we here? We look around, we see low and declining levels of social trust in our world. This is something that came up, a theme in the Baylor presentation just now. Lawyers assume roles of leadership and work in society, but we're not always intentional about preparing law students to become leaders. We recognize that lawyers in legal institutions have, not always, but at least sometimes, a justified bad reputation. Well-being has been a persistent theme today, and there's more, unfortunately, depressing evidence that lawyers and law students are experiencing not great well-being outcomes. And so we in law schools and legal employers, I think we have an opportunity and an obligation to do something. So this is why else we're here. We also have, this hasn't come up a lot, but anytime over the last 2 months that I've talked, I bring this up because I think this is going to shake up everything in ways that we can't even fully appreciate. Right? Things are changing. Technology is rapidly changing the landscape of legal education and of law practice. And we don't even know what all that's going to mean. But I do think, at least one thing that it means, is we need to be more attentive to the broad ways in which we prepare lawyers. We are not simply preparing fancy law computing machines. We need to be attentive to the ways in which lawyers can continue to distinguish themselves, even with extremely rapid advances in technology. So in sum, we see that not all is right in legal education or in the legal profession, and we want to be creative in thinking about alternatives. So I'm here to talk largely about a character-based approach to professional leadership and character-based approach. I'm going to lean a little bit more on the character-based part of it today, character-based approach to professional identity formation. And I'm going to run through some of these justifications somewhat quickly, but I'm happy to talk more with any of you after. So why a character-based approach to professional identity formation? First, this isn't meant to exclude other approaches. We've heard lots of good reasons why professional identity matters. But a character-based approach to professional identity allows us to help develop students in ways that are intrinsically valuable. Now, when I talk about character, what is it that I'm talking about? I have in mind things like resilience. This has come up. I have in mind things like courage, judgment. These are some of the things, empathy, that have already emerged in today's conversations, right? Honesty, various virtues or character traits that are central not only to human flourishing, but also, and this leads to my second point here, to successful legal practice. These things are practically useful as well. Lawyers will be better, law students will become better lawyers if they have developed the capacity of resilience and understand themselves to have that character trait of resilience. As if your identity is an identity where you self-perceive yourself as someone who is courageous, honest, etc., you're going to be more likely to operationalize that as you go out into your careers. The third and fourth bullet points, I'll kind of lump those together, but character and identity conversations are both concerned with connecting the what and the who. Right? Who are you? What's the relationship between who you are and what you do? And related, what's the relationship between your personal values and your professional work? Okay. Now, we're going to be talking about curricular efforts in a moment, so y'all forgive me for talking a little bit about the cultural work that we've done at Wake Forest that I think has set the stage for some of the curricular developments. So in terms of nurturing a culture of character that supports a professional identity formation of law students, I've outlined 4 components here, and I'll just run through each of them somewhat quickly. And the words might be a little bit small to you here, but this is a picture. When you walk through the front doors of Wake Forest School of Law, and some of you were there just a few weeks ago for a somewhat similar symposium, this is what you see when you look to the left, right? Pro humanitate are the words at the top. That's the university's motto, which means for humanity. And then you have various character traits or virtues listed here, like integrity, honesty, diligence, creativity. I took this picture just I guess day before yesterday, because I thought it was a helpful kind of physical embodiment of what Wake Forest at least aspires to, or at least wants to present itself as. But over the last couple of years, we have been intentional, I think, about trying to live into these values more. We've updated our mission statement and vision statement and list of core values to what you see on the screen here to say to the world, right, on our website and so forth, these are the things that we care about. So this is part of the nurturing culture. So I have a joint appointment with the Program for Leadership and Character and the School of Law at Wake Forest. And so much of what I'm talking about today is the result of this deep collaboration between the program and the School of Law. And this is our mission statement in the Program for Leadership and Character. As we have thought about this partnership and built it out, we've tried to be intentional about making sure that it's comprehensive, and comprehensive in a couple of different ways. In terms of temporally comprehensive, trying to frame our recruitment efforts in a way that lead with leadership and character-oriented approaches to professional identity, and have this continue at each stage along the student's development, but also in an institutional sort of way. So this is something students are experiencing and exposed to, as well as staff and faculty, and also even the highest levels of the university and at the law school. So this is all in service of developing this culture to ensure the buy-in. We also have developed a number of student-facing efforts that promote a character-based approach to professional identity formation, some of which I've listed here, a cohort model, which in some respects might be, I'd like to learn more about your fellows model, but it's a very intentional, focused initiative where we work with a relatively small group of 12 students, but then we also have other opportunities that are open to more students as well as more one-off cohort initiatives. As we all know, though, it's essential to have faculty support, buy-in, engagement for any sorts of changes, particularly those that touch on the curriculum in any way whatsoever. So some of the ways in which we have tried to do that over the last few years at Wake Forest is by giving faculty lots of opportunities to participate, to get their buy-in and input. So we've developed surveys for faculty, for example, where we ask them, what do you think are the most important character traits for lawyers to develop? What do you focus on in your classrooms? And then we try to develop workshops as a result of those responses from faculty so that it's clear that we're responsive. We've provided small grants and stipends for faculty to design new modules, or in some cases, entire new courses that focus on leadership and character-oriented content. We've established a partners council, which includes faculty from across the professional schools, with more from the law school than anywhere else, because that's where we're especially based or especially focused. This gives folks another chance to provide input and buy-in. We also are interested in connecting with the world beyond. If you read the kind of long mission statement from the program a moment ago, the last phrase says we aim to catalyze a broader public conversation that places character at the center of leadership. And so we've tried to host symposia, conferences, speaker events, and so forth that draw greater attention. We've also tried to get public scholarship out there through alumni magazines and things of that sort to raise awareness for this and help people connect Wake Forest with this particular approach to legal education. Now, shifting to I haven't seen the sign go up yet, sorry, or maybe I just missed it. I guess I'm making decent time here. I can slow down the pace of my speech a little bit. All right, this is good. The categories for advancing character-based professional identity in the classroom, these have emerged, right? These are some of the ways in which I've been thinking about the points of entry. First year curriculum, the upper level core courses. I teach PR, so I consider that an upper level core course. I'll talk a little bit more about that in a minute. And I love that last panel. I mean, I've loved all these panels, y'all. This has been great. That last panel, took extensive notes on it though. Upper level electives, as well as experiential and clinical courses in legal writing. Here's what I want to spend at least several minutes talking through though, because this has proven especially valuable to our work at Wake Forest, and I think in a fortuitous way builds very naturally upon much of what has already been said today. So a couple of years ago, the founder of our program for leadership and character and some colleagues at the Oxford Character Project, which is based at the University of Oxford, wrote this paper, published paper, How is Virtue Cultivated? 7 Strategies for Postgraduate Character Development in the Journal of Character Education. And these 7 strategies frame so much of what we do at Wake Forest. Habituation through practice, reflection on personal experience, engagement with exemplars, dialogue to expand capacity and awareness, awareness of situational variables and biases, moral reminders, and friendships of mutual accountability. I don't think there's anything in these strategies that probably seems that surprising. These are not necessarily groundbreaking, but the paper is a helpful paper because it brings together and it also provides some empirical evidence for how these strategies actually have worked when used for professional school students, including law school students. So how do we do this in a practical sort of way? I do recognize I'm starting to get a little bit lower on time here now. So I'll pick back up my pace perhaps just a little bit. Because I know we've got a train conductor here somewhere who's probably a little bit anxious about the fact that we're running behind. So maybe I'll even try to wrap up a minute or two early. So what are some of the courses in which this work has emerged? These are just a handful of courses I've listed here. We've, through the course development, redesign and development program, a number of new courses have emerged, like the Leadership and Character in Law, Women, Law, Leadership and Character, Leadership and Diversity, Race, Social Science and Law. These have provided opportunities for faculty to kind of start from scratch and incorporate leadership and character-oriented approaches to their curricula and to elevate professional identity, character-based approaches to professional identity in a thoroughgoing, comprehensive sort of way, which is really exciting. But these are electives that are typically kind of small courses, right? So there are trade-offs between the depth of engagement to some extent and the reach. As someone who teaches leadership and character in the law course, I have to say it is just an absolute blast. And I teach some of your work, some of you faculty in here, you figure into my class. So if I haven't told you that yet, I hope to snag you before the visit is over. But this has also been built into some of the core courses. So just for example, in my professional responsibility course, I have, going back to our strategies here, I intentionally work through each of these strategies, but I'm just going to focus maybe on for just a moment, the exemplars one. Because I think exemplars, going back to something that Neil said a moment ago, I have also focused on young lawyers, not exclusively alums, but young lawyers who are still in their 30s or maybe early 40s, because that seems like a population that students have a little bit easier time identifying with. And I, a couple years ago, brought in Aaron Zielinski, who is a lawyer at the Department of Justice who his claim to fame was he got in trouble because he wouldn't follow the pressure he was getting from then President Trump regarding the Roger Stone prosecution. And we brought him in as an exemplar, someone who was willing to sacrifice his career and make decisions that came at a big personal loss. And then we had students who had done reading and preparation in advance of that, and then they got to actually have the conversation with him, and that was really, really neat. The most famous exemplar that I brought in has been in one of my electives. So I think sometimes the famous ones work. I had Cory Booker come to my leadership and adversity course, but he is so fancy and everything that I think that they're like, wow, I don't know about that. Like, how could I ever be like Cory Booker? But I think a lot of times these lawyers who are 10 years into their careers but are living lives, as Neil said earlier, that are flourishing and who have asked some of these hard questions about who they are, what they do, what's the relationship between the two, that is really where some of the most exciting conversation emerges. Oops, I bumped it. Okay, so one of the things that I want to emphasize in the last minute or so that I have, I'm going the wrong way. Okay. These pieces fit together. So the awareness of situational variables and biases, all of this is premised upon what is the first and most important capacity associated with leadership is self-awareness, right? You have to understand who you are as a person and who you are as a leader. And there's my 1 minute warning, thank you. Sorry, Jerry, I didn't leave the 2 minutes after all. One of the things that I emphasize to my students and that our faculty have done through the new modules that they've integrated is to try to be intentional about identifying what's the purpose of law, what's the purpose of legal practice, right? That's a big question. What are the character traits, virtues, or capacities that are necessary for me to advance that purpose of law or the legal system or the legal practice? What are the occupational hazards, professional pressures that are going to get in the way, right? What are these situational variables and biases and so forth that are going to get in my way? And then how do I adopt maybe some of these strategies to prepare myself to navigate these inevitable challenges? Okay. Thanks so much, y'all. Looking forward to the rest of our time together.
Alrighty, well, so just to get started. So students have reported, common barriers to their academic journeys. They report that demand on their times are depleting. They mistakenly believe there's one way to be a law student or a lawyer. That they're constantly comparing themselves to others. Law students in this room, you don't have to agree, but wink once if you know what I'm talking about. And this goes into part of Kennett's why. But research suggests, however, that students can really shape the way they experience difficult moments by looking at these challenges in positive ways and really adopting a perspective that helps them to thrive. Hi. I'm Andrelli Brutus St. Val, and I am an assistant professor at the University of Pittsburgh School of Law, where I teach legal writing. As always, thank you to the Holleran Center for having me here and to the St. Thomas Law School, Stephen Nowak particularly, thank you. And I'm really happy to be here with you all. So in the fall of last year, and really before that, Professor Sinsheimer, Ann Sinsheimer and Dr. Omid Fertui and we worked with a group of students to create a Thriving in the Law, Tools for Academic, Professional, and Personal Well-Being. It's an intercession course. So the course is designed to give students really the opportunity to discuss just the challenges that they face and to really help them to cultivate tools to help them persevere when they face challenging times. So I don't know if you're familiar with intercession course, some have like a Maymester, but this course is in January before students, before they begin their spring semester, and it's for 5 days, and we meet for 3 hours a day. And in this class, we help students develop their resilience toolbox. So the intercession course grew out of our discussions with students while working on the resilience project. It's a resilience and engagement project. So law school is, not that saying anyone here or the law school here, but it's generally hyper competitive.
right? And, there tends to be really a stigma around asking questions. So thinking about how to improve the culture at Pitt Law and hopefully at other law schools, and really began working with Omid, who is a psychology researcher. So they started studying law student behavior to promote adaptive mindsets. So I also joined the project later on. And as part of the project, we began talking to students. We also use TAs in this project, and we talked to our TAs really deeply about their experience and through their perspective. So, as you know, with law students, once you ask them a question and they're comfortable enough, they will open the floodgates, right? So they really begin to open up about their anxiety, the stress surrounding class participation, cold calls in particular, job hunting, what it means to be a lawyer, choosing a job or practice area, wanting to go into big law, not wanting to go into big law. Like, it just continued. So out of this really came the suggestion from one of our TAs for an intercession course where students would have the space to really address these concerns, but also come equipped with the tools to address them. So the intercession course, the Thriving in the Law course, it focuses on 3 major topic areas, as you can see. So personal, academic, and professional well-being. So the course, we allocate 1 class per topic with a welcome class where we really orient the students to what this class is about. So I'm going to be a little honest. Some take it for what they think will be the easy A. But by the end of it, and we really set those expectations and go, oh, but you're gonna have to work. You're really gonna have to dig deep and really be honest and vulnerable. So we help orient them to what our expectations are, what our goals are, how they're gonna be graded in that initial class. That way we're all on the same page. And then we end with a wrap-up course where we bring all the lessons we've learned together, but also students present a toolbox presentation. Students get to be really creative. Some actually brought in toolboxes, which I loved. And some took a more metaphoric, cerebral approach. But in each class, TAs guided the discussion and they prepared the materials for the day. So one of the main goals is really active student participation from our TAs, but also from the students in the class. So, at the end of each class, students complete a reflection, and then they also complete a survey, and that survey is really for our benefit. It really allows students to reflect on the day, but give us feedback on the course in general, since this was our first time teaching it. So we use science-based strategies to help students understand ways to boost motivation, manage distractions, form more meaningful connections, and improve performance. So this helps with the fuzzy baloney syndrome that Neil identified earlier. I think that's the legal term for it. But using exercises, videos, lectures, and journaling, we really explored best practices for learning how to thrive academically, professionally, and personally. So together we help students develop actionable skills, like things that they can use immediately, the skills, strategies, and routines for their toolbox so that they can positively adapt to challenging circumstances. So in preparing this class, we started the conversations actually last spring with our TAs. Just as we were working on the Resilience Project, they just were telling us more and more about their experience and their problems and anxieties. And so we felt more empowered to do something about it. So we took a wellness and resilience course, instructor training, and this was taught by Dr. James Mazza and Dr. Carla Chugani, who are at Pitt. But this course is available to everyone, anywhere. And the course is primarily grounded in the evidence-based skills derived from dialectical behavior therapy, so DBT. And this has been proven to be effective for improving mental health outcomes in adolescents and adults. So we took a week-long training where we received materials, and then we were able to adapt those materials for law students. This same DBT instructor training is already in use at Pitt undergrad and at the medical school as well. So in the fall, we continued to work with students and really solidify our course plans. We co-created the syllabus.
We guided the TAs in really identifying the goals for each day, the topics to discuss, the questions to ask, the structure and class content. The TAs themselves contacted speakers. And so they contacted recent grads, as others have alluded to, because they were closer to them, they understood them, they also had those connections already in place. And then we also prepared mindfulness exercises. It had videos, and they created the journal prompts. So the key differences, what we believe to be some of the key differences between our class and some of the other courses that we've discussed is that our intercession class is psychologically driven. So we help students understand behavior and mindset from a different perspective. So we worked with Omid, our psychology researcher, and the training from Dr. Mazza and Chugani. And we know that there just are certain points in students' law school journey, where they question their ability in things, and that there are things in their environment that really cause them to question themselves. Some are particular to Pitt, some to law students as a whole, and just some to students generally. So we emphasize, we're not trying to take these things away. Instead, we really focus on helping students really make meaning out of the events that make them maladaptive. So, for example, we talk about cold calls, and really we talk about cold calls, really the fear behind it. And so what we got to was that it's not being called on that's the fear, but it's really what others think, surrounding, looking stupid in front of your friends, or just like, oh, I did not prepare. So, but what we learned, no one remembers your cold call. You play it over in your head, but everyone has moved on. They're worried about their own cold calls, right? So we really explored the psychology behind fear. So this led us talking to about really the most single important psychological skill for well-being and success. I'll share it with you. And so it's the ability to be present. It's knowing that whatever happens will not last forever. So in other words, it's just being okay. Having that brain chatter, that, that voice in your head that's just playing over and talking about stuff, silencing that voice and just being here in the moment, taking it all in, and knowing that good or bad, it's okay. So we talk about psychological theories. We remind students that they are not bigger than the sum of their parts. So another aspect is our class is TA-led, it's student-led. It's the focus on students really actively participating, and that the TAs are also participating in the teaching. So this was our first year that we had this class, and while we're happy with the course, we're constantly thinking about ways to improve it. So this involved continuous feedback from our students throughout the class. At the end of the class, we also did a mid-semester check-in to see how students are using the tools that they've learned. And we were pleasantly surprised to see that they are using them, and some have faced some really great challenges at the beginning of their semester, and having the toolbox really helped them to be resilient and adapt to their situations. So here are some things you can do to incorporate into your classes now. So I think, as Kendall mentioned earlier, some of it might sound overwhelming, but they're just small things you can incorporate. So one of the things I love is using anonymous polls, like Poll Everywhere, Mentimeter, but that Easy Retro, I might be using that. But this is some questions I ask students just throughout the year. What are your challenges in transitioning to law school or transitioning to 2L, 3L year? How's job hunting going? How are classes? It's simple but powerful. And it really allows you to be vulnerable, and you have to really know that there may be answers you may not be prepared to deal with. There may be, and being okay with that. It is bringing in the human aspect. This is just humanizing yourself and the students. Some more questions I've asked. This is my favorite. So during this, at the end, in the middle of their appellate brief writing, I asked them these questions. Thankfully, no one has ever said splendid, because I would be worried. But that last student at the bottom who says help,
it's anonymous. So I just tell that person, if you are that person, see me after class. Come to office hours, email me, but come up to me after class and we can talk. Or just come see me in my office. And inevitably they do. It's always more than one person too, surprisingly, but the one brave souls that clicks help. So, and another really impactful exercise that we did was, and this was led by Omid, so I learned this from him, is asking students to name 5 to 10 people they value, and then to describe those people using just specific words. So then, once they've identified these people, describe them using, really specific actionable words, then they have to take those same words and craft a description of what they stand for and what they value. So this helps students craft their value statements. Because if I tell them craft a value statement, they're gonna go, oh, yeah. But if they have a starting point by thinking about the people they value and the people they admire, it really helps them. So it gets them to think about their value statement. And with that value statement, it helps guide them into thinking what kind of lawyer they want to be, who they want to be, and how do they plan to get there. One more thing you could do is, to start or end a class with a mindfulness exercise. Like Kendall, we could have worked on this together, but Kendall mentioning the meditation. There are mindfulness apps, so you don't have to create it yourself. You don't have to stand in class and go, but there's apps, there's YouTube, Spotify. We had our dean of students come in and she led a 10 minutes of meditation. She is amazing, Allie Linsenmeyer, shout out to her. But in a reflection, one of the students did comment on how he had never done any mindfulness exercises before, and now he incorporates it into his daily routine to help with that chatter that happens in his head. So, as Professor Organ stated, and really others in this presentation today have noted, one of the biggest things is really to just engage with your students on a human level. Let them know you care. Let them know you see them as human beings, and that you, wonderful professor that you are not perfect, and that you too are human. Thank you.
Okay, so I think these are actually going to be short. Andrelli, did I understand from your presentation that it's an elective, that it's not required?
Yes.
Okay, so how many students were
For this,
elected at this January?
yeah, so we had 10 students and they were 1Ls through 3Ls.
Okay, and then Stephen and Leah, practice court's been around for 100 years. I'm guessing it hasn't focused on well-being for 100 years. So how recently has that infusion of some attention to well-being, is that in the last 3 years, 5 years, 10 years?
Honestly, about the last 10 years.
The last 10 years in various levels. So we've had the professional development program for about 10 years, and we've had well-being discussions from that point going forward. And all of those were on concrete skills that students can learn. I mean, we had some that was on mindfulness. We had some on, internal locus of control versus external locus of control. And, you can control yourself, you can't control other people. And that's especially valuable when you're dealing with the other side in practice court. Things like that. Specifically in practice court, I would say it's probably the last 2 years that there have been more specific conversations in afternoon lectures in practice court itself. Although I will say that Jim Wren and Liz Fraley have been very intentional about talking to students about those topics one-on-one when it comes up.
Well, the ABOTA, bringing in the ABOTA group has been a good 10 years. So quite honestly, us creating the professional development program and the leadership development program greatly influenced this. And then one other aspect of that, as associate dean, I heard from the practice court students about the lack of professionalism during the exercises. So it was Jim that said, okay, we'll fix that. We'll add in that component where they're getting judged based upon the professionalism. That changed tremendously. That peer pressure, that being graded, changed that tremendously. So yes, we have some horror stories about the less gentle kind practice court that was our history.
And by the way, the professionalism evaluation is 5% of their final grade.
Yeah.
So this is just interesting. That's an example then of something of the whole building approach, right? You had the professional development. For those who aren't aware, Baylor's is a somewhat distinctive. Most professional development courses are in the first year. Most of them are courses. Some of them are asynchronous. But Baylor's is 3 years and largely asynchronous, I think.
Yes.
But 3 years, it's not just in the first year, it's over the 3 years. But then you've connected that to what you're doing in your leadership stuff, and you've now integrated it into practice court over the last couple of years so that you have multiple touch points, right?
Yes.
And yeah.
Which this document is literally just being finalized.
Can't wait to read it.
First draft. There's still so much more to do because we are trying to do that. Whole building, where's Lou? Thank you so much. We use that language, whole building, making sure from beginning to end, we're doing these touches throughout.
Because it goes back to the first panel and Jamie's wonderful interdisciplinary engagement with the dental school. But I think you guys just got a big grant. I mean, you guys, Wake Forest, got a very large grant that I believe cuts across the disciplines. So are you learning a lot from the other disciplines?
That's right. Yeah. So we are. We've been very fortunate at Wake Forest. We had one grant last year that was focused exclusively on the professional schools, and then we've got another grant that just came through that is focused on trying to get this work out into other institutions. But one of the things that's been really exciting, we're still in the very early stages of it, but with this grant, we have a new director of interdisciplinary and engaged learning in the professional schools. And her job is to spend all day, every day, trying to think about ways to connect different efforts, initiatives across the schools, and to think about this in a way that centralizes leadership and character approaches to professional identity formation, to leader development, to professional development. And so far, I'd say that it's going really well. I will say this, it's challenging to do cross-disciplinary. So I was really impressed by what I heard from Janie earlier. Whenever you're dealing with different schools with different norms and different grading processes and different, sometimes academic calendars, it can get tricky. So you do need somebody who's willing to be persistent. But I'd say that the first few months in, we're feeling pretty good.
I'll just talk loudly in case. So we've been talking both about the importance of well-being in forming your professional identity, and also some of the inherent structures of practicing law that are maybe go against well-being. You know, you get that assignment you get something on a Friday night from a partner that's due Monday morning. That sounds to me, counterproductive to you flourishing in terms of your well-being. As you're educating the next generation of attorneys, and we have the data showing that mental health outcomes in attorneys, something needs to change, the level of drug abuse and alcohol abuse, something needs to change. How do you merge the realities of current practices of law, unfortunately, with this well-being at the forefront of professional identity? How do you deal with the inconsistencies there?
So we talk in the leadership class, we talk about harmony instead of work-life balance. We talk about work-life harmony, in that on a given day or a given week as a lawyer, you may not have balance. It just kind of depends on what your clients need. And that's, if you're trying to make sure that your client who is facing jail time or, their business being, completely bankrupted by a huge judgment, telling, you kind of have to you have to pull out all the stops to help them. But I would say find a practice or a group of partners that you can work with that value balance and harmony over time. And so that You know, it may be a weekend that's killed, but if it's every weekend, then I would start to look for somewhere that might work better for you. But I would say look for balance over time.
And it's sort of like y'all have to balance exams. Yeah. When you're approaching exams, you know that's a different level of commitment than the other times. So you couldn't be in exams all the time, right? So the practice of law, you've got clients, you have responsibilities, you have to take care of them. And so you have to figure out a way to do that, but you do have to protect yourself. But you may not be able to protect yourself on that particular weekend if you're trying to balance all of these things. So I think that's a very, very important message that we need to make sure. And then the other thing is go back to why. What the why? You need to find that practice area that speaks to you, because we can all handle more. We can do more in a healthy way if we believe in it and if it feeds our soul. So many of us have come to this realization that we need to match who we are, what our strengths are, with that practice area, that professional position. So we need to think about that. And so law school's never done a good job of helping students think about that. That's what all this stuff is about. Introduce you to those concepts, encourage you to think about it, give you the tool sets to build on, first the self-awareness and investigation, and then reflection, so that you can take those tools into practice and it becomes a lifelong journey to find fulfillment and satisfaction while you're doing good in the world.
Just to kind of piggyback off that, because it's great. In our Thriving in the Law course, we address that. So we have practitioners who do come in, recent grads who talk about that. And so one of the key things is having students identifying their value system, knowing what they value. Because some students will tell you, I don't mind, I will sacrifice 5 years at big firm knowing I'll work 100 hours a week. And that works for them. But other students who know that is not what they want, and they really examine their value system, and then understanding their options within the law and practice areas, because this field is big. There's so much you can do with the law degree. So letting students know what their options are and seeing how they can align their value system with the practice areas and their options. And then if you do find yourself in those situations, we do give students, and our speakers talk to them, we brainstorm the tools, but knowing how to prioritize, knowing how to communicate. And there, you may have multiple deadlines to how to communicate to your partner that you also have other deadlines. So having those tough conversations, using calendars, and then understanding, and then also telling students how to find ways to satisfy some of their passions outside of the law. Because you're not always, I love teaching, but some days, So I also have passions outside of teaching and outside of the law that also give me great satisfaction. So that way I stay true to me and stay as a whole person. And I don't like outsourcing too much. So letting students and giving them that ownership too. Like there's other things you can do. You are more than just a law student or lawyer.
So I had to comment about the well-being. So this issue is near and dear to my heart. And just as an encouragement to probably to the current students, is that I'm in the role of chairing the ABA COLAP Wellbeing Committee. And as an encouragement to the students, there's a tremendous movement now in the legal profession, not just in law schools, to attend to well-being. Some of you know there's an ABA Wellbeing Pledge, 209 signatories, mostly big law. Now, there's a lot of comment that maybe this is lipstick on a pig, that they're just signing this pledge to, say they're attending to well-being. And I think there is some of that, but I will say there's a lot of energy right now among the big law and people in the profession. I'm a law professor, so I'm not representing the big law by any means, but just kind of almost being on the outside looking in and seeing the energy among law firms, particularly around this issue, and understanding there is a business case to attend to the well-being of your attorneys. And again, I just had a conference couple of days ago, a lot of big law partners on there. So I think that the profession is changing slowly on this issue, but the movement is there. And I encourage you as students to advocate for that in a respectful way, to understand the dynamic and the context in which you'll be operating. But I will say one other thing about this. just as an example of something that's, I think, pretty cool. Now there are even clients out there, big clients, that are demanding of their attorneys that they hire as outside counsel, well-being guidelines within their firm. We saw the diversity guidelines several years ago. Now some big clients are actually demanding that we will hire you, but we're expecting you to attend to certain well-being guidelines. And so, for example, if we send you an email on Saturday evening, we do not want you to respond on Sunday. We want you to wait on Monday. So there are a lot of, I think, systemic things that are changing in the profession to attend to this. And a shout out to St. Thomas. St. Thomas is a signatory to the pledge.
Yeah, all these well-being issues are really expensive to the profession. So the business case is a really important one. These firms have to figure out how to do this because it's costing them a lot of money, the turnover. So without a doubt, that's hopeful. Kenneth, were you going to add something to that list?
I'm sorry?
Are we going to add something to the list?
I think we're about out of time. I see Jerry with the
I'll
mic.
give you one. You did a great job finishing with one.
Yeah.
You earned it.
Okay. So I'll just quickly say, I think this all is so very important. And I think these things sync up, right? So if you go back to the language of 303, it's the values, guiding principles, and well-being practices. I think that the connection between a character-based approach to professional identity formation and well-being is important because both identity and character are concerned with those connections between who you are and what you do. And it helps prevent that disintegration, right, that came up at the beginning of the day, right? If you are someone who is wise, who is humble, who is empathetic, this is something that promotes integration because you can deploy that in personal domains and in professional domains. And if you can exercise this in consistent ways across different domains in your life, I think that advances your well-being in certain respects that sometimes the practice of law can work against.
I chose wisely in giving you that minute.
Thank you.
Okay, 12-minute break. We should have beverages. 4:07. We have one more panel. Keep the energy up.
Hello, everyone. My name is Tristan Cisney. I'm a 2L and associate editor here at St. Thomas, and I have the pleasure of introducing our fifth and final panel. So our final panel this afternoon is going to focus on how professional identity formation applies in specific classroom contexts. We're first going to hear from Professor Daisy Floyd with Mercer University, Professor Benjamin Madison with Regent University, Professor Lou Billones with the University of Cincinnati, and finally our own Professor Jerry Organ from University of St. Thomas. I think everyone knows the drill by now, but I encourage you to take a look at your brochures and read the rest of their accomplishments and biographies. We're going to have 15-minute presentations followed by about 10 minutes of questions.
Well, good afternoon, everyone. We had comments about how it's not a great spot to be before lunch or to be after lunch, but I think at the end of the day, it's hard. We will certainly try to make it worth your while, but it is tough to follow so many wonderful presentations. So again, let me add my thanks to West and to the University of St. Thomas and to the Law Review for hosting this very robust, enriching, really inspiring conversation today. So I'm going to talk about incorporating a professional identity exercise in the civil procedure course. I teach civil procedure. I've done so for decades. I've been working on professional identity for a long time as well, but I do want to begin with this confession to you. I have not used this exercise. I took this as an opportunity to kind of encourage myself to come up with something new. So Jerry had mentioned some of these might be works in progress. I will call this a work in progress and will welcome your feedback. I have done similar exercises in civil procedure and some of the other courses, but I've not done this particular one. So what I want to do is talk about the way that we can use the rest of the story, taken from the title to the Law Review article that we're going to talk about here, to help what is a required first-year course. Usually this subject matter comes up in the first semester for most law students to help fill in some of the gaps, address the hidden curriculum, and help develop professional identity formation. So I'm going to start by talking about the way in which we approach professional identity at Mercer. And I told Ken in the break, he just teed me up perfectly. It was as if he knew that I was going to start with a character approach to professional identity. That's what we use, and he has so wonderfully described it. But the first question I think we like to ask students to think about is a sentence completion exercise. I want to be the kind of lawyer who. When people ask me what professional identity means, one of my short answers to that is, it is about who you are as a lawyer, not just what you know or what you know how to do. And that's, of course, how Ken described character as well. And so we want students to be thinking about who they are going to be as lawyers, but we recognize that this role as lawyer is not the only role in their lives. So sometimes we describe professional identity for our students and others as your sense of self in role as lawyer. But we recognize that you have roles, many, many other roles in your lives. And so we also want students to be thinking about what kind of person they want to be. And we want those to be integrated. We want students to think, how am I going to be a lawyer who can also be the kind of person that I want to be? So this is an exercise where I want to touch on some of those themes of integration and who it is that our students are aspiring to be. So I was thinking about what the goals ought to be for a professional identity exercise, and I think there are at least 4 here. One is to allow our students to imagine themselves in the role of lawyer. They are learning what it's like to be in the role of law student, and that provides some preparation for being in the role of lawyer, but we want them to look ahead and think about who they are as lawyers. We do want to help them acquire and internalize the normative values of the profession. And we have come up with 6 normative values that we think have been developed through the profession. And so we have as a goal helping students recognize those normative values. Those are competency, fidelity to the law, fidelity to the client, public spiritedness. We do include civility. We had some consternation about that. We've tried to deal with it in all of its complexities. And then finally, practical wisdom, which is that value or virtue that helps you bring all of those other things together. But we've also looked at personal values or virtues because we do need this integration. We do expose students to some work in positive psychology. And in fact, the positive psychologists have done some empirical research across cultures and across time, and they've come up with 6 virtues that they say are universally recognized as virtues of someone who is going to live the good life and be able to flourish. And those virtues are wisdom, justice, humanity, courage, temperance, and transcendence. I won't try to explain all of those, except to say that those things we think are important for your identity across all of the roles in your life. We also talk about some of the strengths or traits that need to support those values as well. And of course, a professional identity exercise ought to encourage FDR, reflection, discussion, and feedback. So I have sometimes explained to my students through some visuals what I think an integrated professional identity looks like. It's kind of simplified, but this is somebody, a hypothetical law student, let's call her Sophie, who is trying to integrate her personal and professional values. She's trying to bring her strengths and personality traits and her sense of purpose into who she is. If the PowerPoint allowed it, we'd have 100 words up there rather than just this little bit, because the ETL study has 71 traits that lawyers ought to have. Schultz and Zedek have recognized 26. This is a very crowded space, someone's professional identity. We want it to be integrated with the personal identity. What we don't want is this. And as we've seen, and a lot of people have helped us understand, the risk is that you're going to have one identity in your role as lawyer. You're going to separate that from who you are in all of the other roles in your life. And you're going to do that because you think the professional values require you to do that. So one of our messages is we're after integration, not this kind of dissonance. All right, so worldwide Volkswagen versus Woodson. If you teach civil procedure, you know it. If you've been to law school since 1980, you probably studied it. I don't want to be traumatizing to anybody. It's a personal jurisdiction case. In most schools, it's something that students will encounter pretty early on in their educations. It is a case, simplified, where the Supreme Court held that due process requires that a defendant have purposefully availed itself of the benefits and protections of the forum state, that is the state where they are being sued. This was a personal injury case. It arose out of an auto accident that occurred in Oklahoma and was filed in Oklahoma. So this is not Oklahoma, but it's a nice road view. What happened here is, thanks to PowerPoint, plaintiffs were driving through Oklahoma from New York, where they had previously lived. They were going to Arizona. They had bought the Audi that they were driving in New York. Before leaving, they were relocating. Plaintiff's car was hit by a drunk driver. The accident caused a fire that badly burned 3 of the plaintiffs, the mother, the daughter, and the son. We'll learn a little more about that in a moment. There were allegations of improper design and strict liability in the case. So there's this wonderful law review article written in 1993 that gives us some of the backstory, and the title is The Rest of the Story. And so I recommend bringing these other aspects into your discussion, because usually in the first year course, we're going to read a very, short edited version of Worldwide Volkswagen, and we're going to focus a lot on the law. It's complicated. We're not going to get the rest of the story. I don't recommend necessarily assigning the whole article. It's a little dense. It's got some other things that may be complicated, but you can use excerpts from this article. So the first purpose is what I call getting behind the law school masks. I will say PowerPoint kept trying to give me surgical mask and hand sanitizer when I did this, but I'm referring to something else here. Back in 1975, Judge John Noonan, then on the U.S. Court of Appeals, the late Judge Noonan, wrote a book about the masks of the law. I read this early on in my career, and it was the first place where I had somebody describe the fact that as a new law student, as lawyers, we're required to put on these masks to become lawyers. And part of what we do is we try to repress our own values and feelings. And so this part of the exercise is to help bring in some things that aren't brought in, part of the hidden curriculum. So you can focus on the facts about the accident and the parties in a way that personalizes the parties. So one thing you can do is you can bring this to life. The plaintiffs were driving a 1976 Audi LS 100. The defendant was driving a 1970 Ford Torino. At the collision, the Audi caught on fire, and the allegation was that the fire started because of improper placement of the gas tank and improper shielding, and it was a horrific fire. So again, bringing some of that to life. The law review article has about 4 pages of pretty graphic description of how horrific this accident was and the injuries that occurred. And I'm not going to share with you all 4 of those pages, except to say that part of what was so difficult about this was the father and teenage son were in a separate car. They saw the accident happen. The mother and the other 2 children were in the other car. It caught fire. The other son rushed to try to help. The father couldn't get there because of some physical impairments. 2 people stopped and tried to pull the 3 victims who were in the burning car out of the car. So this is one of the passages from the law review article that describes this person approaching and pulling one of the victims out of the car. And you can see how traumatic this was for everybody involved, right? There's burning flesh, there's help from strangers. pulling them out of the car. So what you can do with this is to design some questions for reflection and discussion. And here are a couple of suggestions. Ask the students, imagine yourselves representing the plaintiffs. What personal values and traits are you going to call upon to help deal with clients with the legal aspects of such a traumatic event? We tell our students, I'm sure students, you have heard this here, for the most part, lawyers are not dealing with people during a really positive time in their lives. Clients come to lawyers because something difficult has happened. It may not be this traumatic, but for them, it's really difficult. So asking these questions, I think, regardless of the answers, helps students have permission to bring all of who they are into this representation. It's not normally discussed when we're talking about the law of personal jurisdiction. What personal values and traits would you call upon to help you deal with the horrific aspects? I had a student have a professional identity seminar I teach. She did a presentation around secondary trauma that lawyers who practice family law feel because of the traumatic events in their clients' lives. And so we need to open up places for students to think about how they can deal with those aspects of practicing law, and then just ask them, what concerns do you have about representing clients who are going through tragic and traumatic events? So I think that's one way we can use resources like this to help with professional identity formation. Then we can ask them to imagine representing the defendants. How are you going to feel? Would you feel a conflict between your personal values and traits and representing a client who is trying to deny recovery to these plaintiffs? How are you going to feel when you take that plaintiff's deposition, right? How are you going to feel when you're putting, your procedural motions in to try to affect the way the case proceeds? And what personal values and traits would you bring to that representation? Not trying to imply that those defendants don't deserve representation and perhaps have cases full of merit, but it can be hard when you're on that side, and that's not how you've seen yourself previously. All right, so here's the second thing that you can do with an exercise like this, and this is to explore tensions between various values. And this particular exercise, I think, can help explore tensions between a couple of values. So this accident occurred in Creek County, Oklahoma, where plaintiffs' lawyers would tell you you could get a great jury verdict, worth twice as much in Creek County as any place else. Plaintiffs named 4 defendants. They named the first 2 to prevent the defendants from being able to remove to federal court and get away from that jury pool. Okay, that was the reason they did it. If Seaway and Worldwide were dismissed, those other defendants could get out of Creek County. So on appeal, all the way to the US Supreme Court, the defendants and the plaintiffs avoided explaining to the court that the real reason they were arguing over these 2 defendants was whether they could stay in state court in Creek County, Oklahoma. Instead, they put their arguments in terms of reasonableness and fairness, which is what the due process clause requires. In reality, I'm going to wrap up. I just got my sign. So in reality, those 2 defendants were represented by the other 2 defendants' lawyers. It would not have been inconvenient at all for those 2 defendants to have to go to Oklahoma to defend themselves. From the plaintiff's perspective, they were arguing to the US Supreme Court that it was going to be inconvenient and unfair if they had to go to New York to sue these 2 defendants. They didn't need to go to New York to sue those defendants. The deep pocket defendants they were going to get in Oklahoma. So what happened here is that neither party revealed those reasons to the US Supreme Court. They weren't asked about them, no allegation of unethical behavior. But some questions you can ask is, how did the lawyers experience these conflicts between the values of fiduciary responsibility to the client and fidelity to the law? Should have they resolved those differently? Why or why not? And finally, if you were representing the parties, would you feel a conflict between that duty of fidelity to your client and your personal values of honesty and integrity? Thanks.
Good afternoon. I think it's still afternoon. I've been fortunate. I'm going to mention along the way some of the folks I want to thank, so I won't do it at the outset, but I'll mention someone who is not here. I was fortunate around 2008 to have Michael Hunter Schwartz ask me to be a casebook author in a series, the Context and Practice series by Carolina Academic Press. And the design of the casebook series was to include all 3 apprenticeships, including professional identity formation. And they were serious about it. Jerry Hess was assigned as my editor. And when I didn't do a professional identity exercise, he let me know it. So there ended up being 44 integrated into my casebook, which was second in the series. It was back in 2010 when I first published it. And integrated throughout the process of a civil suit. And I'm going to talk about teaching from that for over a decade now. And at first, I'm going to tell you about the bad. Then I'm going to tell you about the good. And then I'm going to tell you about the possibly beautiful. Okay, the bad, the first 2 years of my students' experience with the course, they didn't get out of the exercise. It wasn't the exercises. Mike and Jerry made sure they were great. It was the way I handled them, and I'll explain. The good were that within a couple of years, especially after coming to 2 Holler and Center workshops in 2013 and 2012 and 2013, I started understanding reflection. It was a great concept to allow the students to actually have a voice and let me stand back and not try and direct everything. So that was part of the good. And I made another change I'll come to. The possibly beautiful that I'll come to at the end is for the last 8 years or so, when I think I've been teaching professional identity formation from this book more effectively, I not only believe it has helped students develop skills of reflection and the ability to exercise moral judgment consistent with their values so they could continue to like themselves, but I think it has also helped them understand the subject better and the connectedness of civil procedure. Someone earlier today talked about civil procedure is not just a bunch of rules, it's about a system. And there is an interrelatedness. Okay, so I need to start clicking. The rocky start, students unaware of their purpose, lack of students' reflection and struggle. All right, the students unaware of their purpose was a big problem. And I loved the student's question earlier about why should we treat this as anything other than busy work? And I needed to ask that question, and I did. I started after coming to the workshops and talking with many of you. I've learned from the Floyds. I looked for materials like Jerry has mentioned earlier, some of the studies, but I found this article by Reed Elizabeth Loader, and I'll read the full quote. I can't say it better than she does. The lawyer who suppresses moral scrutiny can fall prey to a kind of self-loathing that those with integrity can resist. By ignoring early dissonance, Daisy mentioned that, the dissonance. By ignoring early dissonance, a lawyer suppresses her moral identity. She may overcome alienation by subtly reshaping who she is as a person. Incrementally, these changes are almost imperceptible. This is a human character and moral drift. I mean, that moved me. And I started Larry Krieger's article, which has been mentioned before, some of Neil's and Jerry's work. I had students read it, and I asked them to tell me, what do they mean? What does this mean? And instead of me telling them, and they were telling me things like, sounds like if we do this, maybe we'll be more aware of whether this is affecting us. And I said, wow, they're getting it. And that helped start the buy-in. I'll call it the buy-in. And I developed, of course, a learning objective. Got to have that learning objective. By writing reflections and professional identity exercises assigned in this course and discussed in class, the student will be empowered to practice law and continue to respect oneself and others rather than drift into self-loathing. And then we talked about that. I said, you want to do it as busy work? Do you think you're going to get the promise of this? Or do you want to engage it? Because if you engage it, I think you will get the promise of the ability to practice in a way that you can enjoy yourself. Okay, so that was the first part. Of course, I mentioned and I dealt with the showing students why it mattered, and it helped. Secondly, I started, instead of, the problem was how I had assigned the material in the first couple of years. I assigned it as, like I did the entire, like with Worldwide Volkswagen and all the other, and then we would get to it in class and I'd have a discussion. And it was off the cuff. Now, how effective do you think that was? Not very enlightened. Okay, so after the workshops, I realized, well, maybe I should assign them as reflection papers and have them turn them in and then have a designated date on which we would discuss the dialogue about the professional identity exercise. The comparison between the dialogues or the discussions we had in the off-the-cuff versus the later ones are like night and day. So those were the two major corrections I made and have continued. I have an example of an exercise I do. I had two, but I don't think I have time to do both, so I'll just do the first one. And this is from the case book. The hypothetical I give the student is of they're in practice for about 4 years, limited experience, been in federal court a little bit, state courts more. And they're representing a plaintiff who's been injured by a product manufactured by a non-resident, sold by an in-state supplier. And this is after we have talked about subject matter jurisdiction. So how do you get into federal court? Diversity of citizenship. And if you sue if a non-resident defendant and a Virginia supplier, you can avoid a problem. I mean, you can lock it in to federal court. So, I mean, it was a good example of what a concurrent jurisdiction. So I introduced subject matter jurisdiction, federal question, diversity of citizenship, and then this great concept of concurrent jurisdiction. And students are blown away by the idea that you can file most cases in state court or federal court. And it never failed that students got excited about that. I mean, I was surprised when they got excited. It was second nature to me. But they said, oh, why would you choose federal court over state court? And I said, well, let's have you decide. And so I gave them a practice problem with this plaintiff, and I added some facts. Okay, so what did I add? Well, the plaintiff wanted a fast recovery, wanted money earlier, needed the money earlier. It was the choices between a rocket docket, federal court, U.S. District Court, where I'm from, is a classic example. Cases disposed of between 8 and 10 months of the answer being filed. State courts, 2 years, 3 years. To keep the rocket docket rolling, the federal courts will sanction you on discovery. They don't put up with recalcitrance. Strict on deadlines, no extensions, no continuances. State court, discoveries, a lot of motions to compel, drags out, deadline extensions, continuances. But it's more comfortable to someone who doesn't want to go to federal court into what they perceive as the tougher court. So that was the example. Now, I did play around with the one variable, would jury verdicts be higher in state court? And I said, in cases with injuries such as this, the jury verdicts in federal court were not largely different from those in state court. So that was the problem I gave them. And I didn't give them any prompt. I prompted them to look into the interests in this choice. What were the interests? I did not mention self-interest of the lawyer. I didn't mention the client's interest. And when we got to the dialogues, that came out. They figured it out. And now some people would contend that, well, if I feel more comfortable in state court, I'll do a better job. Then other students would say, well, should you're feeling more comfortable determine where the client's case goes? And so they were making they were just doing the discussion for me, and I was loving it. Now, a couple of times the students would get to this point, and if they didn't, I would add this. What if you brought in a lawyer who was experienced in federal court to be your co-counsel so you could get experience in federal court and split the fee? And that spurred further discussion. But it was just a great exercise on exploring those values and interests below the surface and reaching a decision with which the person, the lawyer, could live. This is the exercise I'm not going to do. The result of the progress, students developed reflection, self-awareness, moral judgment. We have assessments on professional identity formation. That's the great thing. Progress in that. We have assessments we can do. The part of my, the possibly beautiful is implicit in my title, the unexpected synergy, is I see students learning civil procedure more effectively in classes where I use the integrated professional identity formation. And I know I'm gonna get pushback on coverage, and the cases I teach, some of the cases, they're not anywhere close to the professional identity exercises for purposes of teaching. So I'll contend that in some cases, I think it's just resistance to change. And that we can teach them both and teach them better. Now, the thesis I have needs to be tested, and that's where I'm going to say, I'm looking for help. I've gone to our guru, our assessment guru at my school, and I told him, well, the median GPA has gone up. He said, can't use grades, Ben. Not reliable. Really strict guy. No, that's what. Anyway, he says, though, we can design a research study, and that we can design a research study with different groups, and that if you invite schools other than yourself, it will be more reliable. So I'm looking for partners who might want to be interested, who would be interested in doing this. He says we can do it with, I have a model, it's too long for me to discuss here, and that even if you're not interested in joining as a partner, if you have ideas on how to assess that possibly beautiful outcome, which I think would influence schools to be more willing to accept professional identity in doctrinal courses, then I think it will be great for all of us. Thank you very much. And
good afternoon. I have some good news for you. If the useful things that I have to say right now have already been said better throughout the day, if fatigue overcomes you, you won't be missing very much. You can look at it that way. My offer for you today is a model for making professional identity formation thinking central to a mainstream course. And I really mean central. I don't mean a moment here or a moment there, but building the course fully around it. I have a lot of friends in the room to thank. This idea was born here many years ago when we were doing a workshop, and I was returning to teaching after deaning and had already thrown in hard on professional identity formation and had to put my money where my mouth was, I guess. And I wanted to build out a con law course, which is what I teach for first-year students, that made formation central, and do it without losing coverage, and do it to get better performance on thinking like a lawyer and doing things that lawyers do, and get more happiness out of it, and more reward out of it, and better student development. No success story is without an occasional less than fully successful outcome, but I'm sold. It has worked for my students, and therefore it works for me. And it's really not as difficult as you might think. In fact, the model I'm going to offer you comes in two pieces, and I'm afraid that I'm.
Click the slide.
The one on the one on the right.
Try.
Help.
Just click the PowerPoint.
I did, didn't I? Thank you.
There you go.
There we go.
It's just,
I'm a technology
it's technique.
whiz, just
It's the technique. Thank you, Daisy. The model comes in two pieces. There's a strategy, how to think about doing it, and then there are some elements about doing it. And I'm going to lay them out for you quickly. But let me just say the course is a garden variety first-year course. It could be civil procedure, just happens to be con law here. It could be property. In fact, we've heard a lot of good things about that earlier in the day. I happen to think anyone can do it. It doesn't take any particular expertise, any particular insight. What it does take is acceptance that learning and development is what really matters, not what, and it shouldn't be confused with what happens to be the words that came out of my mouth. It's what has been learned by the students. How far have they moved? Coverage is not defined by what I say, but what students, in fact, have acquired. And it takes forethought and some planning. Pretty much that's all it really does. The strategy here is set for you on this slide. It's essentially to try and make professional identity formation natural and integrated in the course, not by virtue of odd momentary placement, part of a hidden curriculum that doesn't count as much as the cognitive and the skill-based work of the course. And therefore, I have to spotlight certain competencies. We've talked about a lot of them today. There's no way I could put all of that in this class. I can't teach tax in this class either. I can't teach procedure in this class. We have to be selective. But choose those competencies that will actually mesh well with the doctrinal and skill work that's going on in the course and enhance that work. Leverage it so that it's in the benefit of everyone involved, me and the students alike. So it starts with framing. And it's about mindset that I think the professor should have too. What I try and do is meet my students where they are, and they are first semester, first year law students, and I'm meeting them at the threshold of their journey. They're on the outside looking in, and I'm here to help them take the steps toward being a more comfortable and acclimated professional. I'm their guide, not just the sage on the stage, but really helping them, accompanying them on their journey. Each student's on that journey of socialization. It's a journey of wonder that they haven't yet really discovered. But one thing that they have in common with the fully developed lawyer is they want to excel. They want to succeed, and they know that that means being excellent. And what we know as developed lawyers is that's something that is a lifetime commitment of learning. We never stop. And that there are certain competencies we're always using to learn for tomorrow. And they might as well be named today for students who are starting their journey, and let the students use them in addition to everything else they brought to help themselves excel in the class and in law school and so on. I frame this right from the start, and we recur to it often to the point where it's just familiar. It's part of why we're there. It's explained and it's elaborated and it's frequently recurred. Now, that's the framework. I'm here to enjoy your journey and help make it better. And we'll stop from time to time and say, how's it going? How are the moot courts? How are the this or the that you did? Try and relate to their journeys and name it for them to help them see better how this is adding up as they move forward. But the competencies I choose to focus on are self-direction. You own this. The more you own it, the sooner you recognize it, the more you'll get out of it. Teamwork and collaboration turns out to be vital here as well, and I'm going to talk about how we use that. Communication, feedback, providing it, receiving it, and also reflection on all of that. Why do these make sense? They're really important, they're accessible, they're going to have immediate value to you and your classes right away, and we can leverage them to success in all the other objectives of the course. It turns into a nice little learning objective, and it's written on the, I won't read it for you again, but you can see it there at the bottom in italics. But I'm trying to create a climate where collaboration and teamwork are part of resourcefulness as well. This is how we strengthen our practices. This is how we get better as professionals. We draw on others all the time. They elevate us, we elevate them. We are the wing, the air under one another's wings. My job at this point is mostly design. Can I design the course to stage student experiences that allow them to be introduced to these competencies and then begin to use them? And then set it up and let it run. And mainly at this point, guide from the side. The rest of my teaching at this point, apart from explaining what's going on, is making sure that I'm handling the cognitive and skill-based dimension of the course. So what we do is we start with teams. It's critical. We've heard a lot about it this morning. 6 to 7 members assigned randomly from day one, and you're going to be together the whole ride. The teams matter. You're going to be doing lots of work in the teams. In fact, almost all of the learning, except for reading the casebook and thinking about it, is going to be done in a teamwork environment that matters. And so it's naturalized. It's just how they live. Each team's going to receive a team grade at the end of the semester. If we're teammates, we all get the same grade. The better you do, the better I do, the better the team's going to do. And so we have an incentive to pull each other up. It's going to be about a quarter of the grade. They worry about it. It turns out to be at most It's like the class participation delta at the end of the day. It doesn't really matter much, but it's enough for them to take the experience seriously. Now, the important thing is what work gets done in these teams. Every day, depending on the size of the class, one or more teams are on call. It's their day to be the rock stars. You're to show up and have total command of the materials, so we'll all learn better in the next 85 minutes. And they love it. How they prepare is up to them. How they communicate is up to them. Whether one or more people will be in the forefront that day, it's up to them. I try and encourage them to, over time, spread the wealth, but they seem to do it really well. Problems turn out to be very important here, but I'll also say before we even get there, quizzes are online along with lectures that I've prepared so that everybody's pretty well competent before we arrive. We make sure that we've nailed that down, and then we move to problems. Now, I have Jerry, my friend, to thank for this. The problems have been deeply improved through the input of Holleran, because what I try to do with these problems is think very carefully about the context in which the student's being placed. It's a con law course that they're not going to be Supreme Court justices soon, as Chris has reminded us. What they may do is be counsel to a school board or to a police department, and I place them in roles. The problems are very realistic to apply that you would find in practice. When we begin to work with the team in class over the problems, they've prepared in advance. They'll talk about how they discussed it. But oftentimes when I place them into roles, they'll be telling me, well, I would say, and I said, no, you wouldn't say, I'm the client, talk to me. And as they talk to me, they begin to talk to me like a professor. And at some point I look glazed. It's not uncommon anyway, I suppose. And I say, I'm sorry, I don't understand a word you've said. I'm not a lawyer. Can you please just explain to me what the law is? And we begin to work through that. It's a lot of fun. Occasionally I have to model some behavior, but we begin to talk in plain English as we will in our lifetimes. So that kind of work is done. Then afterwards, there's a team writing assignment, which is designed to reflect on certain aspects of this exercise so that they can turn into their own words certain concepts that I want to make sure they've learned. But they write, each individual student writes, but then they pour it into a discussion board that's only with the team. They share, and then they produce a team answer, which they share to the class. So they're collaborating to perfect the writing, make it better. They're teaching each other not only content, but writing and expression. Then we move to longer writing assignments, 2 of them. They're basically capstones for one chunk of the course and the second chunk of the course. They're memos that you would be writing in practice. But what happens is I provide prompt, I provide a model, but not exactly giving much away. They draft and they swap drafts with a teammate. They provide extensive feedback to the teammate. I observe all this feedback because it's submitted to me. And then they polish their drafts and submit it to me for a final. I, in turn, grade those for myself, write personalized feedback to the student about not only their paper, but also the quality of the feedback they provide to their teammate. And then when I run all those numbers together, voila, this is how your team did on this project. The students are dying to know how they did individually. And I write a little note saying, not what your grade would have been, but you individually on the memo were at the median of the class or at the bottom third, or I try and put it politely, but to give them some sense of location, because that's what they want to know. But they understand that the team performance is what's mattering here. We do that twice. And then at the end of the semester, a third one, by time, mercy requires that we lay off come late November. But we've covered equal protection, and I need another exercise there. So it's a practice exam drawn from real life. They write answers, exchange it with their teams, and confer. But the process there is prompted by questions. What did you see in strong answers? What did you see that you could have improved on? And then step back and begin to exchange strategies about exam preparation generally. And then also ask certain questions. What are you strong at? What do you need to be working on? How much time do you have to do it? When do you plan to do it? What resources do you have around you to draw upon for this? So it's basically a project management exercise about self-assessment and work ahead and how I'm going to get it done. I could go on and on with this. What I will tell you is the real pleasure for me, among many, is, well, there's so many, but I put more in terms of providing feedback to students. The payback in terms of personal joy is when I read the exams. They're noticeably better than they used to be, just markedly better. What I don't see anymore are those sets of exams that are really struggling, that look like they have not found their way at all. They're gone. I don't see those anymore. Everyone's performing at a more than acceptable level. And it's because of what they've done with one another. I have not changed a word I've said. What I have done is happened to change the stage upon which they work. How does the coverage work? Do you see what the model does? The model structures the time students are using outside of the classroom so that they can use it better to help one another. I'm not losing any syllabus time. I'm not losing a line of my syllabus. But what they're doing is using their time far better. What else do I hear from them? They say, we really liked the teams that we bonded. We discovered that I felt more confident. I discovered that I didn't know everything, but nobody else did either. And that everybody came with something to add. You might ask, what about team difficulties? In 7 years of doing this, I've had maybe 3 visits from team members saying we struggled a little bit. I talk about, have you ever encountered difficulties in family or elsewhere where there's been a breakdown in communication or failure to participate equally? They begin to recognize it's so. And I said, it's not that much difference in real life. Every time that these conversations have occurred, I've not left them with any real instructions, or nor have I intervened at all. And what I get back about a few days later is, we worked it out. It's okay. They like it, believe it or not. They've even gone so far sometimes as to say, could we have a third writing project because we really learned so much from it. It's all about formation, but it's leveraging formation so the rest of the course really pays off. You might consider it. Thanks.
While my slide deck is getting pulled up, could you just give everybody we've heard from already a huge round of applause? Cool, thank you. All right. So this is thinking like a lawyer, quote, with a client, right? So professional identity formation in property. So I want to start with this, right? So when the NCBE started thinking about the next gen bar, they did a pretty broad solicitation of comment on the current bar exam. And I've used a number of NCBE questions, either as practice questions or actual questions. This is the multiple choice questions in my property class. And for the most part, I really don't like them because I think they ask students to think like a judge, not like a lawyer. So I was really struck when Chris mentioned this morning that his class was essentially trying to make an associate Supreme Court justice. But there are very few of them, right? And that's not what lawyers do. So I'm not opposed to the concept of thinking like a lawyer. I just want to contextualize it differently, right? So one problem with the context in which we teach is that the case method focuses on judicial decisions and our analysis of variations on a theme, right? We want to foster analogical reasoning. And so I reflect back on my experience, and it might be a little bit dated, but my recollection of law school was that almost all, and part of this is still true because Martha showed us that's always A and B. She gave them varied names, which was cool. But my recollection was it was always, the notes after a case, always A sues B, who wins, right? Some very cryptic change in facts, A sues B, who wins. So if you're reading that constantly, right, in across all your doctrinal courses in the first year, what's your image of a lawyer, right? A lawyer is someone who sues people. Lawyers are litigators, and they solve problems by suing people. That's what they do, right? Which is not accurate. So my first teaching job, and again, I didn't have a great appreciation for this at the time. I look back on it with great fondness. I started at the University of Missouri in 1991, and that happened to be when the University of Missouri had the only integrated first-year dispute resolution curriculum in the country. There was a professor there named Len Riskin who had managed to persuade all of the first-year faculty that, and we were not describing this as professional formation, right? We were just describing it as dispute resolution. Lawyers aren't just litigators, they're problem solvers. Let's introduce mediation, negotiation, arbitration as concepts. And that's what we did. Everybody had to do one thing that was somehow involved. And, you know, that was pretty natural for me, because when I went into practice, the first thing I had to do was negotiate. And I thought, what did I learn about this in law school? And realized I learned nothing, right? I was suddenly doing all sorts of negotiation and no one ever taught me about it. So I wanted to do this. I was all about, let's help our students be better prepared. What's the other thing you learn? The other thing you learn from A sues B, who wins, with this relatively thin set of facts, is that we, in theory, should be able to figure out the likelihood of success on limited information, right? And again, judges have to do that. Judges only get what the parties present to them, and hopefully the parties are represented by advocates who prepare their case well, so there's at least as much robust information as possible for the court. That's not the world of the client, of the attorney, right? The attorney never has enough information to say who wins, almost, right? A client comes in, tells you a third of the facts that relate to their story, maybe because they're lying, maybe because they just don't understand what's relevant, but you don't have enough. And what you have to do is take your knowledge of the law and figure out, what do I need to learn? That's thinking like a lawyer. What do I need to learn to better serve, better advise my client, right? So I think we collectively, legal education, has done a lot of what Chris Bryant talked about, right? We have taught our students to think like judges, and there's a little bit of value in that, because we have to be able to think like judges to advise our clients on the likelihood of success, right? But that's not the context we should be challenging our students to take, to engage with material, in my view. All right. So I really appreciate, there have been a couple of these complete this thought. Daisy had one, I think there was one earlier. Here's mine. A lawyer is a, right? How could we answer? I think maybe it was Stephen and Leah had this a little bit too, a slightly different variation of this, right? So if you ask our law students this question, here's their answer. The most common answer is a lawyer is an advocate, right? And that's actually pretty, in the survey I did of first years at 280 from 300 law schools, they had this word association as part of the survey at the beginning and at the end, and advocate was the top answer both times. It was coming in and near the end of the first year. So even before they had been shaped much by law school, that was the image they would think, right? But now think about other possible answers. And again, a couple people have shared some with you, and this is not intended to be an exclusive list. It's just to create the idea, right? In a first year course, can we present other images of lawyers so that students are able to think, I'm not just a trial lawyer, I'm not just an advocate, but I'm also this. And as David mentioned earlier, okay, I may be confused. I think it was David, right? This also allows students whose strengths might not be in the traditional analytical framework to feel they have competencies that will be helpful to them in the profession. All right, teacher educator. There have been a couple of examples of this already. Lou just gave us one, right? We have to help our clients understand the law. This is a profoundly important aspect of being a lawyer that we should be emphasizing, right? We advise our clients about the law, how the law intersects with their situation. It's easy to integrate this into a first-year property course. Have them advise somebody about estates in future interest, about co-tenancy, about landlord-tenant, servitudes, bona fide purchaser, any number of these. Here's your client, help explain the law and explain what their options, possibilities are. Prognosticator, right? I don't think we help our students think about this at all, and this is partly where you do have to think like a judge, right? When our students get out, they have to make reasoned guesses about how likely a case is to be successful and how likely the damages are going to be, or whatever estimate of the damages are going to be, right? The calculus lawyers engage in every time a client comes in the door is this worth it? Is it worth it for the client to invest in it? Is it worth it for me to take the case? If it's not worth it for one of us, we shouldn't be representing them. That's a calculus. We don't give our students any exposure to that, right? So we have to encourage them to make predictions on incomplete information and to realize that there's not a right answer. There's going to be a range of answers. People are going to view incomplete information in different ways, right? This is easy to do. I made my students do this in a constructive eviction context, right? They interview me, I'm the client, I give them a handful of facts, and then I make them individually identify a percentage, collectively in their groups identify a percentage, and then we put all the group numbers up and you see this range, right? But you could do it in adverse possession, you could do it in servitudes, you can do it all sorts of ways. That's actually a relatively simple one that has no coverage cost. Negotiator, Howard talked about this, a couple other people have talked about this. This is something everybody does, right? So let's help them do that. We just did an exercise in the business basics class. It's not hard to set up some type of negotiation in a property class around any number of subjects. Colleen has done this as well. Collaborator, right? I've heard a couple, Lindsay, Neil, Lou, all have used Teams. I have students in groups for the entire year. They're sitting together. They have to learn to work together a little bit. So it's pretty easy to do that. We have another course where students have to do an attorney interview in groups. You could have them interview clients in groups, work on scenarios as Lou just described. My current 1Ls are having to draft multiple choice questions in groups. Draft multiple choice questions that can then be a review basis for them. Problem solver. So this is a key one, right? I do think lawyers are problem solvers. But what do I say in parentheses? Lawyers are someone who helps clients solve problems, right? So this is my professional formation evolution. When I was a lawyer, I solved problems, right? I told clients what to do. Clients came to me. I was in the environmental law space. It was complicated. They didn't know what to do. I tried to figure out their situation, and then I told them what to do. I was shockingly young and directive. So some might say arrogant. I'm going to say confident. Kind of in that, what was it? Assertiveness? Who was it earlier? Assertiveness, aggressive. I was on the assertive side of aggressive.
Because you're a man.
Thank you. So teaching for 30 years, and somewhere maybe a decade ago, maybe 15 years ago, as we started to explore some of this and I started to think about what is this identity, I came to realize agency matters, right? And it's really important to help our students understand that the attorney-client relationship should involve client autonomy, clients making decisions. And so it's not that you can't, and you're going to find a whole bunch of attorneys if you start talking to attorneys who are problem solvers and are directive. I just want you to be very thoughtful and deliberate before you just jump into doing that. And so there are ways to do that, mostly just highlight that it kind of matters who's the decision maker. And so that means you have to be thinking about counseling, being counselors, right? Counselors present those options for the client, help the client think about what they might do. And I would just highlight, I appreciate the reference to artificial intelligence earlier. I think a lot of what we're trying to do in the professional formation space is actually what insulates lawyers from artificial intelligence, right? If we are just, I don't remember who said it, if we are just really sharp computers that tell people you can or can't, and that's all we do, we're not adding value, right? You can create programs to do that, and people will, right? The challenge is helping people decide what they should do in their specific context, with their specific goals and interests, with the particular level of uncertainty we have about facts or whatever. That is the daunting human reality where we can add value. So let me end with this, right? None of these is the identity, right? The point is you should be presenting multiple identities so students can figure out which ones they need to be at any given time and which ones are most well situated for them, right? It's not a singular and they're not mutually exclusive. It's really a combination platter. At different times in different contexts, you should be a lot of these things. We just don't emphasize them enough. The first apprenticeship drills home that we're litigators to a large extent. And then this is my ending pitch, and a couple of people talked about this already, right? It's not just the law student identity or the lawyer identity. Our students have other identities that are, man, I'm an optimist, so I don't want to be too pessimistic about this, but I've just read a lot of journal reflections on law school so far. And as best I can tell, time is the scarcity. Right? Law school takes a lot of time. The practice of law takes a lot of time. We had that conversation before with the panel when Leah and Stephen were up here. Time is the scarcity, right? So the challenge I'm encountering right now as I think about professional formation and well-being is that what I'm hearing as I read law student journals, and these are mostly journals of second and third years reflecting back, is that every time they had to make a choice between studying and sleep, studying and exercise, studying and spending time with family, studying won. The other identity got suppressed. The law student identity carried the day. And that's a bad habit, right? Because then the lawyer identity is going to take the day and those other identities are going to be suppressed. And so the word, I did an article when I came here 22 years ago. One of the first articles I wrote was really an apology for why I was coming here. Not an apology in the sense of I'm sorry, but in the sense of a philosophical explanation, right? I wasn't sorry I came here. I made a conscious decision to come here. But it was a weird cultural decision for a lot of people in the academy, right? I'm at University of Missouri. I have tenure. It's a top 70 law school, and I'm going to an unaccredited faith-based law school. That's not the path. You climb, you don't drop. What are you doing? Right? So my explanation for that was a lot about the concept of vocation, being at a faith-based school where I could help students think about whole person education and figuring out who they want to be as a lawyer. Again, before we had the concept of professional formation. But one of the words that was presented there was teleopathy, which is this concept of a single-mindedness of focused purpose that almost always leads to bad decision-making because we're ungrounded from other principles that should cabin us. And I think this is actually one of the cultural dilemmas of legal education right now, is that pervasive inattentiveness to professional formation fosters teleopathy, a single-mindedness of purpose that is unhealthy for law students and lawyers. I hate to end on a downer note, right? So I want this to be a conversation at dinner where you can help find solutions to that. We're not going to take questions because we're already running late and it's been a long day. But thank you all.